Good evening and happy Friday. I am coming in from a microphone that hopefully has not been sounding distorted, off kilter, too loud, too quiet. I'm hoping that we have the audio bugs worked out so that I can basically say, good evening, jurors. I do have to ask you those first three questions. Were you all able to follow my instructions and refrain from discussing the case with anyone since we were here yesterday, last Friday? Everyone nodded their head or said yes or shook their head affirmatively. God, are we ready to have, we're ready to be done with that, right? Ready to be done? We're ready to be done? I'm ready to be done. So it has been a week. I think we've gotten most of the audio quirks worked out. Audio quirks have been worked out. What's the last question? What's the last question she asks? Were you able to follow the instructions and refrain from doing any independent research or investigation of this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about the case since we left here yesterday? Everyone said no or shook their head in the negative. Good afternoon, chat. Good evening, chat. Were you all able to not watch this case? Everyone said no or shook their head immediately. Because we have closing arguments. Alas, the case has come to a close, and we had the opportunity to watch some closing arguments that were prefaced by some debates over discussions on jury instructions and some fiery testimony. It was better than Andrew's impression. Wow. I'll take that. Good evening, jurors. The jurors. There's no, it's like there's no, are there vowels between the consonants? Jurors. Drawers. We're going to figure it out. People are saying, never want to hear you guys say that again. Let's hope we don't have to watch part 3 next year. I don't know. I have an opinion. I have some opinions about how the lawyers did. I will tell you that Hank Brennan is a very different animal than Adam Lally. Very different animal than Adam Lally. But as we get settled in here, everyone pull up a bag of popcorn because we've reached the conclusion of a case. And at the conclusion of the case, we get to watch the lawyers put on the lawyer's dream, which is a closing argument. It's the scariest moment in the courtroom. It's also the coolest moment in the courtroom. It's one where you have more adrenaline coursing through your veins than at any point in time in the court. And holy crap, do you hope that you walk into that swinging for the fences and hoping you hit a home run? And I think the lawyers both did well. People are going to have takes on that opinion. I thought they spoke to who they needed to speak to. The problem is, I think they spoke effectively to who they needed to speak to. But we can get into that a little bit further as we go on. Because we had two closing arguments, were capped at 1 hour and 15 minutes each. You know what that means? We can actually watch most of the closing arguments during a live stream. Oh my gosh, it's phenomenal. We're not going to miss out on too much either. Because Alan Jackson did a really good job. And I was wondering how Hank Brennan was going to do. And I thought he did okay too. So we'll see. I think they spoke to the jurors that were in their camps. And then I know that they went back and deliberated and, surprise, surprise, in the hour and 40 minutes they had before the end of the court day, they were not able to reach a verdict for a trial that's been going on for 32 days at this point in time. Tony B, the fourth question. Host long to eat a ham sandwich. Yes, I had some fun with that on Twitter. It was a lot of fun because ham sandwich entered the chat in quite the most hysterical manner. Did you have a ham sandwich? Did you have a ham sandwich? How long did it take you to eat that ham sandwich? The ham sandwich was 5 minutes. In 5 minutes, were you laughing at jokes? You were laughing at jokes. Were the jokes funny that you laughed at, or were you just doing a courtesy laugh at the jokes? Courtesy laugh? I don't believe that. Juror, do you believe that? Do you believe that this witness had the audacity to have a ham sandwich and then laugh at jokes that he thought were funny? Do you think he actually thought they were funny? I posit you this, they were not funny jokes because the jokes were at my expense. What a day. What a week. We had some surprises this week, and I'm sure I would kind of want to replay at least one of those surprises because I don't know if y'all saw this coming or not. But let's do this. We're gonna play a little bit of a rewind game, shall we? I think we should. Rewind. Doo-doo, doo-doo. I need some what is it, Wayne's World that does that? Doo-doo, doo-doo, doo-doo. Wayne's World. Wayne's World. Party time. Excellent. I just aged myself. So, nope, that was the jury instruction argument. Let's go back another day. Another day. Another day. Another dollar. Another live stream. Another court. Days when we think that things are going to happen that don't happen. And a cross examination that just doesn't hit home, but yet somehow. Here's one thing I did learn. I'm sorry, I'm looking out the other screen that's right over to my right. I need to get my screen set up down here. It worked a little better because when I had 3 screens set up, and I had one screen that was right there. I could look at that screen. It was looking like it was looking towards the camera. But I lost that screen because that screen was a computer that no longer works. Okay. So the screen was there. And now I've got 2 screens, and one screen's here. I have the window tucked up there, but the window's like looking way off there to the side. So it looks like I'm pensively looking off into the middle distance in contemplation of a thought when realistically I'm just looking at a screen that's trying to show the video I want to show to you guys. So I'm not off deep in thought of some, metaphorical concept of what a good argument or a good question is. I'm actually just looking at a screen over here that's there that has Core TV and the live stream pulled up so I can actually find what I need to find. My screen did not self yeet. Let's see. One second, folks. I hate dead air. Let's do this. We're going to pull this up so I don't have to keep doing the dead air thing because I'm just sitting there staring at the screen. I just feel like an idiot. And I don't want to do that. I actually want to share what I'm sharing with you guys. There. So this is at the end of the day, 2 days ago. I'm trying to find it on the slideshow. So Jackson lost his argument. I think actually this argument was appropriately lost because it happens all the time. You might have had a gentleman's agreement that you contemplated your slideshow being admitted or your expert report being admitted because you allowed theirs to be admitted. But that's not really how that works. And you should have anticipated that even though you expected that it would be good for the goose, good for the gander, that doesn't work that way. So the presentation from Dr. Rentschler did not get admitted, which I think was a big loss for the defense. Honestly, that's a big loss for the defense because they very much wanted the jury to go back and be able to watch those videos, watch the slideshow, watch the presentation, and be able to go through that one step at a time. But from a strictly legal standpoint, it was completely appropriate that it not be admitted. It was not substantive evidence. It was demonstrative of the testimony being presented. I think they could have gotten the videos separately admitted. But honestly, I think that this was the correct call. It was the right call by the judge. And the judge was right. It's basically saying, well, that previous slideshow, the other slideshow from the other side got admitted without objection, right? Well, yes, it did, but I expected that mine would as well. You can't make that expectation. You can't have that expectation. The number of times that I've done the same thing, where I've had cases where the other side has offered their bank statements into the record. They want their bank statements admitted. Well, I want them admitted too because I want to cross-examine the hell out of the other person on the bank statements. So I say no objection. They come in, and then I go rather vice versa. If I want to offer their bank statements, they say no objection because they think I'm going to let theirs in. And we play this game all the time. So you have to expect that you have to have an independent base to have these things admitted at every step, even if the agreement falls through. So that's one thing. And I think Jackson was kind of caught off guard with the fact that the argument was going to happen. This is one where the lawyer's scrambling to make the argument, and he is, and Judge Cannoni gives him the ample room to do the argument. So I didn't have a problem with that. And it was properly excluded. But what I didn't expect was what followed the back and forth.
So, Mr. Jackson, when you let us know which slides answer my question about slides that are not in evidence and you want to put in evidence, the videos, just the videos, let me know that. And if need be, I'll hear you all on this tomorrow morning as well. Okay. All right. Is that it for today? Will we see everybody just tomorrow morning? What else do?
I didn't mean to interrupt. No, we should get here first.
After the defendant rests, we will not be calling any witness putting on any further evidence.
Okay.
It was that part. It was that part. Let me do that again, because I heard that record, like the record scratch in my ear when he got up and said this.
After the defendant rests, we will not be calling any witness putting on any further evidence.
Okay. All right.
No rebuttal case. No rebuttal case. Various ways of interpreting that. And I know that I saw a lot of takes on the interwebs as to how we should take that decision to put on no rebuttal case. I saw people saying, oh my gosh, it means Hank thinks he tanked the case. He has no hope. Oh my gosh, he's afraid. Oh my gosh. And then I saw people rationalizing and saying the case is so strong. He just wants to get it to the jury. He doesn't want the jurors to wait another weekend. And I believe the truth is probably somewhere in between those two, probably more leaning towards a rebuttal case will only hurt me. Because, and honestly, quite frankly, I would be pissed off if I'm the defense and he says that he gets up and says no rebuttal case. How many arguments did we have in pretrial motions over what could be brought in rebuttal? How many debates did we have and arguments that were made about ARCA and how Judd Welcher was going to get up and destroy ARCA's testing that was fundamentally flawed, and the logic and reasoning was fundamentally flawed, and that Judd Welcher was going to get up and had to get up and say these things, and he needed more time to come back and rebut the stupidity of these ARCA experts. We heard it left, right, center, in between, up ways, size ways, down ways, all different ways from Hank Brennan for the past several months of how strong the rebuttal case was going to be, how there was going to be 3 to 4 witnesses that were going to come back and rebuttal, including the person who's going to rebut the dog bite. You know what we didn't hear? You know what we did not hear that we heard a lot about in pretrial? The dental impressions of Chloe. So where did those come out at all in this trial after we were promised? Now, the jury wasn't promised these things. We were, which is why I try to draw the distinction between what the jury is promised and what the viewer, the judge, is promised. Because it was presented to the judge that, oh my gosh, the idea that this was a dog bite from Chloe is ridiculous, and we're going to come back and we're going to bring the fact that there was no dog DNA, we're going to bring the dental impressions, we're going to come back and argue all these different things, and then all of a sudden, I know that Bev said no to the dog impressions and the dental impressions, but you don't think that he wouldn't have tried to work it in? You don't think that there wouldn't be some issues? He would skirt the lines and try to present that. Now, I think that there also is a remarkable appellate issue that came out of this. And I know that lawyers are going to have differing opinions on this one. And I think that you can tell about whether Hank Brennan realizes this might be an appellate issue by who focuses on it in their closing arguments. I'm going to wait till we go through Hank Brennan's closing argument, but I don't seem to recall him mentioning anything about dog DNA in his closing statement or his closing argument. And I think that was very intentional, because you guys will recall when Dr. Russell was on the stand and we reached this point of cross-examination and actually resulted in a motion for mistrial, which is the other thing I think is a big issue for Hank Brennan. I think at the very least, he had to have called UCLA to have them present that factual evidence, because one of the things that's interesting about that one is Massachusetts's rule on what experts are allowed to rely on and what they're not allowed to rely on. And for Massachusetts, in order for an expert to testify, they have to rely on something that's independently admissible. And for every other expert that's been out there, all the things they relied on were independently admissible, and a lot of them were admitted. So I don't know that we've got an independent basis for Hank Brennan's question to Dr. Russell. And I don't think where Hank Brennan, because the question came up with this with Dr. Russell. You're aware that there was DNA conducted. Dr. Russell says, yes, I was aware DNA was conducted. But the question is not being asked, and the answer being given by Dr. Russell is not a substantive answer. It actually doesn't go and say that there was DNA evidence presented. It was just her awareness. This goes to her knowledge, her foundation of her opinion. Then Hank Brennan goes on and asks the follow-up question of, and you're aware there was no dog DNA found on the sweatshirt. Well, he didn't get that independently admitted. It was just going to her awareness and her knowledge and her expertise. And I don't know at that point in time whether that constitutes a good faith basis for a question if you're not seeking to independently admit that separately. I mean, that's giving someone all the benefit, none of the doubt. All the benefit, none of the cost. And I don't know that you're allowed to do that. I honestly think that might be a larger appellate issue that we're just glancing over at this point in time. But if I was the Court of Appeals, I'd take a pretty serious look at that. Because very rarely do we have evidentiary issues that I think give rise to a serious question. But when you have an evidentiary issue that sparks a motion for a mistrial, contemporaneously with the evidentiary issue coming up, usually the evidentiary issues that come up are, you shouldn't have allowed the person to testify about A, B, C, D, and E. Okay. Well, at that point in time, generally speaking, you've reached the point where you can cross-examine them on that issue. The testimony, how much impact did the testimony have? Did you move for mistrial right then and there? Did you preserve that objection to the full extent you needed to preserve the appellate issue? And with a lot of the evidentiary problems, you don't preserve that objection all the way through to completion. You lose that on appeal, 9 out of 10. Because the Court of Appeals can hang their hat on a different conclusion. They said it wasn't a turning point in the case. It wasn't significant. It was a harmless error. They go through all these different things. This might be a little bit unique, especially given that it was brought in to undermine the credibility of one of the experts, but it wasn't independently proven. I don't know. I took issue with it. It was a problem that I had with it. I took more of an issue with that than I did with any of the cross-examination regarding Judd Welcher, Rentschler, Wolf. The problem that I had with Russell was that I was reaching outside of what the evidence had, what was before the jury. Don't get me wrong, I had plenty of issues with a lot of the cross-examination that was done, and I think I mentioned it last time when we had discussed some of the cross-examination of Dr. Wolf. And I said that Hank Brennan was doing the same thing that Robert Alessi was doing. Here's the difference that I didn't mention last week. Here's the difference. The two attorneys stand in different postures. Defense attorney is allowed to, encouraged, forced to poke holes into evidence and to present the case or just deflate the case of the Commonwealth. But the prosecution's case is prosecution is separate. They're after justice, not so much simply finding reasonable doubt. So while a defense attorney might be appropriate in putting one expert versus another, cross-examining the expert you have on the stand with the opinion of the expert you're about to call, while that's appropriate, I don't know that that's the same case when you have Hank Brennan cross-examining Dr. Wolf and Dr. Rentschler, Dr. La Posada and Dr. Russell with experts that he has not called yet and has proffered to the court or represented the court that he will call in the future, but has not called them and does not call them. I think that presents a bit of a problem. And I don't like that. I think that's not appropriate. I don't think that you can cross-examine an expert, essentially laying a foundation for testimony to be brought in by your rebuttal expert, without then following up and bringing in that rebuttal testimony. I have a problem with it. I don't know if a court of appeals is going to see it the same way. I'm just saying how I viewed it, and it kind of frustrated me. That said, I saw some very, very, very contrasting views on the effectiveness of Hank Brennan's cross-examination of Dr. Rentschler. And I will say that just like when it came to Dr. Welcher, could they have chosen doctors in this case that had different names or names that were further apart? We had Welcher competing with Rentschler, and we had Wolf competing with Wolf. And then we had Mr. Wolk, and there was too many names that were similar. It was impossible. And one I can't remember, I can't forget, is Shannon Burgess. He tried to buttress his own credibility with his CV that was not quite accurate. But we had a battle of experts to the greatest extent that you would imagine. And as I imagined, given the dichotomy of opinions that are out there, and I do say dichotomy because very rarely do I find someone that's kind of in the middle. If you listen to Dr. Welcher's cross-examination by Robert Alessi, and you were in the Karen Reed is innocent or not proven beyond a reasonable doubt, then you saw Welcher as being evasive, confrontational, obnoxious, condescending, all of those things, right? And you saw Robert Alessi as being effective, probing, asking relevant questions, and making quick points and counterpoints. If you were in the Karen Reed is guilty camp and watching Dr. Welcher's examination, you were looking at every one of Welcher's responses and being like, oh, he owned Alessi, he shot back, he fired back and was dismissive of the question because Welcher is smarter than Alessi and blah, blah, blah. You felt that. And I'm just saying that that's my observation of people that were observing this trial, of those individuals who were talking openly about how they perceived testimony by these witnesses. And a lot of people that were out there that are in the Karen Reed is guilty camp were very much like Dr. Welcher crushed it, killed it. Alessi looked like an idiot, completely ineffective. Now, the other side of that coin, what did Jackson say? The other side of that handshake? I think I like that phrase. I'm going to use that in the future. I kind of like that phrase. The other side of that handshake is for Dr. Rentschler. If you went into this case thinking that ARCA was sus, if you went into this case with the understanding that ARCA were hired guns by the defense, and that of course they were going to come to the conclusion they did because they were hired by the defense and they only had one side of the argument, and my gosh, and everything that came out of Dr. Rentschler's mouth sounded to you just like it sounded to everyone else of Dr. Welcher. Dr. Rentschler's a hired gun. He's completely dismissive. He's condescending. He's not answering the question. He's being evasive. My God, this guy is sketchy. He's completely ridiculous. And then you're looking at every question by Hank Brennan. You're like, Hank Brennan's calling out corruption. He's calling about the signal chat and who deletes text messages. Side note, everyone deletes text messages. I just deleted like 5 lines of text messages this today. Which I hate those arguments now, by the way. I really do. To imply that something is nefarious. Yo, do you know how many freaking notifications are on this damn phone? How many unread texts? How many unread texts? I have 44 unread text messages. 44. I only have 49 unread emails. At the beginning of the week, I had 284 unread emails. Now I only have 49 unread emails. And I've got 39 unread emails in my personal email account, 46 in the Law and Lumber email account. I've got 12 unread Signal messages and like 100 unread Twitter messages. I don't fault anyone for going through and clearing shit out. No way. No way. But if there was a juror in that deliberation, you should read them. You should read them. People saying you should read them. Uh-huh. No idea how many of these things I do read. Every week I strive to make that number 0, and I cannot tell you, I probably go through hundreds of emails, text messages, messages on Friday at the end of the day to try and clear them out. It is wild. There you go. Oh my God, Signal messages. What are you hiding? All the things. All the things. 22,000. Oh, I'm not talking about anything in my junk or anything else. I'm talking about actual substantive emails that are not junk mail, not anything else. These are substantive emails that require a response. And I get back to those responses as much as I can. So if you were in the camp of, I think this is sketchy, then when I think Brennan was asking those questions, you were feeling empowered. You were feeling strengthened. You were feeling vindicated and justified. You get them, Hank Brennan. You go after ARCA and their sketchy behaviors. But if you didn't feel that way, then you were very much like, what are you doing? Why is this an issue? Same thing goes with the ultimate issue question, right? So Dr. Welcher gets up and says, this is consistent with a human being the size of John O'Keefe, and the science tells me being hit by Karen Reed's Lexus. And he goes further and just says, all of the evidence, all the DNA and all the above is consistent with Karen Reed being hit, or Karen Reed hitting John O'Keefe with her Lexus. And everyone on the Karen Reed is innocent or the hasn't been proven beyond a reasonable doubt is furious that this opinion is being offered. Well, then Dr. Rentschler gets up and Dr. Rentschler says, doesn't matter if one hit by a car. I can ignore the debris field because it wasn't hit by a car. I can ignore the speed because it wasn't hit by a car. And everyone on this side of the aisle is going, yay, and everyone on the other side of the aisle is going, what the hell is he talking about? And I lay this foundation because when we get to these closing arguments, I want people to take a step back. Take yourself away from the pretrial motions. Take yourself away from the arguments that we've seen. Put yourself in the seat of those jurors who have just been there, the jurors who have just been there for 32 days. That's all they've seen, 32 days of evidence. Put yourself in their butts, in their seats, listen to this argument. And then think logically. If I were to view this case brand new, and the first things that I was hearing was the statements of the defendant, because again, I'm going to go back and say that those interviews, I mean, between ARCA's increased scope, what they were allowed to get into in their examination, because my gosh, the testing was phenomenal. We didn't have that in the first trial. Oh, the x-rays was damn good too. We didn't have that in the first trial. Right. So ARCA was let off the leash. They were allowed to do the testing they wanted to do to go beyond the scope because they had a new client. They had a new client that was saying, go ahead, go further. Show how it would look. That was a big game changer to this trial. Oddly enough, people viewed that testing as through the lens they wanted to view it anyways too. You know the number of people that were online looking at that video that was played by the defense of Rescue Randy getting hit by the vehicle with the glancing blow, who were saying, oh my gosh, the defenses are idiots because they just played the video that shows exactly how John O'Keefe was hit. A similar number of people were on the other side saying, yes, it shows how a body was hit, but how does it show the body went 10 to 15 feet to the side and ended up face down on top of his phone next to a glass that he was supposed to be holding? How did it get there? People will ignore a lot of problems when certain things highlight in their mind support for their own argument. We call it confirmation bias. It exists in both directions. So today was the day when people tried to persuade people to either latch onto that confirmation bias or dismiss it, or for those that were in the middle to pick one side or the other based on the greater interest of justice. It was pretty good. And I still think the case is pretty damn close. From the practical standpoints of jurors that are watching this for 32 days and having opinions on what they're seeing presented only to them, in the light only presented to them, and knowing how jurors perceive statements when it comes to statements by a party defendant, how they view those statements, and how jurors weigh expert testimony versus first party interaction and first party testimony. I mean, it's pretty wild to me. Oh, he was found face up. You guys, you know, I was pontificating. So that was what we had going into today. And it was very curious to me who these two lawyers were speaking to when they were giving their closing statements, closing arguments. Because they weren't speaking to the middle. That's my opinion. They weren't trying to persuade the people that were on the fence. I mean, they were. But realistically, they were looking for their holdouts. Both of them were. And they were looking for those little things that they wanted the jurors to dig their heels into and fight for in that deliberation room. So I was curious to see it. Very curious to see it. So let's get caught up in some super chats, and then we will get to the streaming. And yes, I know that Ian is streaming the same time we talked about it before. Let's see how far he is into his stream. Oh, he is still in Alan Jackson. Ian's going to be a while, guys. We're going to get coming at some point. Let's swoop, talk about some of these super chats, and then we'll roll into the stream. Okay. Pop Prince says, hi, everyone, here for the snark. We're going to go into some of it. Baby Gator is currently pursuing a ham sandwich. The screen name changes. Thank you for gifting memberships. Much appreciated. Bama Girl 1955, an EMT told me that this AM to call my family, thankfully. Call your family. Everyone call their family. Mama Betts, happy Father's Day, Rob. Thank you. Well, bonus dad. I still like that role very, very much. Charlie Lynn denied transparency in the process of choosing the alternate jurors. Refused to show all the balls that were accounted for, then each number displayed in open court or in front of counsel. Thought that was kind of odd about the denial. I don't view too much into it other than just this judge is going to rule her courtroom how she wants to rule her courtroom. And if you want her to change the procedure she's used, she's not going to do it. The Court of Appeal is going to make a change, but she won't do it independently. Josh H. Welcher equals spread the load. That is all I remember. All I remember from DeSogra is doesn't matter, didn't get hit by a car. Rentschler, doesn't matter, didn't get hit by a car. That's what I remember from those two. Michelle Dover Spike, thanks for being a member for 20 months. Odin's Martyr, do you think as a younger jury, they'll have more understanding of STEM? I don't know. I know they're going to have more understanding of tech, and I don't think they're going to view Signal as being as nefarious as people think. Unless, I mean, again, I don't know. Signal was in the news remarkably recently when it came to the conduct in a political capacity. I don't talk about politics. We're not going there. But it was flashed all over the mainstream media as being something nefarious or something secretive or something improper. I've used Signal for 3-4 years. Told you why. It's got a desktop function. I can type from it. It's encrypted. It automatically deletes certain messages because I don't want things lingering around. I don't view that as nefarious. I view that as smart. So I don't know. Younger jurors might think that that's completely appropriate. I mean, this is a jury made up of Snapchatters. And then the corollary is, are they going to be thinking about, would I ever communicate with an expert witness via Snapchat? Probably not. No. I was about to make the statement of, would an attorney ever communicate with a client via Snapchat? And I can't imagine a world where that would be appropriate. Different reasons. Are there attorneys out there that do? Probably. It's kind of weird. Snapchat's encrypted and self-deleting. So is WhatsApp. Isn't WhatsApp the most broadly used device-to-device communication application, or is it WeChat? Which one? I think WhatsApp is one of the most broadly used multinationally. But I use WhatsApp to communicate with people that are international all the time. And WhatsApp has a feature that makes it self-deleting too. Does that mean it's bad or terrible or nefarious? No, I don't think so. I don't have a problem with that. Baby Gator is currently pursuing a ham sandwich. Rob, the experts are wolf hungry like the Crash Daddy 1, Crash Daddy 2, and Blue Man Group. Not hard to tell them apart. They were pretty big differences between how they acted, how they behaved, and who they were on the stand. You're correct. Zesalex wanted to update you. The CRPS walk went really well. That's wonderful to hear. Also, thanks for the recap. I had minor surgery and missed today. You're very welcome. Glad to present it. Glad to be here. Finally freed. I work in behavioral traffic safety. Leaning against a car at some point would not even ever carry more weight than someone carefully applying the principles of physics. Work in behavioral traffic safety. Leaning against a car and some paint would never ever carry more weight than someone carrying carefully applying. Yeah, I am generally inclined that I've told you various times throughout the live streams, for those of you who are here for the first time. I don't know how many. My brain, and when I talk about my biases, I talk about biases all the time. I am always going to be biased toward the defense. I'm always going to start there. That's where my brain exists. That's where my head lives. That is where my first gut feeling is, because I want to apply that proof beyond a reasonable doubt to the highest degree that I believe possible. I apply it to a level that I don't think common juries do, but I aspire to be even more harsh in what we require of our prosecutors, of the prosecuting entities of the state, in order to deprive someone of life, liberty, or property. So I will always be a little bit more defense leaning just from my gut. Then I try to analyze my own bias, take a look at that understanding, and realize that naturally I'm going to be leaning more towards the defense. And I try to counter that proactively. I try to take that away. I try to basically say, okay, if I wasn't doing this, acknowledging that I generally am inclined to, how would I view this evidence? And I try to analyze it that way. But I also can't divorce myself from my own background. I come from a family of engineers. I am a builder. I am a maker. Sciences and STEM is very, very, very much deeply rooted into my background, into my understanding. I understand things in terms of physics, how physical application of force might work in a certain environment. I was the kid that never understood the maths unless you actually took the math outside or took it into a workshop and showed me how it worked. I needed to see it. I needed to do it. I needed to build it. So generally, applied sciences are going to work a heck of a lot better to persuade me more so than words. And I've been very clear about that. And I think that is a bias as well. I have a bias that leans more towards math, physics, and the physical application of force and understanding of biomechanics than witness testimony. But I also recognize that bias, and I recognize that there are people on the flip side of that script. People who give more weight and credibility to observations by individuals, firsthand observations, repeated testimony, things that people are saying. It wouldn't have happened if they wouldn't have said it if it didn't happen. There are people that put more weight in that camp of evidence or information than the other. So I also have to, when I view all of this, I have to kind of look at my own internal biases towards physics and the practical applied sciences, and also understand that there are people that don't view it that way, and kind of look at the evidence and say, okay, how would I view this if I gave less credibility to the applied sciences and more credibility to the, even though this is less than likely, to the, this is what this person observed. So that's how I approach all of this. And that's why I try to do these breakdowns the way I do. Like I said, my brain is always going to be rooted in that engineer. I'm going to take after my parents, my grandparents, my siblings. It's just, I'm going to want to see how the biomechanics work. You're saying that's how it happened? Cool. Show me. If you're saying it's how it happened, you should be able to replicate it. If you're saying you don't know, then at least tell me you don't know. And then try to prove to me with evidence how it did happen, despite the fact that you don't know exactly how it happened. Prove that it could. Prove that it's consistent with. And don't rely on witness testimony to do that. Because I've told you guys as well, for me and for my sake, how I view evidence, I don't care if someone walks into court and says, I admit that I shot this person in the chest. If I don't see a bullet wound in that person's chest, and if I don't see the gun that did the shooting, I'm going to give that credibility, the credibility of that statement, not a whole lot of weight, because I've seen people who have said any number of things that are completely not true. Why they said them that were not true, I don't know. I'm never going to know. Human behaviors, human discussion, human understanding, human perception is very, very, very different and more complex to understand than what I love, which is the maths and the physics. But I recognize that there's probably jurors that view the exact opposite. I don't have to look at the math and physics if I just heard that she did it. That's why I go into that with that foreground. Book Dragon KSC watching with Mama Dragon. It's her first FNF. Well, hello, Mama Dragon. Glad to see you here. Welcome. Welcome, welcome. Jade, would you be surprised to know Brennan used Signal? No, I wouldn't be. Because a lawyer has to advance an argument that they might not necessarily fully believe, but they believe is in the best interest of their client. The number of times in family law cases where I've had to get up and kick and scream and yell about how a child missed their curfew or the bedtime routine was thrown off on this day because this trip ran long. And in my heart, I'm kind of looking at that argument going, it was a trip. Yeah, it ran long. Of course it ran long. Happens all the time. That's why it's kind of difficult to be a lawyer, because sometimes you have to advance an argument that you might not in your heart believe. Makes it less effective. I don't like doing that. I try not to. Moon Dragon, happy FNF. My birthday is this Sunday, the 15th. Happy Sunday birthday, the 15th. Hope you have a wonderful birthday and a great year up ahead of you. Okay, so now that we have made it through all of that, scrolling back to the chat, seeing what everyone's saying, all kinds of stuff. I don't see a whole lot of angry people, which usually makes me happy. Where? This Tofu Brains, great observation. I'm an engineer, and although Arca did much better job than Aperture, neither one really proved this case one way or the other. I don't disagree with you. I imagine there was also a heck of a lot more testing they could have done if resources and time were endless. I imagine we could have designed better tests. Who knows? We shall see. And the thing is, every single person that's analyzing statements made by the defendant, you have to realize that the rationalization that you might have, the conclusion that you might have reached, might be completely different than the person sitting across the table from you at the jury deliberation room. And you might be very deeply rooted in your opinion, and it might be very deeply rooted in theirs. Which is why defendant statements are so hard to get around, because they're a sticking point for so many people. Almost like hard math and science. Okay. So let us get to today, and let's listen to Judge Cannoni give her admonishment, get into the closing arguments. Shall we? I think we shall. Because it's important. Because it matters, right? Bijou girl, there's a lot of things I can't get past. And when we get through this, I'm gonna keep a little notepad here. I should do that now. I was gonna keep a little notepad of aspects of the evidence that each one of these lawyers hit. That's what I'm gonna do. I'm gonna keep a little notepad and I'm gonna type. So if I look a little distracted, I'm gonna type a couple of things. So I'm gonna keep a notepad of things that pieces of evidence that lawyers highlight. And then we're gonna talk about things that they avoided or they might have wanted to highlight. Okay, we're going to do that. All right, let's go ahead and do we do the bring this jury? I don't know. Do we do the bring the jury? Do we do the Becky Hill? No, we don't do the Becky Hill. Let's go to we're going to bring this jury.
Bring this jury. We have questions.
God, it's so cheesy. It's so cheesy. I don't care though. It's my life. I deal with serious topics every single day. I get to have a little fun in my evenings. Thank you very much, which includes robot juries of plushies. All right, let's start with AJ's close. AJ's closing argument. Let's talk about, we're going to go through that. Ready? Here we go. Let's rock and roll.
My instructions and refrain from discussing this case with anyone since we were here yesterday. Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research?
No EDB was a soundbite. Yes. Back when I was doing the Take Care of Maya trial coverage, the Maya Kowalski trial, I was doing a lot of recaps on that, kind of being the person in the forefront of the recaps, and came on for the verdict. Emily jumped on, and I was telling her about the jury and how the jury asked a bunch of questions. They would call themselves this jury. So that's where that's from.
Research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left here yesterday? So as you know, it's time for closing arguments. And when I was a trial lawyer, I never liked it when just before closing arguments, just before I stood up, the judge would say, jurors, remember, closing arguments are not evidence. But it's true. Closing arguments are not evidence. The lawyers aren't witnesses. And because they're not evidence, I need you to put away your notebooks because you can't take notes on them. But the reason it used to bother me is because I sensed that it made it sound like they're less important than anything else in the trial, and they're not. They're certainly a very important part of the case. And we've all noticed that you've paid very close attention to this case, and we know that you'll do the same to the closing argument. A couple of things I want to say, and you'll hear more about this in greater detail when I give you the charge. First is you folks are the fact finders. So it's what you find from the testimony, your memory of the testimony. This has been a long trial, but your memory of the testimony, not the lawyers and not mine. So if the lawyers or I say anything that doesn't square with your memory, it's your memory that serves. Secondly, there are very important constitutional rights that I hope that you understand, or constitutional concepts that you need to understand. First, again, the burden of proof in this case is proof beyond a reasonable doubt and to a moral certainty. And the Commonwealth bears the burden.
Who had their phone turned up to full volume during closing arguments? I know there's a lot of amateurs in the courtroom because, you know, it's closing argument day, but come on.
Burden of proof, right? The burden of proof is on the Commonwealth to prove beyond a reasonable doubt and to a moral certainty. And because of that, in Massachusetts, because the Commonwealth has the burden of proof, the Commonwealth goes last in closing arguments. I've given each lawyer an hour and 15 minutes, and I'm not going to stop them. So we'll start with the defendant's closing arguments. Mr. Jackson?
Okay, before we go to Mr. Jackson, I have to rant for a second, just 1 second, and how I vehemently and fundamentally disagree with this format of closing argument. I understand that this is how they do it in Massachusetts, but I have a very, very strong opinion about why I don't agree with this format. Holy crap. Okay, so the Commonwealth has the burden of proof. They have the burden of persuasion, the burden of proof. They have every burden in a defense case or in a case of a prosecution, right? So they, how do I phrase this? By placing the defendant first, by telling the defense that they are to give their closing argument, their closing presentation first in order, it sends an implicit suggestion to the jurors who, even though they just heard with their own ears from the judge's mouth that the Commonwealth has the burden of proof, the defense has no burden, even though they just heard from that judge, it places an implicit burden on the defense. You have an expectation when they get up to stand and they're speaking first, that you're looking at them and saying, you don't have to prove shit, but you're going to prove something to me, right? Because you're the one that's the talking first. You're going to tell me why I should vote not guilty. It places the defense in a defensive posture before there's any prosecution of the case, which I don't like. I really don't like it. I know that there are pluses and minuses to this format. In the standard format, or the format that's observed, at least here in Virginia, is you begin with the prosecution goes first, the defense goes second, and the prosecution, because they have the ultimate burden, and it's always phrased that way, by the way. It's never phrased that because the prosecution has the burden. It's always that the prosecution has the ultimate burden. They get the rebuttal close. They get to leave you with the last words. They get the last bite at the apple. And I've always viewed that as being the more appropriate way of doing it, because right off the gate, when you charge the jury and you say the defense has no obligation, you're going to hear from closing arguments. Arguments are not evidence. The jury is looking at the prosecutor with the right anticipation. The jury is staring at the prosecutor and saying, hey, you, Mr. Prosecutor, who are asking me to convict, please tell me why you want to convict. That's the appropriate level of burden allocation. Prosecutor's going to give you their interpretation of the evidence, and they're going to ask you to and they're going to argue the reasonable inferences, and they're going to say, please convict for this reason. Then the defense gets up, and the defense says, this is why you shouldn't convict, right? You place the burden where it exists from the beginning, prosecution, and then you leave that burden where it exists in the end, prosecution, with the defense sandwiched right in the middle, having no burden at all. Now, the negative to this is the prosecution gets the last word, which for practitioners or lawyers, well, no, it's the same way in this one. Prosecutor gets the last word here, and it places a little bit of, I don't know, it gives the prosecution the ability to kind of both rebut the defense case and then present their argument with the ease of already understanding and knowing what the defense is going to argue. You cannot tell me that's not an advantage, right? You structure your argument, you structure your hour and 15 argument. And if I was the prosecution and I knew I could go second, I'm structuring my closing argument. I'm giving an hour of time that's dedicated to the closing that I have prepared. And then I'm wiggling in 15 minutes for what I hear said by the defense that I can pivot to and seamlessly integrate wherever I want to. If the defense doesn't highlight a point that I think they did, that I think they would, then I cut that out of my closing argument and I highlight a point that they missed. I don't like this advantage. I don't like it. I think it is an advantage. I think it's an unfair advantage. And I don't like that from the jump, even though the judge just said it out loud, the defense has no burden. The perception of the people sitting in that jury box looking up to the first individual speaking is, you're the first one talking. Prove something to me. That is a natural perception. That is how human nature works. You're the first one trying to persuade me of something. Persuade me of something. That is immediately placing the burden on the defense. I don't like that. I don't like that. Because if you have the prosecution getting up first and giving their closing argument, right? The prosecution who has the first and the ultimate burden. Prosecution says, this is why you should prove beyond a reasonable doubt. Then that puts the defense in the appropriate posture of getting up and saying, all I have to do is either A, say nothing, B, say that guy said his bullshit, or C, start poking holes in his stuff. And that's with that is before I have to prove anything. And I don't have to prove anything. It's before I choose to start telling you evidence that I think goes to disprove these events. I don't like this system. I think Massachusetts has it flawed. I think it's up to the individuals, the residents, the voters in Massachusetts to change it if they feel so inclined. But I can tell you that if I'm a criminal defendant in Massachusetts, I am not happy if I get to hear that the process that my attorney, the defense counsel, has to get up first and anticipate the closing argument by the prosecution, not respond to it, anticipate it, give their closing argument with the perception the jury has of my guy has something to prove affirmatively. And then the prosecution gets to get up in a defensive posture and then try to drive the nail into the coffin. So yeah, I'm sorry for the rant, but I had a really big issue with this. I had a really big problem. I had a big problem with this in the first trial. And I had forgotten about that until this came up. And I was going, wait, this is how we do it here? And thinking in my head again, going through all of this again, going, holy crap, how much of a disadvantage is that to the defense? Even if they know ahead of time that that's how that works. It's horrible. That's a terrible way of doing it. But that's what we have. And with when we're lawyers, we really just have to operate within the confines of what we have available to us. We don't get to change the rules on the fly. We kind of have to deal with it. You guys want me to the side, or do I go down here? I don't know. Do we like one way or the other? I don't know. Side, down there. I don't know. Let's do the side. I like the side better. Makes more sense. Is that a British law holdover? It might be. It might be. Side works. Okay, side it is.
There was no collision. There was no collision. There was no collision. I want to take a minute to start off with thanking you. I want to thank
Right off the bat, bonus points. Bonus points right off the bat. It's always good news when you can repeat one of the lines you use in your opening statement and your closing argument. I've argued to you guys before, and I've told you before, that every attorney begins every case thinking about their closing argument. And you work backwards from there. You start with your closing argument, and then you say, what do I have to put into the record in order to make that argument? And in this case, there was no collision. Now, Alan Jackson, in an opening statement, a little bit confounded this way. He said, the defense is going to say, he said three things. There was no collision. There was no collision. There was. It's like, don't do the three things thing. Just say the three things. Just say it out loud. This was good. This was good. And beginning with that catchphrase, that line, is remarkably effective because it's your hook right there. You want to captivate the audience. You want immediately to get their attention, and you don't want to just say, thank you for being here, right? That's the cliche. The lawyer gets up and says, thank you all for all your service and what you did. Very much. We appreciate it. We give you want to catch them first. You want to give them something. So I like that.
Thank you for your attention. I want to thank you for your patience. I want to thank you for your diligence. This is not an easy undertaking. Most of all, I want to thank you for your courage, because courage is what this moment demands. Not just to listen, but to stare directly at injustice and say, not here, not now, not on our watch. That's what you're being asked to do. Stare down injustice. I want to start with a simple truth. You folks, not us, nobody else in the courtroom, you folks are the last line of defense. The last line of defense between an innocent woman and a system that has tried to break her, that falsely accused her, that tried mightily to bury the truth. This case was corrupted from the start. It was corrupted by biases and conflicts and personal loyalties that you heard about. And most fatally, it was corrupted by a lead investigator whose misconduct infected every single part of this case from the top to the bottom. In our opening comments to you a few weeks ago, we told you what to watch for. We warned you what to watch for. We begged you what to watch for. Watch for the physical evidence. Pay attention to the medical facts. Pay attention to the science and the physics. But also pay attention to the integrity, the very essence, the integrity of the investigation. But you also saw something during the course of the trial that none of us might have expected, something that should sadden us, something that maybe would anger us. On full display, you saw the lengths to which some police officers will go to protect their own at the expense of the rest of us, at the expense of Karen Reed, an innocent woman. Before we examine the evidence in the case, which we
That's a risky play. That is a very risky play. First of all, if I knew that there was anyone who had a family relationship with anyone in law enforcement in any capacity on the jury, I don't know that I would make that argument. Even with the overemphasis on the lengths that some will go to. Because you can alienate a juror pretty easily there. So that's a swing. That's his first risky take. Because that suggests or requires at least some of the jurors, and you're trying to talk to all of them, believing the shady cop thing. Some are probably inclined to believe it. I can guarantee you that if someone is not of that mindset, it can alienate them. So you guys are right. Yes. You guys, yes. Ian and I coordinate beforehand. We actually talked beforehand. Ian and I both knew that Ian was going live at 7:30 and then I was going live at 9, and that Ian would jump over whenever he was done, and that we were just going to go because I can't go until like 4 a.m. I'm saying that out loud. I've done it before. But trying to make sure that we're both doing all this. Ian has followed this case from the very jump, and I'm just doing every Friday. So if you want to be on one side or the other, doesn't matter. But I support you guys watching his stream just as much as you guys watching this one. We're best buds, so I have no problem with that. But yes, so that started with a bang, and it was a risky swing right there, and that tells you kind of how that's a risk. That was a risky take.
We will
Good.
do. We need to understand the very foundation.
This is great. Do you coordinate over Signal though? Do you want to know the answer? Do you want to know the real answer? Yes. Because he's in Canada and I'm in the States. We needed encrypted applications to message back and forth with one another. Yeah, we coordinate via Signal. We do. Very much so.
Of the entire system of justice in which we operate. It's the bedrock on which this entire system is built. Reasonable doubt. This isn't just a technicality, and it's not a slogan. It's a constitutional shield that protects the innocent and prevents the government from punishing without proof. The Commonwealth has the high burden to prove every single element of every single charge beyond a reasonable doubt and to a moral certainty. As I said, those powerful words are not just some legal jargon. They're your mandate, they're your obligation, they're your community's protection against injustice. In our system of justice, Karen Reed sits here today, presumed innocent, cloaked in the presumption of innocence. That presumption is not fragile. It doesn't just disappear because there's a charge or a badge or a theory. That presumption stands.
Getting shit from my mods. I talked to my mods on Signal too. Sorry with the interjection. One, cameraman, can we get our camera off of Karen Reed's face? We are very much trying to listen to Alan Jackson. I'd like to do that with my focus on him and not Karen Reed, the defendant, who could be given face-to-face questions one way or the other. My mods are all over the country, all over different countries, so I talk to them on Signal too. Now that, I don't think that chat self-deletes. I'm not sure. But yeah, so cameraman, can we get off Karen Reed, please? So I'll back up for a second or two just to make sure that I'm not missing too much.
Community's protection, moral certainty.
Wait, the Boston 10 feed It's the Boston 10 feed, but I thought Court TV, I thought it was the Court Pool feed. Did Court TV not have this stupid angle? If Court TV doesn't have this stupid angle, I'm going Court TV. Because I don't want to, quite frankly, I don't want to stare at Karen Reed while Alan Jackson's giving his closing argument when I'm critiquing the damn closing argument. Oh, Court TV had it too. Yeah, I thought it was a pool feed. So it's a pool feed.
As I said, those powerful words are not just some legal jargon. They're your mandate, they're your obligation, they're your community's protection against injustice. In our system of justice, Karen Reed sits here today, presumed innocent, cloaked in the presumption of innocence. That presumption is not fragile. It doesn't just disappear because there's a charge or a badge or a theory. That presumption stands firm unless and until the Commonwealth clears that high bar, the highest bar the law provides, proof beyond a reasonable doubt and to a moral certainty. That means at the end of this case, at the end of the trial, you think about one or more of the charges, you think, you know what, maybe that's true. It might be true. Then you vote not guilty. If you think it's possibly true or probably true, your vote must be not guilty. If someone among you thinks it's likely true or even very likely to be true, your vote is not guilty. It's because none of those standards, maybe, might be, possibly, probably, likely, very likely, none of those meets the extraordinary burden of beyond a reasonable doubt and to a moral certainty. A moral certainty means a level of confidence so strong, so incredibly unshakable that you could go home, you would go home, look your loved ones in the eye and say, I am certain. Not probably, not likely. I'm morally certain, and my certainty remains unshakable. The law defines moral certainty as the highest level of certainty known in all human affairs. Think about that. You must be that certain about the entirety, not part of, the entirety of the Commonwealth's case.
I'm picking this point to pause for a very specific reason. And this goes back to the point I was making before, the rant I was engaging in before. And the rant I engaged in before, I had told you guys that I believe that the system set up by Massachusetts of requiring the defense to go first because the Commonwealth has the ultimate burden of proof, or the actual burden of proof, is fundamentally unfair. Because by having the defense stand up there first, the implicit understanding of the juror is that they're standing up first to prove something to me. It also gives the defense a disadvantage of not responding or defending an allegation by the Commonwealth. And this is a very good point to highlight that right here. So the beginning of Alan Jackson's statement is what you would expect from someone that's asked to speak first. The call to action. God, I always love that. This is where the lawyer can use about as much hyperbole as they want because they are trying to hook you. They're trying to give you the call to action to really say, focus, lend me your ears, right? Imagine that someone going to the square and the town center and putting down their soapbox, standing on top of it. Good folks and people, lend me your ears. And then you have to get their damn attention. So you give the hook, the call to action. The corrupt cop, listen to science and physics, pay attention to the integrity of the investigation, the lengths to which some officers will go in order to protect their own. The drama. Give them the drama right up front. Second, the statement of the law. Reasonable doubt. It's your mandate. It's your obligation. It is the protection for the community against injustice. And then one of my favorite phrases of all time is cloaked in the presumption of innocence. I love that phrase. I've loved that phrase since it was first written. Then there's the admonishment of if you believe it's likely, then it's not guilty. And then there's the moral certainty. I am certain. I am morally certain, and my certainty remains unshakable. Now, each one of those statements Imagine the weight that would carry if it was appropriately placed in how we're supposed to view the arguments. If you are placing the burden on the prosecution, wouldn't the prosecution get up and say that first? And wouldn't the defense have the opportunity to say, you might have been persuaded by that, but were you persuaded to a moral certainty? And let me clarify what you just heard and give context to what you just heard. And all the recitation given to you by the Commonwealth of Massachusetts against Karen Reed, that might have been persuasive. But let me tell you why that falls short, because it does not get you to proof beyond a reasonable doubt and to a moral certainty. It is this, where this phrase, this part of an opening statement is more appropriately given in response to the Commonwealth's charge. It's one of the reasons why I have an issue with it. I like Jackson has done nothing wrong here. I think he is effective in communicating. The inflection and tone is remarkable. Does a very good job, up, down, with the pace, tone. It works great. I love it. I see that Octo's in the chat. Octo, good to see you here, my friend. See you here, Warren. But Jackson does a great job. This is wonderful. It's just, it's not appropriately placed to have the impact that it's supposed to have. You're not supposed to make the defense get out there and say, hey, even though the guy hasn't gotten up and said what he's proven yet, you have to view that through this lens of beyond a reasonable doubt to a moral certainty. Doesn't that feel unfair? Just from a perception, from the outside looking in. And why does it feel unfair? Because if I'm sitting in the jury box and I see this guy standing up and he's saying, you got to prove it to a moral certainty, I'm operating on the assumption of, well, hey, bud, hey, why are you saying they haven't? They haven't gotten up and told me what they've done yet. Why are you automatically defending something? It pisses me off. It really bothers me. Bothers the heck out of me. So that's the conclusion of the rant. That's probably not the conclusion of the rant. The rant's probably going to go on, but that's where we are thus far. So the call to action, the statement of the law.
As we discuss this case, you'll see that the Commonwealth comes nowhere near, nowhere close to reaching that extreme burden of proof. Ladies and gentlemen, on January 28th, 2022, it was a Friday night. John O'Keefe and Karen Reed made plans to meet up with friends, go out for drinks. You saw through video evidence and eyewitnesses that they were affectionate, they were loving, they were in good spirits throughout that evening. They started off at C.F. McCarthy's, which you've heard about, and eventually made their way over to the Waterfall Bar and Grill. When they got there, the Albert family, they were already there, and they were already drinking. The Albert family, it's been established as a very well-known family in Canton. They've got quite the reputation. Brian Albert was at the Waterfall, a longtime Boston police officer. His wife, Nicole Albert, was there. She was with him. His brother, Chris Albert, who was a Canton board selectman, he was there. His wife, Julie Albert, their daughter, Caitlin, and his sister-in-law, Jennifer McCabe, whom you met, and her husband, Matthew McCabe, whom you did not meet.
But he doesn't close that circle. He says Matthew McCabe, whom you did not meet, but he doesn't close that circle. I get the inflection on Jennifer McCabe. It's also one of the challenges of writing and trying to give your closing from written statement, but you can't. He had 24 hours, folks. Like if he had all weekend, we would have listened to this closing argument with almost no glance at the podium.
They were all there drinking before John and before Karen ever arrived. But also present at the Waterfall that night was Brian Albert's friend, Brian Higgins. We know that he had a romantic design on Karen. That becomes an incredibly important fact as we discuss the facts of this case. As the bar was closing around midnight, the Alberts invited everybody back to their house. They wanted to keep the night going. But the evidence revealed something interesting, that the invitation to John O'Keefe appears to have been for a different reason, an alternate reason. Think about the video of Brian Higgins.
I just caught this. Sorry, Alan. I'm gonna tease you a little bit here. Doesn't this sound like a storytime murder? Like the tone, the inflection, all of it. But John O'Keefe was lured back to the house for a different reason. A nefarious reason. A reason so dark, it was darker than the sky that evening, that had snow about to fall and accumulating on the ground. The reason was scary, because the individual about to give that reason would hold his fists up in just a moment. Please pay attention to the video and keep your eye out for the menacing character. Sorry, Alan. It was good. It was good intonation, good tone. I like it, but it sounded just right there. I heard it the second time, and hearing it the second time, not on 2x speed, because the first time was 2x speed. 2x speed, that sounds a lot different than it does when I just heard that tone. It was dark that evening, very dark.
And what Michael Proctor in his investigation completely and utterly ignored.
This part.
Higgins was agitated after a day of drinking, agitated that it was John and not Karen. John with Karen, not him. Recall that ominous text that he sent to Karen with her and John standing just feet away. Well, he got no response. And then we see this. That's what Brian Higgins was confronted with following his well text. What of all things starts going through Brian Higgins's mind? Where does his mind go? What is he thinking about after seeing this, after witnessing this?
Can someone tell me what I'm seeing? I can't see shit. Is this the forehead kiss? I can't see anything in this. Like the well. Was this? I don't know what I'm supposed to see here. Oh, this is the forehead kiss. Okay, this is the forehead kiss. I'm being told it's the forehead kisses. Well, and then John gives the forehead kisses. Okay. All right, I get it. So he's laying the scene. I agree. I'm right here. There we go.
He shows you. And if Michael Proctor had been the least bit interested, this video would have shown him too. Take a look.
Did they play that whole clip the first time? I feel like the clip was shorter last time. Side note. This is also what you do when you try to get a child who has a stomachache to fart. Sorry. he's about to like pick him up and start shaking. Just silly.
Sparring, practicing, fighting techniques.
All right, that Alan, I mean, that's a stretch, sir. Now, here's the thing. He does that, and I imagine there's some side notes, like side-eye glances from some jurors who are going, really? Sparring? That was two grown drunk jackasses just being drunk jackasses. But I think that it might be appropriate, because the thing is, we didn't see the second part in the first trial. We saw that
Where was
first.
Brian Higgins' mind? What was he thinking about? And then what happens? Before you look at the next video, think about what you're going to see. This next video is after he sees John kiss Karen on the forehead, after he sends that aggressive text to Karen with her standing just feet away. Watch closely, and this is what you're going to see. This is what Michael Proctor and his investigation completely ignored. Higgins is very clearly upset. He's agitated. Chris Albert tries to control him, tries to talk to him, calm him down perhaps. Chris forcefully grabs Higgins' arm. You'll see that in the video that you're about to watch. It appears that Chris is trying to calm him down from something. Brian Albert's standing right there with the other two men, but Brian Higgins is having none of it. He appears to be hyper-focused on one person and one person only, John O'Keefe. In an instant, Higgins angrily jerks his arm away from Chris. Higgins rubs his brow, and he directly gestures at John, a gesture that looks a lot like, let's step outside. Let's go outside. But John.
Here's why this is smart. First time I saw this, I was wondering why the video wasn't playing and why Alan Jackson wasn't narrating the video as it was playing contemporaneously. And I thought it would initially, my initial thought process, again, think about the biases and how you rethink these things. My initial thought process was this would be so much more effective if Jackson was actually narrating what was transpiring in real time. Right now, it's still the freeze frame. But in kind of looking at it again, I'm thinking that that's not speaking to all the jurors. There would be some jurors that would be eyes on screen, listening to Alan Jackson narrating, but there will be several more who would be focused on Alan Jackson and not the screen. And by narrating the video, you would risk that some of the jurors who would otherwise be looking at the screen would be listening to you and looking at you. Told you guys a story about the whole like moot court and the collar and how I got criticized about the fact that the judge couldn't stop looking at the quarter inch between my collar and my tie, and how it was a lesson for me of never actually be the one the person's focused on. Make sure they're focused on the words you're saying. So this is very smart in retrospect, because again, cameraman's sitting here focused on the screen, but I imagine every juror, once they realized that it was a freeze frame, every juror looked back to Alan Jackson and was focused on what he was saying, which is what the point was. Come look at me, focus on what I'm telling you, and then I'll show that to you and watch it given what I've said. It was a very good point. And again, this is something that gets overlooked. It's a good point. It wouldn't be watching the speaker on the screen. Yes, and you need to make sure every juror is watching the screen. Could you object that narrating the video is legal? No, you are arguing the evidence and the reasonable inferences there too. Like you're allowed to argue the inferences to be taken from the evidence. And you're allowed to project onto that evidence the inferences you want the jurors to take. It's the same thing as having a slide up there with a still frame and then arguing what the jurors should see in that still frame. But you want them to focus on what you're saying, and then you want them to focus 100% on the video itself.
Looks at him, takes a swig of beer, completely ignores him. Take a look.
Cameraman didn't pick up on it. The side-by-side highlighting edited, phenomenal. I imagine this might have been objected to. If I was the prosecution, I would have objected to this and said that this might have been either altered. It's not the evidence as it exists in real time, but this was phenomenal. This part, the guys in the bar sparring, they're practicing. I don't buy into any of that. I really don't. I don't think there's any jurors who buy into that, especially if it's a younger juror. They're just looking at these assholes being assholes in the bar. They're like, oh, you guys are just showboating, just being jerks. Now, here's the thing. Let's say that I view them as being peacocks or showboats or drunk assholes. Maybe I need to see that they're being drunk assholes, but they're being drunk assholes that are capable of horseplay, physical interaction. Oh, it's so stupid when you say it out loud. It's like they're not toddlers. They act like it, but sure. So it's this part that I think is really more impactful. And this is what we didn't have in the first trial. They're both shouting at each other across the bar. Now, what
Michael
I thought
Proctor.
was most interesting about this wasn't really the beginning. It's that when John has his head turned towards the bar. Hang on, it's this part. It's, and I can't tell you how much I wish that date stamp wasn't there. Like, I really wish that date stamp wasn't there and I could see that. I don't know. Is he flipping him off? Is he egging him over? Because John O'Keefe's head is clearly turned the other way. But this is more impactful. This makes more sense. Arguing the first videos, little to no impact, right? I don't think that does anything other than make the jurors kind of dismiss the credibility of your argument. If you're trying to tell me that you're hanging your argument on these two jackasses being jackasses in a bar, I'm not giving you a whole lot of credibility. But you play this video of that, because everyone knows that gesture. You have someone reaching out to the arm. You have the person who's leaning over, trying to get attention or not get attention. I don't know. But point being made isn't that Higgins did this. It's that Proctor didn't even bother to ask the question. Very different contexts. One being more persuasive than the other. If you're trying to use this video to prove to me that Higgins did it, I'm going to say you're far away from that. But if you're trying to use this video to prove to me that Proctor should have at least asked a fucking question or a regular question, Ian's not here, but I got to fill in for him, then I'm going to buy into that 10 out of 10. Proctor should have asked the damn question in view of this video, especially because he said he watched the whole damn video several times. And what's funny is now you see Higgins really doing. The suggestion was in the testimony in the first trial, the perception I had was that they all kind of had this agreement to go back to the house, right? They had the agreement and that there might have been some coaxing, but holy crap, did anyone think that Higgins was the one leading the charge in the first trial? No. From the first trial, I was left with the impression that Brian Albert, it was a plan all along and yada, yada. But this video gives me a very different impression of Higgins jumping out there and leading the charge.
Michael Proctor, the lead investigator in this case, had all this footage, but he did nothing. He had access to the exact same thing that you saw. Why did he do nothing? A few minutes later, Higgins then texts John directly. You coming here? 3 question marks. It's now 12:20 a.m.
Alan Jackson with the Twilight recitation again. You coming here? 3 question marks. Sir, respectfully, you coming here? 3 question marks can mean very different things. Very different things. Hypothetically, well, I'm not going to go. Very different things.
These guys are not good friends. They barely spoke or even acknowledged each other when they walked into the bar together, other than a quick greeting. So why was Higgins coaxing John over to 34 Fairview? You coming here after this? And why not text Karen? Because at that moment, he wasn't interested in Karen. He was interested in John O'Keefe. This is about 5 minutes before John gets out of the SUV and walks toward the house, about 5 minutes before Karen sees him alive for the last time. So what happened inside that house, or that basement, or that garage? What evidence was there for the investigators to look into? What did they ignore? laceration over John's right eyelid, black eyes, a large dog at the home, an obvious dog bite on John O'Keefe's right arm, a head injury from falling backward onto a hard surface, alleged surface, a text from Higgins, one of the last people to ever communicate with John O'Keefe. You come in here? Those words now echo in the wake of John's death. But Michael Proctor, he didn't listen. When John didn't come back outside, Karen, very oblivious to what had happened, thinking she was just left alone in the car out in the cold in the middle of the night, she got frustrated and she drove home. She arrived back at home and her Wi-Fi connected to her car or phone connected to John's Wi-Fi at 12:36 a.m. It's an important time, 12:36 a.m. She left John voicemail after voicemail after voicemail. He was unresponsive. He didn't pick up a single call. He didn't respond to a single text. The longer he didn't respond, the more upset she got. Her voicemails reflect that frustration after the fact. That's the frustration that you hear in her angry voicemail.
All right. We're going to be a little bit nitpicky here because I'm going to be fair to all sides. Mr. Jackson, one of those voicemails was left on the way home. It's not so much after the fact of being frustrated with the calls not being answered. I mean, she was pretty hot right off the bat. Like, it was pretty quick. It was pretty quick. She was pissed off. So one could infer that she was upset about him getting out of the car. And that or some confrontation that existed there is probably one of the reasons why. But the voicemails kind of began pretty quickly after she left the property. So that is the lawyer taking and putting a spin on some bad facts. There it is. That's a lawyer putting a spin on bad facts.
She uses harsh words and foul language. She's obviously upset. She's obviously irritated because he didn't come back out of the house and he wasn't responding. But Karen did not know what you know. She didn't know what the investigators should have known. She didn't know what was happening with Higgins and Albert and with her boyfriend, John O'Keefe. When he didn't come home at about 5 a.m., Karen went looking for him in a panic. As you know, her worst fears were realized when she found John beaten, battered, bloody, and left in the snow in Brian Albert's front lawn. At 6 a.m., when Karen found John, you heard about the scene. It was described in detail. It was chaos. To use Mr. Brennan's word in his opening statement, it was bedlam. The screams for help.
Facts not in evidence. She was upset because she was waiting for John to come back and tell her if she was wanted there. He said he would come back out and tell her. That is not in the evidentiary record. Not from any of the witnesses at this trial. Not from any of the clips that were played. She said she watched them go in. She didn't explain why she was upset. Not from my knowledge. If I'm wrong, I'm wrong. I'm happy to be wrong on this. I would be happy to be wrong on this. But if I'm the juror, I don't know that I can make that inference. I don't think that was in this trial. So in the first trial, that might have been presented. This understanding of her being out in the car waiting to come back in, waiting for him to come out and say, you're allowed in or not. It didn't get presented in this trial. So in this trial, there's no understanding. This is the point of the clip, or the clip that was played. The part of the clip that was played did not include that part. I don't recall. I don't believe that. And the full length clips are not in evidence. They are not. Only the portions that were played by the Commonwealth are in evidence. That is it. So this is why this case is more complicated by the clips. What you can play, what you can't play. And opening statements are not evidence. I don't believe that this came in evidence in any respect.
help by Karen, the yelling and the hollering, ambulances, emergency lights, fire engines, ladder trucks, paramedics, patrol vehicles, patrol officers, all of them swarming all over the lawn just under Brian Albert's bedroom window. And of course, as you learned during the course of this trial, Brian Albert, a sworn peace officer, a first responder trained in being a first responder, never came out of the house. Never went outside to help a fallen fellow officer who was laying on his own property. Never came out. And you learn through the undisputed evidence that the lead investigator, Michael Proctor, for his part, never went into the house. The Commonwealth has struggled to try to prove that John O'Keefe ended up in Brian Albert's front lawn because he was struck by a vehicle. They have failed. They cannot and they will not ever be able to prove.
I wanted Alan to focus more on that. That was one point of the evidence I really wish he would have focused on, is the ambulance, police vehicles, everyone right outside the front door. He doesn't happen. And the part I wish he would have hammered home is not just that, but we know that he was awake because Jen McCabe went in and woke them up. We know he was awake. He was there. He was present. It wasn't like he was passed out and didn't know what was happening. We know he was awake. He didn't come outside. And I would have wanted him to make more of an inference there. Push harder on that point. He pushed it, but you can spare another sentence.
That John was struck by a vehicle beyond a reasonable doubt and to a moral certainty, because the science does not lie, the medical evidence does not lie, the physics do not lie. Their investigation was flawed from the start because their investigator was corrupted from the start by bias, personal loyalties. Folks, they cannot prove a collision. John O'Keefe was not hit by a car. There was no collision. So let's start there. I want to take a minute to discuss the actual science, the actual physics, and the actual medical evidence that was presented in this case. The science, it's an old saying, is known as the silent witness. It doesn't lie, it doesn't forget, and notably, it doesn't take sides. If there was no collision, what are we doing here? In order for there to be a collision, there has to have been an impact site. The vehicle had to have struck John, period. I want to remind you of some of the most important testimony in the entire case, and it comes from the Commonwealth's own medical expert, Dr. Irini Scortibello, the Commonwealth's medical examiner, someone governed by law to make these decisions. We know that a person struck by a vehicle suffers massive trauma, broken bones, fractures, soft tissue damage, torn ligaments, contusions, soft tissue injury, severe tissue injury, crushing blows. None of that was present with John. None of it. Not anywhere on his body, including his right arm. Not one bruise. Nothing. The fact is, the injuries are not from a vehicle impact. Not his head injury, not those scratch and bite wounds. Not a single medical expert. Think about this. Not a single medical expert called by the defense or called by the Commonwealth has testified that John was hit by a car. Not one. Think about the irony. Not one.
One of his best.
That's not just significant. It's literally the most important point in the entire trial. Listen again to Dr. Scortibello's words. Question. You did not include in your autopsy in any fashion any discussion of whether Mr. O'Keefe's injuries were consistent with a motor vehicle accident. Did you? Answer. No, I did not. She told you, quote, I did not see any evidence of an impact site, end quote.
I'm gonna let him get through this part.
She was talking about John's body.
Pause after he gets through the medical.
The Commonwealth's own medical examiner, Dr. Scortibello, performed the autopsy. She did it personally. She's the only one to have personally examined John's body, and she found no evidence of an impact site on his entire body. That in and of itself is reasonable doubt. You don't need anything more. The Commonwealth's case is done. It's cooked. Their own experts said there is no evidence of a collision, no evidence of an impact.
AJ, ruh-roh. Oh Oh, who heard it? Who else heard it? Who else heard it? I want to hear who else heard him. Who else heard the slip? Anyone else hear it? And then really, really wish that like might have been like of all of the opportunities to say the word or to screw one word up, right? Of all the opportunities to say one word. And I talk about this about people that are embedded in one camp or the other, right? Hypothetically speaking, let's say that you are very much in favor of the, I don't really buy into the defense theory right now. I kind of believe that she's guilty. And you're listening to this attorney and you're listening to him with a fair bit of skepticism. And you're watching it. And you're basically, you hear him say, there was no evidence of a collusion. And you're going, oh, okay. All right. Hang on. It was the one part where it's like, damn it. like you couldn't say a word during your closing and you kind of said it.
That in and of itself is reasonable doubt. You don't need anything more. The Commonwealth's case is done. It's cooked. Their own experts said there is no evidence of a collision, no evidence of an impact. If you want to know what an impact looks like.
Oh, there he goes. It was. No, you cannot think that he did that intentionally. Because if you think that he did that intentionally, there was no evidence of a collusion. Because collusion, the only people who could collude in this case would be the people of the Alberts, the McCabe's, all of them were colluding. They were colluding. That's where the collusion is. It was a bit of a slip. And then y'all are going to be mad at me here. I've told you from the very beginning, I am going to try in my very best, to my very best extent, to recognize my biases as being pro-defense, analyze and inspect those biases and analyze the evidence and the argument being offered with an understanding that bias is generally going to lean pro-defense. And then also try to give a fair interpretation of how the other side might perceive certain things being argued. I don't think it does anyone any good to view everything through rose-colored glasses. I think that it is only good to actually view things through a realistic perception of how everyone in that courtroom might be viewing the evidence, pro or con, good or bad. So I'm telling you that if there's someone on the jury who is viewing this skeptically, is looking at that and saying, huh, you said collusion. There's no evidence of collusion. You kind of said the word. Do I think Alan Jackson is a good attorney? Hell yes. Yeah. I'm not really afraid to go up against any attorney. It would be very difficult to litigate a case against him. Very, very difficult. I would not want to. If I had to choose adversaries, he would not be one I would choose. He is very effective. All of it. Remarkable. But I'm also going to be critical where I can be or where I am or what I see. I'm going to give you a fair analysis. The Commonwealth's case is cooked. There was no evidence of a collision. It was just
Take a look at this. This is what a body looks like after being struck by a car at 25 miles an hour. And this is what a car looks like after hitting a person.
Bro, here's the thing. This is a masterclass in closing arguments, and he had an hour and 15 minutes. Both lawyers had an hour and 15 minutes to present a case. They had evidence of 30 days plus to present. Could I do this? Probably no fucking way. But is it a possibility that lawyers are going to look back at this, hindsight being 2020, and think that they left stuff out or should have done something a little differently? 100%. Like I said, everyone can be critical. Everyone can be praiseworthy. Everyone can be praising. I'm very praising of Alan Jackson. That's kind of funny that a lot of people are very mad at me right now. It's odd because I've kind of been consistent the whole time.
At 25 miles an hour. These are exhibits from Dr. Welcher, the Commonwealth's expert. John didn't even have a bruise. Make no mistake, Dr. Scortibello was presented with the Commonwealth's theory of the case, the same case that you've been presented with, and she refused to conclude that John's death was a homicide. She flatly refused to conclude that there was a collision. And you know who agrees with that? That silent witness, the science, the physics, the data. Dr. Wolf and Dr. Rentschler, you just met them recently. They explained they were not initially hired by the defense. They were asked by another agency to conduct their analysis. They looked at the evidence from both.
Nice move. Nice move. Well played, sir. Anyone catch that one? He did not say another entity. He's allowed to recite exactly the evidence that was elicited at trial. And at trial, they did not say another entity, another person. They did not say another third party. They actually got all the way to another agency. Good move. Way to go. And he adds the inflection on another agency. Well played. That's one where you very much do that.
Both sides, not taking a side for the defense or the Commonwealth, completely independent. They looked at the damage to the SUV on the one side of the coin. They looked at the injuries to John O'Keefe on the other side of the coin. Both PhDs, both engineers determined there was no collision. I'm not saying it. The science says it. That SUV's taillight was not damaged by striking an arm. And John was.
Okay, we've made it past the medical part, and I get to focus on one thing I wish he would have brought up, because I said we're gonna talk about things that he raised and things he didn't. So in the medical part, because we've cleared the medical and now we're on to the science. All right, so we're gonna take little pauses here and there, and we're gonna do medical, we're gonna do science, we're gonna take pauses, because remember, hour and 15 minutes. He has an hour and 15 minutes to make his entire statement. We're gonna do this with Hank too. So in the hour and 15 minutes, what he is consumed and what he is focused on with the there's no collision. Let's start there. Okay. The investigation is flawed because the investigator was flawed. Love the argument. Great. With the medical, in order for there to be a collision, there had to be an impact site. Commonwealth's going to take an issue with that. They're going to say the elbow was the impact site, and that was the injuries that were sustained. He doesn't talk about the abrasions. He doesn't. Not here. He doesn't. He talks about the not one bruise. One point I would have wanted him to highlight is, at least here in context, I know he brings it up later with the x-rays, but in context, I know he brings it up later with the x-rays. I wish he would have brought it up here, because he has organized his closing by theme. And with this theme, he's talking about impact site and injury, and there being the absence of an injury. So jurors are going to focus on, this is the theme. This is right here. We're talking about medical. So he says, not one bruise. I wish you would have brought the x-rays up here. And then there was one thing I really wish you would have brought up, was that I think it was Dr. La Posada who said that they had actually drawn the skin back. They had pulled the skin back to observe the actual soft tissue. It wasn't just the x-rays not showing bruising. I believe they had said they drew the skin back to actually look at the tissue itself and to see not just whether there was a physical bruise appearing on the skin, but to see whether there was any swelling or injury to the actual musculature or the actual, and whoever it was testifying about the ME, and the ME's reports and records are in evidence. Was that Dr. Russell who brought that in? I would have wanted to bring that up. Even with the legs, I would have brought that up. I think I would have brought that up here with the medical. I'm saying that they went so far as observing in the legs, not just the scratch, the superficial scratch that was there, but they actually, and this is where the hour and 15 minutes really kind of kills you. If this was a 3-hour close, you better damn well believe, the ME herself brought it up. I'm seeing in the chat. You better damn well believe that if this was a 3-hour close, that would have made it in. And this is why I don't like that you limit it to an hour and 15 minutes. It's not fair. Let the lawyers argue the evidence. There's a lot of evidence. Let them argue it. Irony, not a single expert says he was hit by a car. It's a pretty good point. I liked it. I liked the fact that the irony, the inflection, it makes scientific evidence seem more impactful because there's an emotional tie to it. Very good. This is very good. I wish, and I think that that's the one critique I had. I wish he would have taken all the medical, put it in one, take the x-rays there, focus on the fact they actually drew back the skin, and saw no contusions or bruising, because some people are going to focus on this understanding of a misunderstanding, understanding of, well, yeah, if I get hit in the arm, a bruise, just the natural understanding of a bruise isn't going to show up for several months or several hours. Right. So if I get hit in the arm, am I going to immediately bruise? No. Within 4 or 5 hours, you might see swelling. But is the musculature and the tissue immediately beneath the surface of my skin going to show some reaction? Blood vessels broken, whatever. I think it might. So I would have highlighted that here. That's my only critique.
Was not struck by a 6,000-pound SUV. Period. Full stop. Dr. Dan Wolf did the testing on the taillight. Actual testing, not some ridiculous blue paint kindergarten project. He did lab testing. He did field testing. He did data testing. Actual impact force analyses.
You know how mad I was here. I really liked the line that I came up with. When was it? I was so mad. I was going on a rant. I think I said something to the effect of the prosecution promised you science. No, it was the prosecution promised you science and data, and they gave you paint by numbers and cosplay. If I was giving a closing argument, you better damn well believe I would have thrown that in there. Oh, one line I wanted. Prosecution promised you. Look at the science, look at the data. What did they give you? They gave you paint by number and cosplay. Damn. I was waiting for it. I wanted it. Oh, it was so good.
Every single test dated paint pounds not damaged by striking an arm. And John was not struck by a 6,000-pound SUV. Period. Full stop. Dr. Dan Wolf did the testing on the taillight. Actual testing, not some ridiculous blue paint kindergarten project.
God,
he did lab testing. Ridiculous. He did field testing. He did data testing. Actual impact force analyses. In every single test at every single speed, the taillight damage was inconsistent with striking an arm. In every test, the taillight damage was inconsistent with damaging the shirt, the sweatshirt. Remember that severe internal damage to Karen Reed's taillight. Not just the outer lens. The internal diffusers were completely smashed, completely shattered. ARCA testing established that all the internal components of every single test taillight, especially the diffusers, remained completely intact. Conversely, on Karen's taillight, the diffusers were almost completely gone. Folks, understand something. If any part of that diffuser portion of the taillight is broken, there is no light.
Was that in evidence? Because I don't think it was. I think that if we're being fair, I don't think that was in evidence. I don't think there was testimony about how the diffuser on that particular model of SUV and taillight worked. Was it? To me, that was not in evidence. Not on anything I saw. And I watched every witness testify. I think Wolf called it out that the diffuser was there and that it emanates. I don't think it was as clear as it was. Did Wolf say it? If Wolf said it, Wolf said it. Okay. It was mentioned. I'm going to give the chat the benefit of the doubt. All right. If it was in evidence, then it was one of those that AJ was very good to bring up. Let me tell you this. If I didn't remember it from evidence, having watched all the testimony, then Alan Jackson bringing it up is very important. Because if I was a juror without that understanding or without that, I would have thought back to Wolf and been like, I didn't hear that. I might have reached that conclusion naturally. But if Wolf testified to it, he testified to it. And AJ needed to emphasize that. Very much needed to emphasize that. So I guess we had it. Yeah, Dr. Wolf briefly mentioned, I'm seeing the chat go by. Yeah, I get it, guys. I understand. I very much understand. It's a good point to raise, good point to drive home, because I thought that was very important that he bring that up. And when I heard this for the first time around, I was going, did he just say something that wasn't in evidence? Did he make an argument that we didn't hear evidence for? Was my thought process.
It doesn't illuminate at all. It's just black. Let's take a look at a couple of photos. At 5:07 a.m. at One Meadows, that's the photograph on the left. What do you notice about the right taillight? It's completely illuminated.
Lit up.
Later, at 4:12 in the afternoon, photograph on the right, it's lit up. How can that be? How can that be if the Commonwealth claims that those diffusers, the portion that lights up the light, were already scattered all over 34 Fairview? That's their theory.
Now, that wasn't raised in the first trial. So I like that. Trish. It's kind of my job. I'm not gonna just, I will give my summation at the end. And if you hang on until then, you might actually change a little bit of your script. Right now, I'm focusing on things he does good, things he does bad. This one, I didn't hear that in the evidence. He brought it up. He focused on it. That was a damn good job. So chill out. We'll get there. Because I think this is one of the better closings I've ever heard.
But don't believe your lying eyes. The taillight's completely lit up. That would be impossible. Dr. Andrew Rinchler, a PhD, a biomechanist, explained that at those speeds, the other side of that coin, John's arm would be basically destroyed. Contusions, swelling, torn ligaments, hyperextensions, dislocation of joints and bones, fractured, broken, and shattered. But as you know, John's arm was pristine, save those dog and claw bites.
Here we go.
He didn't even have a bruise. Think about this. Think about that photo of those x-rays as you deliberate.
Yeah,
you can manipulate a
X-rays.
taillight fragment. That's
all right. I kind of take it back. I don't know. Hindsight being 2020, if it were me, and again, I'm wondering about this, I probably would have brought the x-rays up when I went through the medical, brought the x-rays up, talked about them. X-rays that they didn't know existed, blah, 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 blah. And then I'd hammer that again. But just to kind of put in the juror's mind of like where they're going, oh yeah, the x-rays. Then I would have gone to the physics and been like, the physics, the arm would have been destroyed, and then would have done exactly like this. This is beautifully presented. Beautiful presentation.
It's not that hard. You can manipulate a taillight fragment. That's not that hard. You can't manipulate a bruise.
Look at that arm. That is pristine. Nothing. Look at that. Nothing. Remember how I told you that he was talking to the people, and I had told both sides, both attorneys were talking to the ones who would dig their heels in. Right here, this one point right here. This is a dig your heels in point. This is if there is a conflict in the room in deliberations, one of those jurors is pounding their fists on the table and saying, give me the picture of the x-ray, and then putting it on the table and say, how did that arm look like this getting hit by a car? That's why I said they're talking to the ones that they're dug in, because they're hoping that they bring these points up.
If they claim the car was going fast enough to shatter the taillight and shatter the diffusers, that it was also going fast enough to destroy and shatter John's arm, and it simply did not. How do they square that? They don't, and they can't. So they spent nearly $400,000 of taxpayer money to hire someone to dress up and look like John and paint his arm blue.
Cosplay.
Which told you
could have done fingerprint cosplay. Here's the other part I want to focus on. You know what else that X-ray doesn't show me? It shows me the entire right side of his body. I don't see a broken hip. I don't see hip fracture. I don't see shoulder dislocation. I don't see collarbone break. I don't see ribs fractured around the area that I would expect them to. I know there were some fractures around the sternum area from the chest compressions. I don't see a single finger fractured. Nada. I don't know that I've seen a bone scan look that good. Okay.
And look like John and paint his arm blue, which told you exactly nothing. The ARCA testing, conversely, also established that it is impossible for John's sweatshirt sleeve to be damaged by an impact with the taillight. The Commonwealth's theory is that the sleeve of John's hoodie sweatshirt was damaged by flying shards of taillight slicing through the shirt and through John's arm. I have 3 questions. Number 1, John's arm had about 36 abrasions. How did 36 shards of acrylic?
Yes. 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 I love this. I love this. And it's placed far enough in the closing argument that it wouldn't be responded to. This is risky as hell. This is risky as hell. Why is this risky? What did Alan Jackson just do? Alan Jackson just asked the jury a hypothetical question. He just said, Alan Jackson just asked the jury a question. I have 3 questions. If anyone in the jury has made a conclusion, the jury is listening to those questions and giving answers to them. So you got to be pretty good about what questions you're about to ask. I love this play, though. I love this move. Great move. I have 3 questions. Because this is basically this. This is what this does. This is what this does. It's risky because you don't know what it's going to do. It's risky because you might be alienating someone in the jury. It's risky because the jury is looking at you and saying, well, why do you have questions? You're the lawyer. You're telling me what's supposed to happen. You're supposed to tell me what had happened that night. So I'm not sure that, and this is why I like where it's placed in the argument. If he had done this early in the argument, then Hank would have focused on it very much because it would have been primacy, right? Get that position, answer those questions. I would have focused my closing on combating the answers to those questions. If you put it at the end of the argument, then it's the first thing that Hank gets up and says. If you put it at the beginning of the argument, also the downside is the jury looks at you with skepticism. Why do you have questions? Why are you leading with this? But you place it in the middle of the argument where you've essentially established credibility with your recitation of the evidence and the facts. You've gone through all the history. You've laid all this foundation to the point where you can now assert that there are 3 questions because you've done this. Also, the repetition of the 3, I love this. Great move. But don't kid yourself. This is risky. It's a risky move. I have 3 questions. You might have some jurors say, really? I love it though, because it also does this. It puts you on the same page as the jurors. You're like, hey, I'm one of you right now. I have 3 questions. You should have these same questions. We are the same. I'm looking at the Commonwealth and saying it kind of shifts that burden back where they should be. You're telling the jurors, you should have these 3 questions as well. I love it. It's a good move. Very good move. Yargan, this is the other part. The other reason why I hate. This is the other reason why I hate the defense going first, because I'm going to have to do the same level of breakdown with Hank Brennan. And if I make a comment of like, I like the argument Hank Brennan makes here, this is going to be complicated. Pissed. Hopefully you'll like that neutrality.
The ARCA testing, conversely, also established that it is impossible for John's sweatshirt sleeve to be damaged by an impact with the taillight. The Commonwealth's theory is that the sleeve of John's hoodie sweatshirt was damaged by flying shards of taillight slicing through the shirt and through John's arm. I have 3 questions. Number 1, John's arm had about 36 abrasions. How did 36 shards of acrylic go through 9 tiny little puncture holes? How'd that happen? Somebody needs to answer that. Number 2, why are there no slices or cuts in the hoodie? All the defects are punctures. Punctures that you might get from, say, I don't know, canine teeth. And number 3, if the shards cut bloody gouges into John's arm, that's their theory. Why is there no blood, no skin, no tissue on a single shard of taillight
That one.
that they claim came in contact with John's arm? The Commonwealth cannot answer a single one of those questions because John's arm was not impacted by the taillight.
And he picked 3 good questions. Oh, he picked 3 good questions. Oh, it sucks. He picked 3 really good questions. I love it. 36 wounds, 9 holes. Okay. So you got to figure that some of those wounds might have been superficial. You could probably get it through the cloth with a sharp point without actually tearing the cloth, maybe. But then you've got the projected parts of the tail light. Commonwealth comes back and said, well, they weren't projected parts of the tail light. Tail light was already cracked, and the cracks were the ones that made the injuries. But then you can't have the 36 plus the tail light was already cracked and made the injuries. It doesn't work that way. And then you have the blood question, which I've always asked, is these pieces of tail light, you're telling me you magically found a hair on a bumper and you found like touch DNA on a piece of plastic, but these pieces of plastic were said to inflict such damage that they cut through fabric into the arm and didn't have anything left behind. And that part doesn't make sense to me.
It doesn't make sense simply because it didn't happen. Compare and contrast the ARCA experts and their actual testing to Judd Welcher. He came to you in the Commonwealth's case in chief and...
Don't give him Dr. Welcher. Come after him. Judd Welcher. Judd Welcher. Compare and contrast to Judd Welcher. Oh, look at the lady in the back, the blonde hair. She's like, oh shit, he's going there. She gave very subtle facial expressions. Very subtle. She was subtle the whole time. I do appreciate that. The little very subtle smirks here and there.
He told you that for the better part of $500,000, he'd come in and testify that John was tall enough to touch the taillight with his elbow. That's it. And even in that basic demonstration, he had to lean in to manipulate it to get the results that he wanted. Dr. Welcher then claimed that the reason he didn't do the reconstruction, the actual testing, think about what he said. There isn't enough evidence to determine what happened. I beg your pardon?
Yes.
What happens when there isn't enough evidence, in his words? You vote not guilty. That's what happens. That's out of his mouth, not mine. The Commonwealth also used the same company, Aperture, to try to establish a time of a collision that never occurred. The Commonwealth called Shannon Burgess, the supposed expert from Aperture. There is a cardinal sin for experts, folks, a cardinal sin. It's called confirmation bias. It's when you decide to change your opinion to fit a theory.
No, cite it right. No. Don't do that. Don't do that, Alan. I don't like the way you phrase that. Confirmation bias isn't when you change your opinion to fit a theory. It's not. Confirmation bias is when you have an opinion or a theory and you look at only the information that confirms that opinion or theory and you ignore all the information that refutes that opinion or theory. I wish that would have been more carefully stated. Because it's not that I get why he said change, because he wants to put the report was changed. But I don't think the report was changed is the bigger point. I think it's the ignoring the other glaring issues and choosing only the things that are helpful. Focus on what they chose to focus on and how they ignored the other stuff. Oh, if people aren't hearing the difference, let me tell you the difference. One is suspecting, and this is for the sake of argument, right? If I'm trying to argue to somebody that the only reason they have this theory is that they had first an original theory, and then they changed that theory because they wanted to change that theory and they wanted things to confirm that. So you're trying to get into the mind of people that they had an original theory they were working off of, and then they worked to change that theory with the evidence, versus they were presented with a theory and they only accepted information or data that confirmed or corroborated that theory, and they ignored all other data that might have conflicted or ruled that theory out. The second one is more impactful because I think the second one falls more in line with these facts. Aperture was hired knowing the theory the Commonwealth had and accepted information presented to them. No, he's not saying that, guys. He's saying they changed the theory. I just listened to him say it. You want to play it again? You want to play it again? We can play it again. You guys disagree? Fine. We'll play it again. We'll play it again.
It's when is a cardinal sin for experts, folks. A cardinal sin. It's called confirmation bias. It's when you decide to change your opinion to fit a theory.
Change your opinion to fit a theory. It's not really the case. It's not what confirmation bias is. That's not an accurate recitation of confirmation bias. It's just not. Changing your opinion to fit a theory. No, that's corruption. That's stupidity. That's inappropriate. That's ignoring science. But that's not what confirmation bias is. And let's say that you have a true science nerd in the jury. Let's say you have a science nerd in the jury. The science nerd in the jury is going to say that's not confirmation bias. But I get that they changed their opinion. That there's really, I don't think there's an artful way of saying this, because this is trying to highlight Shannon Burgess and how, and I think maybe the better way of saying it is that he changed. I'm thinking of this like from 30,000 feet, right? So 30,000 feet, having seen this, hindsight being 2020, we've had more time to digest this case than anybody. These lawyers are doing what they're doing. If I'm going to do this or phrase this, I'm going to basically say confirmation bias is having an understanding or having a desired outcome, something that you understand to be either a desired outcome or one you view more favorable than the other, more likely than the other, based on your bias of looking at it, right? So you have an understanding. You start at the end, and then you adopt or ignore information that you receive along the way in furtherance of that understanding. And when you are faced with evidence that does not support that understanding, you come up with a new method of interpreting that evidence so that it does. I think that might have been how I probably would have rephrased it a bit from that, but would have said you start from the end with a conclusion in mind and you adopt information that supports it. You ignore information that doesn't. And when you can't ignore the information that doesn't support it, you find and develop a new opinion on how that information can be interpreted to instead support the opinion that you started with. There, it's right there. It's there. It's that one. It's the last one I just gave. Whatever I just said, that one. I'm not going to repeat it again. I don't think I could. But that's how I would phrase it. I think that's how I would phrase it.
The most important takeaway from Shannon Burgess' testimony was how brazen, how shameless he was in trying to change the data to try to suit the Commonwealth.
That one.
Remember Mr. Brennan's opening statement. He made some promises to you. He said, this case is about the data. He stressed it over and over again. They've had 3.5 years to get this right. The Commonwealth has had this case for 3.5 years to get it right.
Bro, some people in the gallery just had some really big expressions about the 3.5 years.
So his top expert, Dr. Welcher, prepares a report. And that report says that John O'Keefe was struck by Karen Reed's SUV at 12:31:38. Note that time, 12:31:38.
I was waiting till he was going to get back to that. Wish I would have timestamped it when he said 12:36.
He was struck. He was immediately incapacitated. He was immediately unconscious. So says Judd Welcher and the Commonwealth's theory. But there was a huge, huge problem with that. And somewhere in the middle of trial, somebody must have realized it. They must have realized that the very data they produced unequivocally establishes that they are wrong about a collision. It could not have happened. Why? Because John was interacting with his phone after 12:31:38. Remember, the collision immediately incapacitating. How could he be interacting with his phone afterward? He was on his phone, opening his phone, checking his phone, reading texts on his phone, and locking his phone, all of it after 12:31:38, which is the time Welcher clocked for the moment of the impact. And he was taking steps and walking with that phone after 12:31:38 also. That's what their own data showed, and it devastated their case, and it devastated that false theory.
Good use of time. Very good use of time. Very good use of time. Because I don't know that Hank Brennan comes back and refutes that. So he doesn't emphasize the point again that Shannon Burgess after this. So he kind of says Shannon Burgess dismisses it, but he doesn't explain how. He says Shannon Burgess had to make the evidence fit the theory. Okay. But he doesn't go into how it's the better or yada, yada. What he says is under the theory that they had, he goes straight to the original theory they had, and then he focuses on the time and then the movement, because the explanation of how Shannon Burgess changed the time takes a lot of time to explain. It wasn't an easy explanation, the clock synchronization, all the above. It's a good use of time because I don't think you can make the counterpoint to the same gravity with the same amount of time consumed.
There must have been panic, I'm guessing, in the room. What do we do now? The data shows John wasn't struck by the car. What do we do? Enter Shannon Burgess. Question. Can you believe him? Can you believe Mr. Burgess? He came up with a brand new story right in the middle of trial. You might ask yourself, would an expert actually say something he knows not to be true? Would an expert actually say something he knows is not supported by fact? Would an expert shade the truth?
They both
You don't have to look any further than Shannon Burgess's CV to answer that question. That was a shame.
Oh no.
Even with the pull and push and stretch and manipulation of the time data that Mr. Burgess came in here and told you about, it still shows that John O'Keefe was very much alive and walking around after they claim he was hit and incapacitated. Think about that. Matt DeSogra looked.
Okay, so Alan Jackson and Hank Brennan both take the gloves off when it comes to the experts. Holy crap, do they both swing? He literally just he took Shannon Burgess and any opportunity that Shannon Burgess had to possibly testify in another trial again, it might just be gone. It might have been gone during that cross, but if it wasn't gone during the cross, ooh, oh wow, that was brutal. That was brutal. Called him a liar.
Looked at Burgess's report and told you that in 30 out of 30 scenarios of the possible time skews that Shannon Burgess identified, he came in the middle of trial and identified all these other time skews that he called it. In every single scenario, John was alive and walking after they said he was hit. And that's a problem for them because there was no collision. Just look at Mr. Whiffen's data, Ian Whiffen. John O'Keefe took 31 steps at a steady rate, about 83 feet. And then think about this, in a westerly direction.
There you go.
That would be right toward the house.
There you go.
Remember, it's 78 feet to that garage door. That's not a coincidence.
I was worried he wasn't going to make that point. Now, Hank comes back and asks a really good question about that. And we'll wait till we get to that. But I was worried that he wasn't going to drive that home. And again, right now, I'm recalling this closing now based on having listened to it at 2 times speed while also doing work. So I'm going to forget some stuff. That was a good point to make. Very good point to make.
The Commonwealth's witnesses, or the Commonwealth's witness, Mr. Ian Whiffen himself conceded that he has reasonable doubts about the accuracy of John's location data. Remember that question and answer on cross-examination by Mr. Alessi. Do you have doubts? I do. Are those doubts reasonable? They are.
Yeah, that was bad. That was bad.
Remember,
for Ian Whiffen.
It's still the Commonwealth's burden. If their own cell phone expert has a reasonable doubt about John's location, so should you. John O'Keefe was inside, and the phone battery temperature further proves it. This is not speculation. This is science, and it's irrefutable. It tells us that he was not laying outside in the cold. He was inside somewhere a little bit warmer. Ian Whiffen told you that when the iPhone is exposed to freezing temperatures, think about these numbers. When the iPhone is exposed to freezing temperatures, it will drop from 81 to 21 degrees in 15 minutes. 15 minutes. That's a 60-degree drop in 15 minutes. Now look at John's phone. It was laying, according to the Commonwealth, it was laying directly on frozen ground. He arrived at 34 Fairview and his phone dropped only 20 degrees over the course of an hour. Then inexplicably, it stayed steady, never dropping below 50 degrees for the next 4.5 hours, never dropping below 50 degrees for the next 4.5 hours, basically through the entire night.
But it was under him.
He was not outside. He was someplace warmer, like a basement or a garage. Dr. LaPosada confirmed that John O'Keefe did not have hypothermia. No telltale signs, no telltale Wisniewski spots, no frostbite on any extremity. He did not die of hypothermia because he wasn't outside.
The hypothermia testimony from Dr. LaPosada, I think, was probably some of the best. You could view LaPosada when you got to the not hit by an arm, therefore I didn't care. I imagine there were some jurors who might be skeptical in one camp or the other who were kind of like, all right, you're going to say what you're going to say. But the hypothermia testimony of not having it, I found remarkably credible. And that was before you got to it. So I wanted to hear that. That was one that I wanted to hear in this closing.
Dr. Isaac Wolf, Dan Wolf, Elizabeth LaPosada, Judson Welsher, Andrew Rinchler, all agreed. Every expert agreed. This is how John O'Keefe died.
Was that a clock check? Or was that a check at the, was that a clock check or was that a slideshow check? That might have been a clock check.
Died. A rearward fall from a standing position.
It was a, there you go. Here you go. Nice. Effective use. Put the Commonwealth's own expert up there and do the drop test. Effective use. Way to go.
What could make you fall straight back like that? Let's just think about that for a second. What could make you fall from a standing position as Judd Welcher just showed us? Standing up, falling straight back. At a laceration.
Oh, that's where the cards came from. I like this closing better now. I didn't realize that's what I love the cards beforehand. I love the oh, we'll get to that. We're not there yet. Oh, now I have the good context. Now I get it. Wow. Okay.
To the right eye consistent with a fist or a punch. And you've got your answer. He certainly didn't sustain that wound on the back of his head by falling backwards onto a lawn. Dr. La Posada told you that the patterned injury on the back of John's head could only be produced by hitting a hard, ridged, or ledged surface, like a concrete stair or step. What's just through that garage door? Michael Proctor never stepped down in that garage to find out.
Great argument there. And it's making it in that way. Let me tell you why I like this defense theory better than any other one that they had been positing. What drove me nuts about the first trial. Maybe I should hang off on that. Let's hang off on that when we do summary. We'll hang off on that when we do summary. But the way he made that point right there, that to me was a complete change in, I guess, view of the argument than the first trial. This was a lot better because it didn't go and try to close that circle. He didn't embrace a burden. He didn't say, I'm going to prove to you that the damn garage was concrete floor. He didn't go and say, I'm proving to you that John was in there when this happened. What he said was, he raised those questions, and then he said, we won't know because asshole Proctor. And it's the question of, wouldn't we want to know? And isn't the fact that we don't know enough to get you to reasonable doubt? That's the implication. That's why I like that. What a better argument.
And look at the arm. Just look at John's arm. You don't need the top expert.
You know what? This right here, Becca, I think it's better that he didn't get the pictures in. That might be an interesting and controversial understanding, but I think it's better that Alan Jackson did not get the pictures into evidence of the garage, because it's a better question to say we would have known, we should have known had Michael Proctor done his damn job. And,
I don't know about that.
What?
I said, I don't know about that.
You wanted, I liked the way that it was phrased. I liked the question.
The thing is if the pictures were good, like if the pictures had a distinct step or ledge or something like that, that they could have said, a ledge just like this one that Proctor never investigated. Is that not better?
That's one step further. It does sound better, but I like the question the way it's phrased. He did a damn good job with what he had.
Oh, I mean, I'm not going to disagree with you on that he did a damn good job with what he had. It's just, if the Judge Canone had let them have the pictures, that would be even better. Right?
Yeah, I agree with you. How much further?
I mean,
he doesn't have
the
much
pictures
longer.
don't suck.
Let's see. We just got a little bit more to go because I want to get to the point that I think he is the most impactful part for me has not yet come up. And I think his pace was good. He did he made a good use of his full hour and 15. How far are we? Oh my God, we've gone at snail's pace. Holy crap. I gotta speed up.
Experts in the country, but you had them. You don't need the top medical minds on the planet on this issue, but you had them. These are dog.
All right, I gotta do 1.25 because I got to get through this close because I'm not going to get through Brennan's, and I need to actually watch Brennan's because I got to be fair in how I give critiquing.
Bites and scratches. These are animal wounds. Not one witness has been called in their trial. Not one. 8 weeks and counting. Not one witness who actually disputes that John O'Keefe's arm injuries are from a dog. The Commonwealth could not. That's
a Brennan fail and a Lolly win. I'm going to chalk that one up to Lolly doing better in the first trial than Brennan did in this one. Because at least Lolly could make that argument of I proved to you it wasn't. Brennan can't.
Find a single medical expert, a single medical witness who would come in here and tell you those are inconsistent with a dog bite or a scratch. And it's equally clear that there was no collision. Dr. La Posada told you in probably the clearest voice in the entire trial. You remember her testimony. He didn't get hit by a car, in her words. He just didn't get hit by a car. You remember the question that was posed by Mr. Brennan. Did you consider the speed of the vehicle? And she said, speed didn't matter because he didn't get hit by a car. She repeated it 3 times because it's true, not just because she says so, but because the medical evidence proves it. The medical science proves it. There was no collision. Dr. Rentschler told you unequivocally and just as firmly he didn't get hit by a car. The Commonwealth has not met their burden. They cannot meet their burden. The Commonwealth hasn't called a single medical professional, not one, to testify that John's wounds came from being hit by a car. Not Dr. Squidabello, not Dr.
In
Ezekiel.
fairness to the Commonwealth,
Contrast that
it's not their
with the
fault. They can't call a single medical professional because they're not willing to testify to bullshit. So
no, but it's also, this is also him. I am calling this closing argument battle firsthand observations versus science. It's testimonial evidence versus scientific evidence. That's what both, and Jackson picks his home base. Jackson's home base is science, data, and evidence. That's where he picks as his foundation. That's his rock that he wants his jurors to tie themselves to.
And it's almost never the rock the defense is picking.
I know.
Like, that's the weird thing on this, is that, like, it's so unusual that the defense is like, you know, you should trust the experts, because usually the defense is like, don't believe those lying experts.
Yeah.
It's not weird.
Brennan, however, ties his anchor to a rock that is the testimonial,
and then he throws it into the ocean.
Well, at the end, really at the end. But we have to watch it, because I think both of them know on the jury, they all know who they're talking to. Jackson knows who he's anchoring in at. He knows that there are people that have focused on the medical testimony, and he's like, hey, you jurors who have listened to the medical testimony, listen to me now and remember this phrase: not hit by a car. This was good. This only kind of shores up my belief that you're going to have a hung jury. That's where I am at the end of these two closing arguments.
I think Brennan actually intentionally plays towards a hung jury.
I think he does too. And we'll get there when we get there.
Caliber and the quality of the experts who came in here to tell you what is obvious to anyone with common sense. Those wounds on his right arm are from a dog. This was not an oversight by the Commonwealth. It's just that there is no one out there. No matter how big a check you write, there's not a medical expert who's going to disagree with that. The fact is, this is the central fact in the case. The only fact that matters is literally uncontested by every medical expert. Uncontested, undisputed. There is no evidence that John was hit by a car. None. How much more reasonable doubt could there be? This case should be over right now.
I mean,
Done.
Can't you see the clear car
Because there
bites
was
on John
no
O'Keefe's arm?
Collision.
No.
So given all that, how did Karen Reed end up sitting here? Why is she even here? Why is she in that chair? Why is she in this courtroom? There is a reason for that. And it's a reason they don't want to tell you, and it's a reality they don't want to admit to. The reason we're here is because the system, the very system that was meant to protect her, that was meant to protect all of us, that system has failed badly. So now let's discuss the facts that were and were not presented by the Commonwealth in this case. Over the next few minutes, I want to talk about the utter failure of the police to investigate this properly and to investigate this fully. And what you're going to see is that Michael Proctor, the lead investigator for the Commonwealth, did nothing to actually and properly investigate this case. Let's start with the house. That's the most logical place to start. I think you'd agree. Brian Albert's house, where John's body was discovered lifeless in the lawn. A police officer, is found dead on the front lawn, and no one secures this scene. No tape, no preservation of evidence, no crime scene log, no search warrants, no consent searches, no photographs of the house interior. They didn't treat the house as a crime scene, and shamefully, they didn't even treat the yard as a crime scene. The lame excuse offered by retired Lieutenant Gallagher: it was really cold and windy, and I didn't know if there was a crime that had been committed.
Coming up is one of my favorite parts of the closing. This part. This is one of my favorite. It's one of my. I'm going to pick 4 favorite parts. This one is probably one of the lower ranked favorite parts. This is one of my favorite parts.
At the point where you're picking 4, you're basically just saying the closing.
It was good. It was a good close.
It was.
You didn't know that a crime?
Possibly the best I've seen.
I don't know if I would call it the best.
Which close?
Here's
better
the thing.
that you.
I will say the best under the circumstances. An hour and 15 minutes was ridiculous because he left out things that I wish he would have focused on more.
No, but I mean, of the closings we've covered, which one do you think is better?
With the constraints in place that were in place, I don't know.
Even without them, like even just looking at all of them, were there any that you'd go, this one?
I don't know.
See?
This might be my favorite. I'm trying to think of when the other one was that we would have heard.
I mean, it's certainly better than anything we heard in the Paltrow case.
Yeah, Paltrow sucked. I hate both closings on that. I hated the closings on. We didn't get the closings on Baldwin. Murdoch. I hated closings in Murdoch. I hated both. I hated Creighton Waters. I hated.
The prosecutor did a good one in Hannah Gutierrez Reed. Bowles did not.
But I didn't like how she did good in Hannah Gutierrez.
It certainly can't compare. So I think the only one that's up there is
Kowalski. Kowalski was good.
I think this is better than Kowalski.
I agree. Mostly because I think Kowalski was disjointed and confusing. This was good. This was probably the most organized.
I think that this one actually did better than Kowalski and better than the Depp close. And I like both of those closes. So
I'm gonna get a lot of shit for this. I liked Rottenborn's rebuttal or Rottenborn's close on Depp.
I mean, Rottenborn was underrated in Depp because Rottenborn was actually a good lawyer with a shit case. Or
I thought Rottenborn had the better argument on Depp. I thought Rottenborn did probably better on the argument in Depp.
If they let Rottenborn argue Depp, I think he could have won it. But
if they kept
Rottenborn's argument,
if they had kept Andrew Heard off the stand, then they might have won. Let's face it.
I mean, you can't keep her off the stand. She's got to testify. But
no. But
I mean, if Rottenborn had been able to
mastery of the law in delivery of the close, I think Rottenborn did a damn good job.
If Rottenborn had been able to argue what he hints at, because he hints at a position that he can't actually argue, and what he hints at is she can't have actual malice because she's too crazy to have actual malice. And I think if they'd been able to put that to a jury, then they'd be great. But
my favorite was in the Depp trial was Rottenborn starts the closing argument. I'm going, shit, this is good. And then Elaine takes the torch and just uses the torch to light the courtroom on fire. And it's like it's just like Ben Rottenborn goes in. It's like we watching this closing argument going, holy shit, this is good. This is really good. And then it's like pass the torch to Elaine Bredehoff, and Bredehoff's like, this is a lovely torch. I would like to burn my entire case to the ground. Watch you do this.
That is actually something that happened repeatedly, where Rottenborn makes a good argument, and then Bredehoff comes in and is like, don't buy what my loser co-counsel said. You should, and I'm just like, what? Why are you trashing the better argument? And
no, but
yes, Rottenborn is the person who objected to his own question.
Yeah, he did.
I mean, I'm not saying that everything he did was great, but yeah.
No. But this closing by Jackson is, you're right, probably the best that I've heard of the cases that we've covered.
I mean, and it's not perfect. I think the starting of it, like the first third, is actually pretty weak in a lot of ways. And then it really finds itself.
My favorite part's yet to come.
It just becomes, I mean, the way I describe it is like, imagine a guy pushing a boulder, and it's not very interesting the first while, but then once that boulder hits the hill, you're going to take notice, and Jackson becomes the crushing boulder rolling down the hill that
you've also been here before. I had a discussion with one of my associates this week. Discussion with my associates this week, and he had the opportunity. By the way, I have to give massive kudos to this kid. My associate who passed the July bar of 2024, right? So passed the bar in October. Okay, passed the bar in October. Had his first trial, sitting first chair last week.
Okay.
in a landlord-tenant case, and he won.
Which side was he on?
He was on the landlord side.
Boo.
His tenant did not do good things. His tenant, bad person. But when he was talking to me about it, we were doing the postmortem, right?
I'm sorry. I'm just statutorily required to
I
be a
know,
dick
I
about
know you
that.
are. But when we're doing the postmortem, now here's the thing: the defendant, the individual defendant, did not bother to show up, but had an attorney present. So, do we give him the full win? I don't know. I'm still 50-50 on it. You still have to convince a judge. You still have to get the damages award. It's still good. It's good practice. He did a damn good job. But
I'm giving him the win.
I am too. I
I
absolutely.
was gonna say,
But we
even if
did-
you aren't.
Oh no, I gave him the win. But we're doing the post-mortem on it, and he's going through and he goes, I really hate my opening statement. I read it off of a piece of paper, and I was like, here's the thing, buddy. You're not there yet. Like you are not there yet. I know lawyers now that still read their opening statements off of paper
And I laugh at them when they've been doing it for long enough that
when they've been doing it for a long time. Now, with a case like this, 30 days of trial, you're reading it off. You're at least having very, very thorough notes. But looking at that young lawyer and saying, stop being critical of yourself. You will find your footing. You will find your place. You will find your intonation, tone, recollection, ability to speak off the cuff. You'll get there. We're not going to be critical of the fact that you're reading off a piece of paper.
And
so we can always improve.
The other thing about reading off a piece of paper is that there's a way to do it where, I mean, when you get better, I'll have pieces of paper, but I'll have notes as opposed to like things I'm reading because that works better for me. But yeah.
Now, something I did tell him was that for me, I have about 30 minutes of nerves in me in the beginning of every trial, where the first 30 minutes of trial, whether it's motions argument or whatever it is, I am talking 1.5 miles a minute and I can't seem to calm down. I can't find my flow. I'm scatterbrained and I'm just like, I am just speaking like crazy. So it helps me for the opening statement to have more detailed notes where I reference that until I get calmed down. Once I get calmed down, I ain't looking at my notepad. I'm going off of my gut, off of my instinct, off of everything I've got. The jitters. It's how you begin. And this is what I felt about Alan Jackson. In the beginning, he did great with the first part of it. It was scripted. Then he kind of felt a little bit shy. And then right about now in this closing argument is when he's picking up steam, when he's no longer going to his notes. He's more comfortable. He's eased into it.
That's fair.
So, and I think that you're right, this is the best part of his close because he's now in that righteous indignation part.
Had potentially been committed? You have a man laying dead in the yard, and here are the undisputed facts that those officers were confronted with. Black eyes. Obviously, black eyes are consistent with a fight. Bloody nose, also consistent with a fight. Bleeding from the face, consistent with a physical altercation. A cut over the right eye, consistent with a punch. No coat in the freezing cold, not dressed for outside, dressed for inside, and one shoe on. I wonder where the other shoe could be. I don't know, maybe in the house 30 feet away. And then you find a broken and shattered drinking glass next to him, the type of glass that you might find, I don't know, let me think about this, in a kitchen, in a house, 30 feet away.
That's what I'm talking about.
John's phone was tucked neatly under his back shoulder. Lieutenant Gallagher actually claimed he did not know it was a potential crime that needed investigating.
I mean, the other thing is that
Lieutenant Gallagher had a ring camera.
Every dead body that doesn't have an obvious cause of death is a potential crime.
Yeah.
Like, and even most of the ones that do have an obvious potential crime, like an obvious cause of death, right? Like you find somebody who is 87 and appears to have fallen down the stairs, and it's like, well, it could be that they fell down the stairs and died because a fall down the stairs could be extremely dangerous at that age. But it could also be that, like, their crappy grandkid who thinks they're in the will decided to show up and inherit a little bit earlier with a little bit of pushy push. So, you know,
I want to get through at least one next portion before I go to the very end of his close. What? It's taken me like an hour per 15 minutes, so we're gonna take a little. I can't go through another 45. We're gonna go through my favorite part, get to the end.
A Ring camera that was pointed at the exact direction where John O'Keefe would have been hit, and nobody bothered to secure it. Nobody bothered to secure it. Nobody even bothered to look at it. Of course, this was a potential crime scene. Of course it was. Let's not forget, this was Brian Albert's house, and that comes with privileges. Quote, is the homeowner going to catch any shit? Nope. He's a Boston cop too, end quote.
That was how he began his opening. I loved it.
That quote starts to make a little more sense now, doesn't it?
Perfect.
Michael Proctor wrote those words just hours after John's body was found. He sent this in a private chat, in a private text he never, ever believed would ever be revealed. He sent that text in a series of messages that now belong to you. You weren't given the opportunity to hear from Michael Proctor, but you can read his thoughts for yourself. And I urge you, go read them. They're in Exhibit 209, 209. In case you
he's like, write this down.
God, I love when this is. I will oftentimes create my closing arguments with the bait stamp numbers of my evidence, and I will pause, long awkward pause, wait till the judge is looking, and be like, that would be bait stamp 1247. 1247, about halfway down, and then I will pause and keep talking because it's like, Judge, did you write that down yet? And I wait long enough until the judge looks up and kind of goes, oh shit, I should write that down. Writes it down. It's like, I will now continue. 209. I wish you would have done that with the x-ray of like, these are available to you. Please go look at them. It was good though.
But here are the highlights. Proctor starts the conversation. Quote, all the powers that be, one answers ASAP. He's getting pressure, obviously. Get this done. His friend then asks what Proctor's probably thinking at the time. Quote, I assume you guys are out to make it cut and dry since it involves cops. Something stinks. And Proctor responds, yeah, to the something stinks. And then he goes on, but there will be some serious charges brought on the girl. Think about that. Hours into this investigation, there will be some serious charges brought on the girl. She's a whack job cunt. Yeah, she's a babe. Weird Fall River accent, though. No ass. No ass bitch. She's got a leaky balloon knot. Leaks poo. Zero chance she skates. She's fucked. And up to this point, Michael Proctor had done zero investigation. Nothing. Save talk to a grand total of 3 people, all of whom were named Albert or McCabe. That's it. And this was his mindset. This is the same lead investigator who sent the group chats that you heard about with Sergeant Butnick. Late night, sitting at his office, rifling through Karen's phone, bragging about looking for naked pictures of her.
Yeah.
That text wasn't sent to his buddies or his friends. That text was sent to his supervisors at the Massachusetts State Police, for God's sake. And what was their response? Sergeant Buchanan liked this conduct with a big old thumbs up.
Hey, now that's just a symbol of
He
acknowledgement.
acknowledged it.
We're both mocking it at the same time.
Which means that there has to be someone on the jury who just thought that in their head.
Oh, I mean, the jury is apparently fairly young. There is no way that the jury is like, yeah, that's an acknowledgement. I mean, it's just not like it's just not plausible.
It's like in harmony, acknowledged. God.
It's like if you claimed that you were not robbing the bank, you just happened to take your gun and ski mask for a little walk because they need some air. You know, it's Uh,
Yeah. Okay, he used them synonymously.
and be right back. I need some large
Yeah.
chunks.
Side note, anyone in the chat, that's the live chat right now, there's 4,490 of you here. Please, hit the like button. Very much appreciate it if you would. Take a quick second while Ian's off screen. Pause button, hit the like button, like the stream, subscribe to the channel, do the things. Please, 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 please. I know a lot of you don't do that. Guys, saying something cringe about like people who percentages. I do this once a week. I watch these trials while I'm practicing law full time, and I try my best to try and play catch up on this stuff. Please hit the like button. Second comment, Kate R, whose comment is pulled up on the stream right here. He uses them synonymously. Kate R has a YouTube channel. It's actually kind of funny. I don't know if Uptown Funk is still up, but there's a Uptown Funk edition on her channel. It's phenomenal, where it's a stitch of all the lawyers just dancing around and bobbing their heads to Uptown Funk. Great. Please do it. You'll see me in the unicorn hoodie. Also, Kate R is 100% responsible for all of the chapters that you see on each one of these videos. The videos that will sometimes go 5 and 6 hours long. Kate R is the one who does the timestamps and then posts them as a comment and has been kind enough to let me copy that into the description of the video. So please thank Kate R for all the work she does. Please do so. Nerdy Writer Kate, please do.
Ladies and gentlemen, a lead investigator every investigator is supposed to be objective, an objective fact finder, no bias, no agenda. Michael Proctor went far beyond just insulting Karen Reed. He dehumanized this woman. He betrayed her as a human being. He was fired for this blatant bias. If the Massachusetts State Police can't trust him, how can you trust him with this investigation and with your verdict? And with Karen Reed's life. The lead investigator in a murder trial was never called to testify. Think about that. That should stop you in your tracks. Wouldn't you want to hear from Michael Proctor? Wouldn't you want to hear from the lead investigator in the case? Don't you?
This part, I don't want to have the fight over the missing witness instruction. I know I'm going to lose that fight over the missing witness instruction, but I very much want to make that argument in front of the jury. And I am going to make that argument. I think the instruction would have hurt them. I think the instruction would have had less impact than him being able to make the argument without the instruction. I don't think the instruction would have helped. Because the instruction tells you how you're supposed to view the evidence, right? You may infer, you may take from this that there's a negative information that would have come to light. Cool. But when you tell that to me, you're almost minimizing it when it comes out of the lawyer's mouth. Let him argue it. Let him argue the hell out of it. And that is about to bring me to my next point.
Don't you have questions? The Commonwealth did not present their own lead investigator to the jury, the very jury who is charged with judging the investigation. Michael Proctor clearly is radioactive, and the Commonwealth stayed away from it. Michael Proctor is no longer a Massachusetts State Police officer. He wasn't transferred. He didn't go on sabbatical. He didn't retire. He didn't resign. He was fired. He was terminated for cause. The Massachusetts State Police investigated him, found him guilty of dishonorable conduct, not just for those text messages, folks, for sharing confidential information with witnesses and for bias. Not just any bias. Bias in this case. Fired. This is the man who touched every single piece of important evidence in this case. All the evidence that was brought before you in this trial went through his hands one way or another. The shirts, the shards. Remember that when Mr. Brennan gets up and gives his closing argument. The shirts, the shards, all in Michael Proctor's possession. Mr. Brennan and the Commonwealth, I think, have pinned their hopes on some microscopic pieces of, or close to microscopic pieces of plastic that were claimed to have been scraped from the hoodie several months after the fact. What he failed to ask every single witness is who had access to that shirt and who had access to those taillight fragments. And the answer is it was Michael Proctor. Not for days, not for weeks, for months on end, for months unaccounted for, before they were submitted to the crime lab, before they were ever scraped. Just go look at the chain of custody documents. You've got them. Why didn't Michael Proctor give those clothes to Maureen Hartnett with the crime lab when she was at Canton PD just days after the fact to receive those solo cups? Remember that? Just a few days later, she was there. She drove up. She did the driving to take the solo cups in the grocery bag, which has a ridiculous aspect to it in and of itself as well. Why not just Give her the shirts as well. Give her the taillight fragments if any were found at that point. Why hold on to them? What could possibly be a reason? Why wait until March to book those into evidence? Now let's talk about some of the other problems with the Commonwealth's evidence. As I indicated, there was no blood, no skin, no tissue, no DNA found on a single piece or shard of the taillight that the Commonwealth claims cut and sliced into John O'Keefe's arm. Where is that trace evidence? Where is that biological evidence? The DNA. Where is it? They got nothing. Not a single piece that the Commonwealth wants you to believe cut up John's arm. How is that possible? It's not possible. The only way it's possible is if those shards never touched his arm, because it was a dog.
The whisper was pretty good. I'm usually not one for the whisper, but the whisper was pretty effective right there. That was good.
Oh, and the one sample of DNA that they did find.
Ian. It was a dog.
What's that?
He doesn't have his ears in. Damn it.
I've got only one ear in.
He has one
Now I've
ear.
got 2 ears.
Ian, pay attention. It was
Pay attention. That's not my
Pay
song.
attention. It was a dog.
Paying attention is not my strong suit.
No, I was just saying the whisper move. The whisper move, you gotta know that you gotta know that you have the jury if you're gonna pull that stunt. A little bit. It was a good point.
Yeah, it'll piss them off otherwise.
Yeah, it was a good move.
Find, by the way, it was found on the outer smooth part of the housing, not any shard. It was the outer smooth part of the housing. Nothing that they claim actually came in contact with John O'Keefe. Number two, that sample had DNA of 2 other men.
I'm sorry. I pulled this up in hopes that I was just gonna pull it up so people could laugh at it in the chat, but then I saw the actual photo that is the avatar, and I can't unsee it anymore. I can't unsee that. I'm sorry. That is horrifying. Side Bob Ev. Brennan and Bev probably communicate with Signal. I did not intend for that pause moment. I apologize. I thought he was on a flow.
2 other unidentified males. It tells you that DNA had nothing to do with a car strike. That DNA would be expected to be, John's DNA would be expected to be all over that car. Inside, outside, he had access to that car for months and months and months. He was in and out of it all the time. Show me
Phrasing.
some blood, then we'll talk. They can't, and they won't because it doesn't exist. That SUV never hit John. The hair found on the bumper. The Commonwealth really stretched its own credibility on this one. That magic little hair on the SUV supposedly survived a 37-mile drive in 47-mile-an-hour winds. But that little magic hair just clung there, just hung on. That same hair that moved in between photos.
Alan, it knew it could. It knew it could. The little magic hair knew that it could hang on to that car.
It's the little hair that could.
It's the little hair that could. Don't disparage the hair. It knew that it could. Thomas the hair.
In the Sally Port. Remember that? There were 2 photos taken, and it was either the breath of the photographer or just the movement of walking by the hair. It literally moved between the 2 photographs. But that hair is supposed to have hung on in a 37-mile drive in a blizzard. Yeah. The only thing that hair proves is that the Commonwealth is embarrassingly grasping at straws. That hair has nothing to do with anything. But it doesn't stop there. There was another revelation at trial, a big one, a huge one, and it came from a very unlikely source. Christina Hand.
Oh, damn it. I thought it was this
quiet,
part.
reserved criminalist who told you something the Commonwealth likely did not want revealed because it's devastating to their case. Absolutely devastating. And it's this. The glass on the bumper didn't match the cocktail glass. None of it. Remember, February 11th, Michael Proctor, without any other person with him, no witness, no supervisor, no other person with him, claims to have found a single piece of glass at the scene. February 11th, single piece of glass, Michael Proctor. Keep that in mind. Interestingly, the glass on the bumper that didn't match the cocktail glass, one piece did match one other thing, the Proctor glass. Those 2 go together. The only 2 things that go together from that bumper are the Proctor glass. We know that there's no glass in the taillight. We know that nothing else was shattered on the vehicle. Therefore, that glass had to be placed there. Didn't come from a crash, didn't come from a cocktail glass. So how did it get sprinkled on the back of the bumper?
Oh no, I lost my place. No, I didn't need to do that.
To create a plan.
No.
The back of John's sweatshirt were from January. How it got cracked. Sister at 607 with
Hang on.
by Celebrate.
Rob, I'm judging.
Lawn. You can betcha.
Damn it. My one comment that I was going to make was the beautiful chalk / evidence that actually made it into evidence. It was an exhibit, numbered exhibit. That spreadsheet or the
It was very good.
demonstrative. I wish he would have pulled that up and then identified that exhibit like blank and pulled it up and said, just like with the 209, right? Just pause and then say exhibit like 175 or whatever the hell it was, to point to it and say, this is substantive evidence in the case, admitted by the Commonwealth, admitted by everybody involved. This is the glass. This is the plastic. Don't take my word for it. Go back and look at this. I wish that would have been there. I wish that could have been there.
But because this was Brian Albert's house, a Boston cop, nope. And because he was a fellow cop, an insider, they didn't even open the door.
There we go. It's 2 hours
No way.
later. Thank you.
It was found on the outer
awesome.
smooth part of the
No.
housing, not any shard. It was the outer smooth part of the housing. Nothing that they claim actually came in contact with John O'Keefe. Number two, that sample had DNA of two other men, two other unidentified males. That tells you that DNA had nothing to do
I'm
with
trying
the
not
car
to
strike.
be.
That DNA would be expected to be, John's DNA would be expected to be all over that car. Inside, outside, he had access to that car for months and months and months. He was in and out of it all the time. Show me some blood, then we'll talk.
Bad Ian. Bad Ian. Bad Ian. Bad. Naughty. You're thinking of fucking jokes, aren't you?
I
Not
am.
regular jokes. You're thinking of.
I'm thinking of exactly that kind of joke. Yes.
Yes, I know you are. I know you are. Bad Ian. Bad.
Talk. They can't, and they won't because it doesn't exist. That SUV never hit John. The hair found on the bumper. The Commonwealth really stretched its own credibility on this one. That magic little hair on the SUV. So, but that little magic, remember that? There were two photos taken, and it was either the breath of the photographer or just the movement of walking by the hair. It literally moved between the two photographs. But that hair is supposed to have hung on in a 37-mile drive in a blizzard. The only thing that hair proves that the Commonwealth is embarrassingly grasping at straws. That hair has nothing to do with anything. But it doesn't stop there. There was another revelation at trial, a big one, a huge one, and it came from a very unlikely source. Christina Hanley, quiet, reserved criminalist who told you something the Commonwealth likely did not want revealed because it's devastating to their case. Absolutely devastating. And it's this. The glass on the bumper didn't match the cocktail glass. None of it. Remember, February 11th, Michael Proctor, without any other person with him, no witness, no supervisor, no other person with him, claims to have found a single piece of glass at the scene. February 11th, single piece of glass, Michael Proctor. Keep that in mind. Interestingly, the glass on the bumper that didn't match the cocktail glass, one piece did match one other thing, the Proctor glass. Those two go together. The only two things that go together from that bumper are the Proctor glass. We know that there's no glass in the taillight. We know that nothing else was shattered on the vehicle. Therefore, that glass had to be placed there. Didn't come from a crash, didn't come from a cocktail glass. So how did it get sprinkled on the back of the bumper? Whose proverbial fingerprints are on that glass on the bumper? The only thing it matched was Michael Proctor. What about the Ford Edge?
I like
and that
that.
snowplow driver, Brian Loughlin?
Good.
He observed that Ford Edge parked outside Brian Albert's house at 3:30 a.m. That vehicle was moved directly in front of where John's body was found sometime between 2:30 and 3:30 in the morning. The only person connected to a car of that make and model, Brian Albert. Michael Proctor did nothing to investigate that point. Did nothing to investigate whose Ford Edge was parked in a spot specifically to block the line of sight in the exact position where John's body would be later found by Karen Reed. No one, not Michael Proctor or anybody else, checked it for evidence. No one even asked any questions about it.
Really? Y'all watching us?
I think that's super cool.
It's the Maya case. That was my first interaction with it. Was the Maya case? Was the lawyers watching the live streams before court? It's interesting. I think it's
That
interesting.
Ford Edge, Brian Albert's Ford Edge, completely ignored. Michael Proctor failed to interview obvious witnesses in this case. Why? Why didn't he want to speak to the snowplow driver, Brian Loughlin? Why did he falsely claim that no one plowed the roadway that morning? When police dash cam video, you saw the dash cam, it shows plows going back and forth all morning. Why did he wait so long, years even, to interview Heather Maxson and Ryan Nagel, individuals who were literally outside 34 Fairview at the exact same time John and Karen arrived at Brian Albert's house that night? Brian Loughran, had he been investigated or interviewed, would have told Michael Proctor that he drove past the lawn multiple times on January 29th, and there
Well,
was
that's why they didn't want to interview
no
him.
body on the lawn. He would have had a perfect view. Remember, the weatherman told you there was only enough snow at that time. I think he said the very charming phrase, only enough snow to track a cat. I think that was it.
Good use of the catchphrases of the trial. This is important. Remembering and this is why I think it's important for these lawyers to be watching the recaps of the trial streams, because chat picks up on things that become kind of trending enough to know to track a cat. Where if you recite that, like, you pick up on it because it feels natural to you. But lawyers in trial, we don't hear that stuff. We don't. We're not very good at hearing those little catchphrase words because we're so focused in the moment. But he's used several of them. And I think it's effective.
There was no body there. Heather Maxon and Ryan Nagel would have told him that they arrived at 34 Fairview shortly after Karen and John pulled up behind them, and they would have told Michael Proctor, at least Heather would have told Michael Proctor, that when she left 10 minutes later, she drove past the SUV and observed Karen Reed in the driver's side, dome light on, passenger seat empty.
Wait 1 second.
So where was John? Wasn't outside, wasn't sitting down, wasn't laying down. There's only one place he could be. We could all say it together if you could talk with me. He was in the house. But Michael Proctor did not want to have those answers. He did not want to have to disclose those answers. He didn't want the truth. The Commonwealth has presented a shred of evidence of when Karen Reed consumed her last drink that night. Think about that. It's critical information that the Commonwealth has to prove beyond a reasonable doubt and to a moral certainty. They have to prove when her last drink was that night. They have to prove it. We don't have to prove or disprove anything. Every single witness who was asked and who had an opportunity to observe Karen that night said the same thing. She wasn't drunk. She wasn't stumbling. She wasn't slurring her words. She was, in the words of Ms. Kolakithis, completely normal. Even Jennifer McCabe grudgingly had to admit that fact. It's on video. Instead, they used Yuri Buchanan to try to come into court and count sips of alcohol, which he admittedly got wrong. According to Ian Whiffen, the Commonwealth's own expert, the location data, using location data on John's phone, showed Karen driving lawfully. She was driving safely. She was under the speed limit. She was slowing and stopping at stop signs, slowing around corners. And Ryan Nagel corroborated that when he saw her make that left-hand turn onto Fairview. The Commonwealth has an incredibly high burden to prove that Karen was driving under the influence. They have failed to prove that beyond a reasonable doubt and to a moral certainty, because it depends on when she had her last drink. What happened after she got home and she was upset with John for not coming back out of the house? That would answer that question. As you well know, no one searched the house for signs of a struggle. Not that night, not the next day. I'm talking about 34 Fairview. Not ever, not once. Not with a warrant, not with consent. They never went into the basement, the stairwells. They didn't look at the walls. They didn't look in the garage. Nothing was ever examined. Nothing was checked for blood. Nothing was checked for DNA. They didn't look for a ledged or ridged surface. Zero. You'll remember how surprised Jennifer McCabe was to recall that there was a garage door even on the house, except this was her sister's house. She's been going to that house since she was 5. She's seen that house. She's been in and out of that house hundreds of times, maybe thousands of times. She's been going to that house her entire life, and yet she acted surprised when I asked her about it. Remember Jennifer McCabe's answer when I asked her whether there was a door at the garage. I was asking her about the front door, the side door, and the garage door, and her answer was, oh, actually there is a garage door right there. Investigators never opened that door. Let's change the scenario. What if it wasn't the house of a Boston cop? What if it wasn't the house of Brian Albert? We can be certain.
This I like. This I very much like. This is probably the other part of his closing argument that I was very much focused on, that I thought would resonate with the juries. Imagine that this was your lawn. Like, if this is your lawn, same set of facts, but it's your lawn.
Oh, Christ.
Is there-
They'd be in here.
That part.
They go through my books page by page in case I, had a confession tucked between, the pages somewhere or something like that.
They did not make this argument effectively last year. They might have touched on it, but they didn't make it effectively. This was effective. Imagine this is your lawn. what would have happened if there was a body in the front yard that had a drinking glass in their hand, that had a contusion on the back of their head, that had all these things? Like, just imagine that.
That investigators would have torn that house apart to get answers about why a fellow police officer was laying dead on the homeowner's lawn. You can betcha. But because this was Brian Albert's house, a Boston cop, nope. And because he was a fellow cop, an insider, they didn't even open the door. That is not justice, folks. That's just pure favoritism. Each of these facts is more than a question mark. They're failures of duty. They're blank spots on a map where justice is supposed to live. And every single one is a reason why you cannot convict Karen Read. Reasonable doubt abounds. If the Commonwealth failed to investigate every reasonable alternative, how dare they come in here and ask you for a verdict? They didn't investigate the case fully, and yet they're asking you to take the easy road and do their job for them. These facts do not represent reasonable doubt. Nothing does. Every one of these facts that you're seeing that we're talking about represents reasonable doubt. Every one. The police and the prosecution are in a position to take people's liberty. It's the most dire and consequential act a civilized government can take against one of its citizens.
Reach.
Their obligation is not just to try to get it right. They have to convince you to the highest degree of certainty known in human affairs. They have to do it all, every bit of it, beyond any and all reasonable doubt. And they have not done that here. And how about the homeowner himself? The host, the first responder, the Boston cop, Brian Albert, who was sparring and practice fighting with Brian Higgins just minutes before John O'Keefe appeared at his house, 34 Fairview. Brian Albert, who was watching Chloe that night, the German Shepherd. Brian Albert, whose phone and his wife's phone were never secured. Brian Albert, who never came out of the house. But that doesn't mean he wasn't awake. It doesn't mean that he wasn't on his phone. Think about this. Jennifer McCabe claimed that her sister and Brian Albert both slept through this complete chaos right outside their bedroom window. But Jennifer McCabe's phone records tell a different story, and they tell the truth. She spoke with him for the better part of a minute, 38 seconds to be detailed about it, at 5:07 a.m. And then she lied about that call. Remember that? What was the reason for that call at 5:07? Was it panic? Was it a warning? We know that conversation took place at the precise time Karen left her house to go search for John, 5:07. We could answer those questions if we just had access to their phones. Brian Albert, Brian Higgins, and Michael Proctor wasn't interested in their phones. Not only did he not secure their phones, he never even asked.
All right, I'm fast forwarding to where I want to get to before I go to Hank Brennan for a closer loop on this. He does well here. He does very well in the very middle. Like, he hits the peak right in the middle when he thinks the jury is most attentive, and then he starts to get into this stuff, which is a little more tedious, little bit more slow pace, until he starts ramping back up again. And he closes. He brings it out. He carries it through to the end. We'll watch the last, call it, 10 minutes or so.
It's a false memory.
Ah, yeah, no, with that one. I wanted to go back. Hang on. Who's this? Dever, I think he did okay dealing with that witness. You don't like it when you're the defense and they're testifying the way they are, but he does okay on closing.
The defense.
He argues it well.
Oh,
she
boy.
just looks awful because of how she acted. So,
but he does well on closing with it. He does.
oh, absolutely.
Then this rookie cop was called up to the police commissioner's office. The same commissioner that was the boss of Brian Albert.
I also like that he puts the blame not so much on Dever as he does on the superiors. Like, he kind of shifts it. So he kind of gives the jury permission not to hate her. Like, don't hate her. Hate the fact that she's just an agent of the power. But the false memory thing.
They have a meeting, a private meeting. And he says, wink, wink, nod, nod. We support you, Officer Dever. What else was said in that meeting? What else is reasonable to believe was said in that meeting? She claimed she couldn't remember. She claimed not to remember if he instructed her to do the right thing. But the commissioner of the Boston Police Department certainly said something to this rookie cop. And all of a sudden, that detailed, unambiguous, unequivocal statement to law enforcement became, what did she say? A false memory.
Alan, we know you didn't forget that phrase. We know you remembered that. That was playful, but well played.
Not I didn't say it. She admitted she said it. She admitted she detailed the entire story. She just said, it's a false memory. What? So she's called to the commissioner's office to make sure that she would do the right thing. That's why she was called. And now we know what that means. In her words, my entire career depends on what I say here on the stand. I'll quote that again. Quote, my entire career depends on what I say here on the stand. You bet it does. That's how it works. And that's how we got here. At the end of the day, you have to ask yourself, can you trust the Commonwealth's case? Can you trust their witnesses? Can you trust their evidence? And here are a few of the highlights. A video that was played in a courtroom and sold as accurate. Turns out it was completely inverted, flipped.
This part's getting, this is my favorite part. This is my favorite part of the close. Because this one isn't, don't trust, it's not about the witnesses, it's about who's presenting the case to you. This is attacking Hank Brennan directly. And I liked it. Generally speaking, we don't get the chance to attack counsel. Very rarely does this opportunity arise. But the second that you put into the mind of the fact finder, whether that fact finder is judge or jury, that the lawyer that is presenting information to them did so in a manipulative, false, or misleading way, you can very quickly change and tip scales.
Backward, completely false. The test that formed the basis of their entire theory of the case. Watch closely as Dr. Welcher stands as a surrogate.
Oh God, the leaning in. I can't unsee it after Rentschler.
And the thing is this is why you don't do this kind of bullshit. This is why you have a double-blinded test as opposed to this fakery. You see him lean. You see him do the hokey pokey. You see him
part of that. My God. Even if you are in the Karen Reed is guilty camp, how do you watch that and not cringe? I don't understand that part. I don't get it. I don't
Is that a righteous
understand.
test? Or is that a manipulation? Dr. Welcher tried to deceive and fool you by leaning into the car, manipulating the results of his own test. When the truth was revealed by Dr. Rentschler, the Commonwealth spent the next hour cross-examining it about how that test was meaningless. It actually didn't mean anything. Well, that's convenient now that we realize that it was a manipulated test, and it actually does mean nothing. It didn't represent the theory of the Commonwealth's case. That's what was suggested. That test does not represent the theory of the Commonwealth's case. Really? Then why was Dr. Welcher playing dress-up in John O'Keefe's clothes, or identical clothes to John O'Keefe, when he was holding a glass? Why was he holding the glass right behind the vehicle? And why was he standing with his right arm oriented to the right rear taillight if he wasn't trying to recreate the circumstance that is the Commonwealth's entire theory? The Commonwealth stood up here with a straight face and told you they weren't trying to suggest that that's how John was hit by the car. Of course they were trying to suggest that's their theory of the case. They only abandoned it 2 days ago when it was revealed by our experts that it's physically impossible. That silent witness, that science, that physics has become very pesky to the Commonwealth because there was no collision. Dr. Welcher also told you under oath that there were no x-rays taken of John's arm. He tried to deceive you into believing that John's arm might have been broken. I don't know. I didn't see any x-rays, so I can't tell you what the damage was inside the arm.
Wow, this is so good. This part is so good.
I mean, the thing is as a defense lawyer, I have never been given this much material to dunk on the other side with.
I was going to say, I don't know if it's that good or if it's just like you were just waiting to use this.
If I have this much material to dunk on them with, there's no way it goes to close. Like, they just don't give me this kind of stuff to play with because they'd be crazy to in my area. There's no, like, they would drop this.
how did they think that the x-rays weren't going to come up? How did the x-rays not come up? I saw people online speculating like, oh, the x-rays are probably fake. No, they're fucking real. And they're also actually real. They're real.
They're real and they're glorious.
And how that would feel if I was a juror, I'd be pissed as hell if you put on a whole case and it took the defense showing me x-rays. I'd be furious.
Mm-hmm.
That's why I think it was a good way to, this is a great time. And he does this in his lead up to what I think is one of his best points.
Really? The Commonwealth has had those x-rays in their possession for 3 years. And again, it took the defense to bring out the truth. The x-rays do not fit the Commonwealth's theory, so you weren't shown. And Dr. Welcher wasn't going to admit it. And my goodness.
I mean, this is the thing, is it makes Welcher look like a jackass. And there's no way to rehabilitate Welcher, so this is why you don't see Welcher come back for I mean, how do you get Welcher back to say like, hey, we need a
You don't. He's tanked. The second that Welcher takes the stand, any credibility Welcher has is completely destroyed by the x-rays.
You can't fix him.
You can't fix him. You can't repair that. The best you can do is to try to explain it away at closing, which is what Hank decides to do. Hank cuts the bleeding and tries to explain it away.
I mean, I guess you could fix him in like the veterinary sense, but
intimate that. But look at these x-rays. Look at these x-rays. Look at them. Look at the hand. The hand is the most shocking to me. You know how easy it is to break those bones in your hand? Ask me. I have 2 boxer's fractures in my right hand. Like, just it's this part where I don't trust the Commonwealth, and I have not trusted them. I gave them the benefit of the doubt. I did. I gave them the benefit of the doubt from the very beginning when Hank Brennan got jumped on board. I did 100%. And I was 100% in his camp. I was like, you're being full in disclosure. Good. You're giving access to the vehicle. Cool. We're going to pull a data dump. Cool. Love it. Phenomenal. Hey, these motions seem kind of weird. Why are we arguing these issues? Seems kind of extraneous. And then it's like, you're really arguing an issue that you yourself just did. And wait, did I just hear you argue about discovery responses and disputes when this hasn't been turned over? And wait, did that happen again? Little bits at a time, but certain inflection points in the trial ended up being really significant for me. The x-rays were pretty massive.
This might not be a data dump, but this case is certainly a different kind of dump.
Yeah. Like the one Amber Heard took on the bed.
Hey, now, according to Elaine, that was just the doggo.
What was it? They were they were Yorkies? Is that what the
Yeah.
Is that what it was?
Teacup
They were teacup
teacup poodles, was it?
teacup chihuahuas. They were teacup chihuahuas or something like that. They were tiny little dogs.
Yeah.
How did you know it was human feces? It's like in law school they tell you never ask the question that you don't know the answer to.
Yeah, that's like,
how do you know
it was bigger than the dog.
Yeah, they were that's it. They were 5-pound Yorkies. Yeah, that one. They were 5-pound Yorkies. Oh my God.
And it's like, well, we weighed it and it was 5 pounds, so it didn't come out of a 5-pound Yorkie.
Terrible. That's the same thing, not the same thing, but it kind of feels like this. It's you look at these x-rays and you're like, are you kidding me? Are you kidding me?
Goodness. Then we get to the sweatshirt.
This is my favorite part. Thank you for not making additional instructions thank you for allowing the attorneys the latitude to make this argument. And Hank Brennan, thank you for having the common sense to keep your ass in your seat and not object. Because this is my favorite part.
That was a moment. Mr. Brennan stood here in front of you and dramatically held up John's sweatshirt, not just to the witness, but to you, and asked Dr. Wolf about it multiple times. Specifically, while it was in that plexiglass, asked Dr. Wolf about the multiple holes in the back of the sweatshirt. He interrupted Dr. Wolf, and Dr. Wolf started to look at the sweatshirt and say, well, and he said, how about here? Here's a hole, here's a hole, here's a hole, here's a hole, dramatically tapping on that plexiglass.
God, I love it. Hang on. Oh, hang on. I'm gonna go real time. This is, I know people, I've said favorite parts. No. This is my favorite part. This right here is my favorite part. You know why it's my favorite part? Because it immediately precedes the wrap up of his closing argument. And you know what follows the second he stops talking? Hank Brennan starting to talk. So what do? Before the person who's about to attack your argument gets up, you attack their credibility in the best way that you can, which is on what they did in front of the jury. I understand that there are things that lawyers do that feel shady all the time. I get it 100%. We ask questions that might appear misleading or things that are implying a certain outcome that I understand. We do a lot of things that we are doing for the advantage of our client, but this, as highlighted by Alan Jackson, I think was remarkably effective. It
basically Brennan's going to get up and tell you a bunch of stuff, but he lied to you.
Uh-huh.
And the thing is if the jury is upset about him lying to them, then they, like, if they find that, if they don't believe what Brennan says, then Brennan cannot move the needle for them.
Oh, no, wait. Shady, yes. Lie, no. Uh-huh. No. We're going to take issue. It was a lie. It was a lie. That was a misrepresentation to the jury. It was an outright lie.
Yeah, I do not believe him for a second with the notion of, it was just an accidental mistake. I'm like, nope. Don't buy it.
Not in a million years do I for a second believe that someone who has lived with this case knows this evidence. And here's inadvertent my ass. When I try a case, the detail that I know about every aspect of my evidence, everything.
Well, and the thing is we've seen Brennan in action, and we can use lots of things to describe him, but one of the things we can't is sloppy, right? He's not, he's not somebody who, he's not somebody who is an idiot in that sense, right? He's not somebody who,
go ahead.
I've seen lawyers where they make mistakes and it's just because like the guy's showing up at like the second before trial with a binder with pages falling out of it, right? And they're like, okay, maybe you should figure out what you're doing here today, but Brennan's not that guy. Brennan he's super careful. He's super diligent. He's super everything. And I'm like, how are we?
I'll give you an example. Alessi makes an argument about something never coming up. The DNA never coming up. The DNA never came up. Brennan, in rebuttal, gets up and says, page 15, line 26, page 25, line 13. Immediately goes to those sites. I'm like, oh, no. You knew that was an issue. There is no way you didn't know exactly where to go. Like you knew damn well. And as well he should. Here's the thing. There's a very big difference between people gonna get mad. I don't really care. There's a very big difference between a defense lawyer poking holes in arguments by the prosecution and the prosecution engaging in tactics that a defense lawyer can and does engage in. Very, 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 very big difference. And if you don't understand that, my God, I hope that you never end up on the wrong side of a prosecution. It is different because the state has every power of the state to know every single factual detail, period. All of it. All the testing, all the resources, all the labs, all the investigative power, subpoena power, warrant seizure power, every single power you could ever imagine. They have all of it.
And on a case like this, their budget is just yes.
So
like, imagine you suddenly had a black card that just connects to like Elon Musk's bank account and the things you could spend with that. That's really what the Commonwealth is looking at here.
That's the point. That's the frustration. So yes, I liked this part.
There's a hole in the back of the sweatshirt.
Oh. Sorry, Shark. I didn't mean to call you out if that was unintentional. My bad. But I got to make the point, even if it wasn't to you. I got to make the point, period. You misunderstood. I meant a fight with the lawyers being shady, but not with them lying. No, Hank intentionally lied. He's a skid mark. On this point, I don't know about the skid mark part. On you, yeah, I will agree on the lied part.
And I will agree on the skid mark part because somebody has to.
I'm sorry. That was funny.
He interrupted Dr. Wolf. And Dr. Wolf started to look at the sweatshirt and say, and he said, how about here? Here's a hole. Here's a hole. Here's a hole. Here's a hole.
And Jackson's doing the same thing to Brennan's case. Here's a hole. Here's a hole. Here's a hole. Here's a hole.
By the way, that hurt. There is no way that Jackson is. I have hit those podiums before with my fist. There's no way that didn't hurt a little bit. And he's like, he wants the resonance and he's trying to make the point. But
he's like, I'm going to feel this later.
This hurts a lot. Like that hurt a lot. I wonder if he has more. God, I was going to say that. Do I say it? Is it okay to say it? I don't know if it's okay to say it.
I mean, you know the choice I'd make.
I wonder if the bruising will show up on his hand the next day, as opposed to what we saw with like John O'Keefe and being hit by the car.
I have gotten bruises getting out of bed.
I'm not trying to downplay this. I really am not. I'm not. I know that an individual, a man who had his life cut short that should not have been cut short. I know that he's not here with us. I hate the way the prosecution has tried this case. I hate the investigation that's gone into it. It is complete shit. We're never going to know the actual thing that took place because the investigation was complete shit. And the fact that the prosecution keeps flaunting this in our face is just a reminder of how corrupt that system was. They spend the money and fix it. Spend the money and fix it. All the money you took on the prosecution of this case, spend it on fixing the issue.
Mm-hmm. It was clear what the suggestion was, that the holes in the back of John's sweatshirt were from January 29th. That's the impression that was expected to be left with you. That's the impression that he wanted to leave with you. And that's false. The truth is, the Commonwealth created those holes. They aren't holes from road rash. They weren't made on January 29th. Those are cuttings from the Commonwealth's own crime lab, folks. That's what those holes are. And even with 3 prosecutors, all 3 of them, sitting right there in the room.
It was the call out of all 3. It was like all 3 of y'all. All of y'all saw this happen and none of y'all fixed it.
Yep. I mean,
wow.
He chose violence and...
Wow.
He chose violence. It's my favorite flavor too, so I'm here for it.
This is the burn. This is where it's like you're feeling your groove. It is just
at the time. It had to be the defense to correct that record, to bring out the truth. If we hadn't done that, what impression would you folks have been left with? That's more than negligence. That's dangerous. It's dangerous. I'm going to guess that Mr. Brennan's not going to say much about this.
Oh
about the
my
fraud that was
God.
attempted on you.
It was that might have gone. I'm surprised at Hank Brennan's. All of a sudden, Hank Brennan decides he wants to actually be cautious in his use of objections. Right.
The thing is that he can't object to this without looking worse.
I know.
They've got him in an
have.
absolute. They've got him in a headlock here, because if they say, "What will Brennan say about
Oh
this?"
my
and
God.
Brennan stands up and is like, "Objection." It's like, well, that's what he's going to say about it. Is he doesn't want you to hear it.
I know this is also why this is my favorite part, because he's boxed in. You have free reign here. You can do what every lawyer has wanted to do in every case since the end of time, beginning of time, is you can say everything on your mind, all of it. You can go after it. And there is nothing that they can do, right or wrong. And the thing is, Hank Brennan, I expected him to stand up. I got through this and I watched this 3 times today. And I watched this part 3 times today. And I got through this and I was shocked that Hank Brennan did not stand up, because given his track record during the trial, the man doesn't have an understanding of when to object or not object. He objects at the worst possible times. So I'm sitting here going, he's going to object, isn't he? He's going to object. He's going to object.
Also, should I have a margarita or a Long Island iced tea?
Margarita first, Long Island next.
All right. Also, Greg has an excellent point here. Hank's not the skid mark. He's what makes the skid mark. He is indeed the skid marker.
This what I mean, we're going to replay this little section here, because Alan Jackson finally got to say in open court in front of the jury what he's kind of wanted to say the whole trial.
Negligence. That's dangerous. It's dangerous. I'm going to guess that Mr. Brennan's not going to say much about this. About the fraud that was attempted on you.
God.
And if he doesn't, that speaks louder than any concocted excuse that the Commonwealth might come up with.
God.
It's shameful. It's shameful.
God.
We are after the truth in this courtroom. You're entitled to it. Demand it.
Oh, it hurts. Oh, it hurts.
Why would
I have gotten to call out opposing counsel like once in my whole 15-year career. I've gotten to call out opposing counsel for possibly misleading the judge one time. I've never gotten to do it like that.
I've had a couple, but they weren't this delicious. My favorite of them was one where the lawyer, they read paragraphs like 1 and 3 of a decision, and they skipped 2, and paragraph 2 completely changes the meaning. And I'm like, you've just heard this, and they had to backpedal really fast, because the judge was like, why would you read an incomplete quote? Why would you skip that? And they're like,
So mine was a lawyer that had written their closing argument, and I had gotten an entire witness stricken because they did not have the credentials.
Delightful.
I've told you this story before.
Yes,
I got an entire witness stricken because they were so confident going to trial they were going to have this witness testify, and I was like, I will admit them for this expert qualification, and then they start to go down this scope, and I'm like, it's not in their expertise, outside scope. And the judge goes off the bench for like an hour, researches, comes back and says she can't go into that. So I get the entire witness stricken, and in closing argument, this lawyer starts to read off of her closing statement that she had prepared clearly, and starts arguing about what the doctor who I had stricken testified to. And
this is why you don't write your close before the end of trial, folks.
I got to get up and make the comment that was basically saying, I don't believe that this lawyer intentionally did this. Because if I did believe that, that would be an intentional misrepresentation to the court. The look on the face of this other lawyer is probably one of the very few times I've ever and that wasn't even going for the jugular. That was,
you were being very nice.
Being nice.
Like that, you did them a kindness.
Uh-huh. That's like the one time in 15 years of trials that I've been able to do that on a closing to that extent. I have never in my career come close to anything that Alan Jackson is doing right here. This is, it is character annihilation of the person who's about to get up and try to convince you to listen to their version of the facts. This is the most impactful and important part of his closing argument. And I'm not even like, it's not even a close second to anything else. Maybe the x-rays might be there too. X-rays and this part. Those are my two big points of his closing.
It's the level of violence he's getting to do. And the thing is that most of the time, if you had somebody else who was in this position, they would drop the case.
Oh, side note. People make the comment about Judge Bev. There is a point in here where Jackson, right about here, has hit a line where I actually wouldn't fault the judge for interjecting.
Hold on,
making comments about counsel.
I need to grab something. 1 second. I'll be back. I'll be right
There's
back. Don't get to it.
Oh no, he's getting something. Oh, he's going to get something. We're going to rewind a bit. Because like I said, I've never been able to do this. Let me catch up on a few of these super chats while he is stepped away. Edward Kirkpatrick, and remember, of the only two, AJ is leaving this trial with a reprimand from the judge of intentional lack of candor to the tribunal. Yeah, but did that get called out for the jury? This has got to feel sweet. Music to my soul, I suspect Judge Bev said that instead of adding the hoodie instruction, she'd give AJ wide latitude to address it. I think that's why Hank Brennan didn't object. I don't know. I've never seen this, ever. AG, to be honest, this case has me excited to become a court reporter. The record is sacred, and it will be an honor to become the guardian of that record. I know most trials aren't this exciting. They're all this important. AG, I agree. We actually have a court reporter issue right now that we're facing here in Virginia, where we're losing court reporters, like left, right, and center. And the record is sacred. Like getting that transcription is sacred to maintaining and preserving trials. Okay, you're back.
I am back. I needed to get some fire.
Okay. Fire. We're ready to hear the rest of the fire. Like I said,
yes.
I can
actually get into this.
I've never had a case where I could do this. And I don't know how you recover from this.
With the comment,
you move into the woods and you just feed
know.
yourself to a bear.
This closing it was good. It was good. And then it got to this point and I said, oh shit, is he going there? Because what I was saying before you were about to get off stream, there is a place right here where I think the judge would have been well within her rights to cut Alan Jackson off and stop him sua sponte without objection. I think the judge could have done that from the bench based on some of what Jackson says here. And it would have been appropriate.
courtroom. You're entitled to it. Demand it. Why would the Commonwealth stoop to a stunt like that? It's desperation. They know what you now know, what their experts know. There was no collision. So now we've reached the final moments of the trial, and you've seen the facts and you've seen the evidence, and we've just talked about dozens and
Oh no, hang on. I fast forward past it. I want to go back.
about the fraud that was attempted on you.
This one, the fraud that was attempted on you. The fraud that was attempted on you.
If I was
Right
a judge,
there.
I would have said, Mr. Jackson, too far.
That right there, I think Judge Bev could have very easily, and I'm shocked didn't. Honestly, I'm surprised it didn't cut him off or admonish the jury. Like that you are supposed to listen to the evidence, not the inflection of counsel or the attacks on counsel. You are not supposed to attack counsel ever. And what Alan Jackson does here is accuse the other attorney of committing a fraud on the court, which is like the biggest accusation one can possibly make. There is no accusation as to another attorney that is as resoundingly loud as the fraud on the court.
As an example of how bad this is, I had a lawyer take a sort of run at me where he basically suggested that I'd lied to the court, and I was getting up, and the judge was like, "Mr. Runkle, sit down. I've got this."
Yeah,
and then proceeded to tear the other lawyer, like a new asshole collection. It was actually pretty epic, and it not a good scene for that lawyer.
This is perhaps, for all the criticisms that I have had of this judge, let this go. No admonishment, no clarification, no nothing. And
she was just like, you get to live with that, Brennan.
This was Alan Jackson going for the throat. No, this was Alan Jackson actually hitting a body at 25 miles an hour reverse with the Lexus SUV.
Did he borrow it from Aperture?
No, but Hank Brennan did his best impression of Rescue Randy. Like this was murder by closing argument.
That's not fair. Rescue Randy is useful.
That's dangerous. It's dangerous. I'm going to guess that Mr. Brennan's not going to say much about this, about the fraud that was attempted on you.
Just, oh my God. Every time I hear it, I can't believe he gets the words out without an objection.
Well, the thing is Brennan can't. He's been painted into a corner where if he objects, he's going to look like a dick.
God.
And he doesn't have the ability to do it.
Do comments like that work on the jurors?
Yes.
Yes. Yes. That is literally a lawyer looking up and say, he just called you an idiot and lied to your face. And the thing is, he makes the point with a very objective false statement. Like, it's not even close. Even the judge had to come out and clarify it. That makes an impact.
It's bad.
This is worse than an admonishment. This is worse than admonishment. This is worse than any instruction. This is worse than anything else. This is absolutely annihilation.
And if he doesn't, that speaks louder than any concocted excuse that the Commonwealth might come up with.
And that was objectionable as hell too. The
thing is Jackson knows he's got Brennan painted into a corner here. Brennan's got no choice but to sit there and eat it. I mean, Jackson is basically just like, I have served you up the world's shittiest shit sandwich, and
you want a bite?
You get to go find all the peanuts. There might be some corn.
You're right. There's no out. There's no way this, you know what? What's funny about this? This might have been the first line that out. You know what? I'm going to go on record with this. I bet I'll put $10 on this. I'll put $10. This was the first line that Alan Jackson wrote of his closing argument.
I don't know, maybe, but I would certainly bet $10 that Jackson is not going to be on Brennan's Christmas card list.
Oh, I'll put that on money. I'll put money on this. This after that happened in court, I'll put good money on this. This was probably the first thing that Jackson wrote down, and he probably wrote down "end here." You've been there in court where you've heard that thing and you're like writing it down. You're going, this.
Yep.
I'll put money on it.
It's shameful. It's shameful. We are after the truth in this courtroom. You're entitled to it. Demand it.
And I mean, here's the other thing.
Yep.
Jackson's not wrong is the problem.
Stoop to a stunt like that.
No.
And because he's not wrong, the remedy, like, the sad thing is that the people doing a bunch of bullshit here will never see punishment. Jackson is actually more likely to get punished over this trial because of Canone's, thing about I have, grave concerns. I feel like you intentionally misled me and so forth. They're actually more like he's more likely to see some sort of consequences there. Meanwhile, Brennan and Canone and, Lally and, Proctor got fired. That's something, I guess.
That's nothing. And Brennan downplays that so much. Let's see. We've got like a minute left. Yeah. Okay. Minute left in Brennan.
They know what you now know, what their experts know. There was no collision. So now we've reached the final moments of the trial, and you've seen the facts and you've seen the evidence, and we've just talked about dozens and dozens and dozens of facts that are reasonable doubt. Each one of them are reasonable doubts. These facts, these note cards that you're looking at piled high.
The note cards, this one.
One on top of another, literally stacks and stacks of them covering the table.
Yeah, it said stacks, which I have to highlight. In fact, it said stacks because
there's some history on that.
Channel history, Wood Daddy Stacks. Look it up. I'm not going to say it now.
As you mentally sift through those cards, realize that every one of them is a massive hole in the Commonwealth's case. Every single one of them.
That also connects to the Wood Daddy Stacks.
In the Commonwealth's case.
I hate you so much right now. I hate you so much. So much anger going through this live stream.
If you're holding mentally even one of those cards, you're holding reasonable doubt, folks. You're holding a not guilty verdict. Reasonable doubt is not a sliding scale. It's a wall. If the Commonwealth cannot get over every one of these dozens of walls, you have to acquit Karen Read. The truth is, Karen Read is not guilty. Not because of technicalities, but because the facts, the law, the science, the physics, the data, they all say so. They demand it. The Commonwealth does not have a theory about how John was hit by the car. They haven't even shown you that it's possible that he was hit by a car. And the reason they haven't is because it's not possible that he was hit by a car. There was no collision. Your job is not to do their job, their burden entirely. It's theirs. They have to prove this case and their theory beyond all reasonable doubt and to a moral certainty. And not only do they not have a theory, they can't prove one that doesn't exist. All you need to know is that the Commonwealth failed. They failed to provide you with a truthful representation. They failed to prove the essence of their case, that John was even hit by a car to begin with. They failed to prove any intent on the part of Karen Reed because she has none. They failed to investigate the actual suspects in this case. They failed to present the lead investigator to you. They failed to justify the perjured testimony that you heard discussed in this case. They failed to hold accountable an officer who came in here and lied to you and claimed false memories so she could do the right thing to cover for a fellow cop or cops. They failed to maintain a fair and unbiased and honest investigation. They failed to present you with the truth. And this is what you get. An investigation that's riddled with errors and omissions and a rush to judgment and conflicted and corrupted from the start. Every part of it. That is the literal definition of reasonable doubt. How can they ask you to be morally certain based on this evidence? It's a tragedy. When the government fails so completely, so catastrophically, when there are dozens and dozens of points of reasonable doubt on the table, your duty, your oath is clear. Your sworn obligation under the law is to acquit Karen Reed, not just because you can, because you must. Justice demands it. Do not let the Commonwealth get away with this. Don't let them get away with this. Do not endorse and sanction an investigation that is broken and corrupted top to bottom. But just as importantly, do not let Michael Proctor get away with it. And make no mistake about it, folks. If you convict Karen Reed of anything, if you convict her of anything, science, the physics, the data, they lose. But tragically, Michael Proctor wins. Remember his texts. Something stinks. Yeah, but serious charges will be brought on the girl. She's fucked. Could you ever say to yourself, this is justice? The fact is there was no collision. A car did not kill John O'Keefe. So I ask you, let your voice be heard, not in whispers, but in truth. Let the community feel through your verdict that justice cannot be.
That's objectionable as hell.
Yep.
That's objectionable as hell. Wow.
I'm going to allow it.
It's okay. Why is that
Again,
objectionable? You cannot argue. You cannot argue larger ramifications. You're not allowed to do that in any respect.
and that goes for both sides.
It does.
Brennan is not, for instance, allowed to argue like other people will think that they can get away with things like this, you know, that kind of thing.
Correct.
It's just not allowed.
That's objectionable.
Be bent, and that it will not be buried. Find Karen Reed not guilty, not guilty, not guilty. Thank you.
All right. I was at an 8.8. Weighted. I'm going to weight that, and I'm going to basically say the hour and 15 minutes is a constraint that I'm going to bump into a 9.2. That's where I was watching it the second time. I'm at a 9.6. What's that? Hot?
The lid, it says caution hot.
Caution
and
hot.
These are pickled habaneros that I bought like 3 years ago and then forgot about. And they are kicking my butt.
We went 84 minutes. Oh, damn. Okay, Canoni. There you go, Canoni. Latitude, baby. All right, so maybe I don't weight him all the way up to a 9.2. Maybe I weight him to a 9, then a 9.4. I'm going to give him a 9.4. 9.4.
I'm going to round to a nice even 9-5.
9-5. It's fair. It's fair. Damn good close. Damn good close. I don't know. And with an hour and 25 minutes based on that, like that's a whole lot of facts to condense into one argument. I've got to catch up on super chats. Give me 1 second. Let me swoop and then let's get to these.
No deal.
Because there's a lot I've got to catch up on real quick. And I know you probably did the same. Dr. Wrench's ham sandwich. God, all these. So glad Hank established that JOK was not a bison. At the beginning, I liked that he had a running list behind him. He did. Big Dog 5758. Thank you for gifting memberships. Light Queen, thank you for gifting memberships. Shay B coming in very generously. We have arrived in the chat. Runkle is live a third time today. Shay B also following that with 50 gifted memberships. Thank you, Shay B, for the continued contribution to my channel, Ian's, and various others. It is very much appreciated.
Shay B also might send. I don't know if you're aware of the wonderful evil plan I have.
Which one? Is it alphabetical, numerical, chronological, or reverse chronological?
So, what is it? You know that we just got an outhouse.
Yes.
Me and Mrs. Runkle.
I'm aware.
So, what's that?
I'm aware. I know. Outhouse.
So, what I'm planning on doing is like insulating the walls a bit and putting in like some plywood just to give it an interior surface. And then what I'm planning on doing is putting up some art.
Oh, yep. I heard about this. I love it. I love
and I'm not telling Mrs. Runkle what the
I
art
love
is
it.
before.
The creepy art. I love it. It's phenomenal. It's one of my favorite things in the world. Creepy art is going up on the inside of the outhouse. Very creepy art. Disturbingly creepy art. Yes.
And it'll just be at some point, Mrs. Runkle's going to go in and, have a seat and go, what the hell?
Ian, I need you to do me a favor. I need to take a break. Can you pull up a couple chats on your end?
Absolutely. Bijou Girl says, I can't get past taillights on top of the snow. Well, I don't think that that's the thing you should get past because that is messed up. Finally freed. It wouldn't matter which side presented the evidence. Due diligence will always be more credible than attempts at confusion or combative witnesses. I feel like the jury, I hope they're going to be pretty smart about this and they're going to look at it and go, yeah, this is, the Commonwealth's case was a big problem. Josh H. I won't be surprised if this case ends with a guilty on an OUI on the lesser included charge in count 2. Split the baby. We convicted her of something. And that may have actually been the strategy, is to give them something to convict her on that isn't going to send her to jail for the rest of her life, in order to prevent another mistrial, prevent her from being on this for the rest of time.
I also thought about this for a second. I think it also gave Jackson the ability to say not guilty, not guilty, not guilty.
But he already had 3 counts.
Did he already have 3 counts?
Yeah.
Well,
there's already the leaving the scene, right? So
can leave the impression of overreach on behalf of the Commonwealth, like they're pushing too hard.
Yeah.
But it's seeking a compromise verdict. It's playing the numbers. Right?
Yeah, I mean, it is a risk. Oh,
Joe Jones, 100%. I would guess
yeah.
One of the first questions of potential jurors would be, do you have any law enforcement in your family due to all the cops in this? It would, but it wouldn't necessarily exclude them. Phoenix, love your commentary on this trial. Thank you. I've been doing minimal. Ian's been doing a lot more. Please go check out his recaps. They've been phenomenal. AG, happy Friday, Rob. Getting over strep. So I lost most of my center practice this week. Been working on painting up some 3D printed miniatures for a campaign. Oh, that's fun.
That is cool.
Making things does make me feel better. See, told you. Ode's martyr, missed opportunity 250 years ago. This state led the fight against government injustice. You can show that you still do.
Now it leads the fight for government injustice. It's similar.
But opposite. Shy, my question is, how did the x-rays just come up? Do you think the Commonwealth will try to bury them, hoping the defense wouldn't find them? It just seems sus, but one of a multitude of shady scenarios by the Commonwealth. I don't understand I don't know that we're ever going to get an explanation for this. The gag order, hopefully, with the end of this trial, we'll actually find out where they were, why it took so long to come out. But this has been one of my questions forever too, because from my understanding, based on how it came out in testimony, this was part of the original ME file. Was the ME did these x-rays, which, if true, is pretty shocking. Mrs. Squirrel, thank you for the gifted memberships. Sarah, if these jurors know about the previous mistrial, do they get to know the reason why? No, they do not. Sandy,
they don't even get to know that the previous thing was a mistrial. They've just been told a prior hearing, right?
Yeah.
At a prior proceeding.
No, they heard earlier trial too. They heard earlier trial.
Yeah, they don't get any details as to what that's about. So
yeah. Sandy, thank you for gifted memberships. Why you're gifting memberships? You're a mod. Don't gift memberships. Stop. I mean, grow the community. I don't discourage that, but also you're a mod. You do enough. Josh H. I got in a fight with an ex at a concert in Vegas. I left the concert and was preparing to go to the airport to fly home. People in relationships argue. Yes, that's fair. It doesn't mean they kill each other. Randy Rose, the butt dial trial part 2. After 2 gut-wrenching trials, my heart truly just hurts. John deserved better, and so does Karen. If this doesn't end in acquittal, I'm not sure my faith in our justice system will be restorable. Don't put all of your eggs in one basket. Work to make the basket better. Zebra Z, imagine Proctor sitting at home watching this. Well, that's what he's doing. Odin's martyr. If I'm a juror, the clips, especially the way they were cut, would make me disregard. I've seen out of context clips before. Some will, some won't. Some will latch on. Josh H. The fun part about LawTube is it's easy to Monday morning quarterback, nitpick every word, etc. In reality, it only matters what the jury thinks. Josh H. was very mad, as were several people, when I was critical of Hank's beginning of his closing argument.
Of Jackson's?
Of Jackson, yeah. Yeah. People were mad that I was being critical. They did not like that. It took them a while to get going. Guys, you can be critical. That's how it works. Abby loves sunshine. Do all closings have a time limit? Most do. Usually it's not an hour and a half. Mashed potato goblin. Did I miss a curative instruction about the hoodie? Judge said she'd put it in the jury instructions. I don't think she gave the instruction. Josh H. My legal mind says the defense got the x-rays from ARCA, who got them from the feds. I don't know. They got them in discovery. I see a Brady issue here. If it was a Brady issue, it would have been brought up before. Charlie Lynn. Yes, La Posada said she got them 2 weeks ago, the x-rays, but that's La Posada. That doesn't mean that Sorty Bello didn't have them. Luke Halsey, 55. Do you think the defense asked for OUI to give the jury an out? Yes, that was Ian's posit as well. I think as well that could be easily overturned on appeal. I don't think it's easily overturned on appeal due to the blood test timing. I think that if it was OUI, that sticks. Baby Gator is currently pursuing a ham sandwich for $400K. That better be some damn good blue paint. It was expensive blue paint. Well, Allegan News. The juniors are young, so make your argument to them. Don't confuse them with the accurate definitions. Gen Z doesn't care about word meanings. People were mad about my definition of confirmation bias as well. It's actually conformity bias, but they did both. Gethralkin, Brennan would like to pit science versus common sense without the common sense. We're going to get to him in a second. Kitty Jennings, thank you. Carrie, was it the first trial Jen said she woke up the Alberts? It was. Kitty Jennings, thanks for becoming a member. Kitty Jennings again. Rob, I know you're not a criminal defense attorney, but how do you think AG/Ianetti go about preparing Karen for a potentially hopeful 0-chance guilty verdict? You've had that discussion a long time ago. And you have it again the day before you give closing arguments. You have that discussion about composure, maintaining composure, all of the above. It's not easy. The client knows it's coming because you've had the discussion before. I've always wondered how that conversation goes. It's not easy. But what I always tell clients is, do you want me to tell you what's really about to happen, or do you want me to tell you reality? You want me to, you don't pay me to treat you with kid gloves. You pay me for my advice and counsel. Ashley English, my cousin just argued her first case in front of the Idaho Supreme Court.
Wow.
She did amazing, but loved watching her answer questions without notes. Yeah, that's fun. I like that. When you get the appellate arguments and it's back and forth justices, that's awesome. That's really cool. Ashley, can you send me, do they have that on video? Can you send me the link? I would love to see that. I love watching appellate advocacy. It's a lot of fun. Especially knowing it's her first, that'd be really cool to see. Lissy Quinn. Hey, Ian Runkle, look up the Bachelor's Sean Lowe's dog attack photos. It's nearly identical to JOK. KR didn't do it. Sadly, JOK will never get justice. A lot of people feel that way. Equality. Can we please skip Brennan's closing? I can't. I have to do some of it. AJ gave me logasm. Brennan gave me, I don't know, aneurysm. Aneurysm. Red.
Lost DD. I don't know.
Oh, God. Michael Mlodzinski, the way Jackson's voice turned when he said, the Massachusetts State Police, for God's sake, healed my soul. It was good. Like Queen, I told you this thumbs up doesn't mean what you think it does. You acknowledged it. Jen K, feel like it's been ages. AJ's close was epic. It was great. Baby Steps 22, happy 2-year anniversary as a member. Been here since the beginning. Glad to have you, Baby Steps 22. Thanks for the great Friday Eves. Waiting patiently for a shop stream. Thanks, Rob. Patiently waiting. I will get to that. I actually got several packages sent in the mail today that have been waiting for a long time. I brought them to the office. We've brought in extra help in the house to help things. I'm fixing a lot of things that needed to be fixed. K-Rab,
I gotta
Red
get a
Solo
bunch
Cups.
of stuff sent off because I'm behind on that.
I'm finally getting to a place where I'm playing catch up, and I'm playing catch up as fast as I can because I owe a lot of people a lot of things, and I've fallen short on that, and I'm doing my best to play catch up. K-Rab, Red Solo Cups to a jury, which by all reports grew up on CSI. Yeah, it's gonna be rough. Catlin, shoot, I'm super late today. Just popping in to say 1 week until Special Olympics Summer Games. Good luck. Good luck to your athletes. This time next week, I'll be sharing the medal count for a day. Can't wait to share with y'all. Love you guys. Can't wait to hear about how your athletes did, and best of luck to you and all of them. Nancy 70, Kate R, thanks so much for your time stamping. Tremendously helpful. Donnie B, best post I've seen. When the fire trucks went past courthouse, how amazing would it have been if AJ turned to Brian Albert and said, did you hear that? Oh, objection. Pat in Virginia, thank you. Marmar, Ian, I just met Basset Hound named Rumpel. I got to tell you the owners, I got to tell the owners about you and your channel. Look at that.
Oh, awesome.
That's cool. Miss Erica Claus, CW opening, science data, close. Trust me, bro. Yeah, kind of. It really did. Fiona W, thank you for the gift of memberships. Dina Kawaji, thank you for the gift of memberships. Gingy Probs, thanks for becoming a member. Very much appreciated. The Squid, thank you. The X-rays never came in before because what they show was never contested until Welcher. The X-rays would have been relevant. I don't understand where they were. I don't get it. They would have been relevant. Music to my soul. So if you had all these things to dunk on the Commonwealth with, would you add an OUI lesser included charge? Your client will almost certainly be convicted of. I don't know. I'm not the lawyers. I don't know the strategy. I know that I had talked about simplifying the defense case for months and how I didn't like how they led with the whole this conspiracy thing. I wanted them to simplify it to the reasonable doubt case. Put the burden where it rests, where it lies, put it where it should be. They did that this go round, and I love what they did. Gigi Prob, something I've been thinking about lately. The after party is odd. I've never been to an after party that lasted less than an hour. Most everyone said they left by 1:30. Not the most important, but scratching my chin. Yeah. Miranda Bowman, I think Canoni's rulings could have an immaterial effect on the outcome of the trial. All rulings do. If so, which rulings do you think were the most impactful? Prohibiting certain witnesses from testifying to certain things. Like La Posada the dog, various things. It's very difficult to do that, at least at this stage. I don't really know. The ARCA, let me put it this way. If Brennan had put on a rebuttal case, the ARCA rulings would have been really important. Honestly, the ARCA rulings were important because it let Brennan kind of pregame his cross. So I don't know, 20th Century Fox, but they lied and she knew they did lie. Tanner H, the taillight pieces in lawn equals guilty, in my opinion. I get no proven collision. That's like finding an egg and saying, well, you haven't proven a chicken laid it. See? And this is the part. Tanner H, I am completely understanding that there are probably several jurors in that jury box that have this opinion. I'm not disputing that. There are several jurors who will look at the totality of the evidence and because of that might view the importance or significance of certain scientific or the physics a little bit differently. And that's why I approach this with, I am not that way. And I acknowledge I'm not that way. And when I analyze this, I try to give credit to all the different perspectives that could be out there. And this is one that a lot of people will vibe with, of the aggregate of the evidence, including witness statements, is enough to get them there. And that they would dismiss everything else the defense said. And I think there's people on the jury that are like that. And I'll get to that more in a second. Jen DeSimio, miss closing day. My daughter got married. That is a very good reason to get the miss closing. Like, daughter getting married. That should be the focus. Daughter married. Enjoy that time with family. Texas Katie did. Rescue Randy is Resusci Annie's baby daddy. Oh my God. That seems dirty. But for like CPR resuscitation class, like dirty. CPR class first aid. Yeah, that was okay. There was some mannequin dirty jokes there. Miranda Bowman. Okay, so why did the judge allow Jackson to do such violence?
Because it wasn't objected to.
It wasn't objected to. She could have jumped in. She didn't though. Hank Banana know how many super chats to get you to make a wooden sign that says Dumple of the Bailey for Runkle's Outhouse. None. There are no super chats required. Just
he's
reminders.
like, I will do that for nothing.
just reminders. That's all I need for that one. Just reminders. Just give me reminders that I owe that, and I'll make that happen. Lawyer's daughter when Brennan stole AJ's line. That one. Aussie J, holes in the back, jumper debacle equals bar complaint. No. CS Tears, I'm looking forward to a movie to reveal the FBI story. Who knows? Amanda Lang, already x-ray, no lower injuries, stipulation until Welcher. Wow. All right. So that was self-inflicted. Ooh. CHRM, Proctor finally emptied out his uniform pants pockets and found the x-rays. Nastar, one, Commonwealth has blank check and spends it on crappy contractors. Yeah, it does. Again, news. Wood Daddy needs to get back in the shop with apron on. Yes, I do. Baby steps. Thank you for gifting memberships. XCDA, love hearing your views on the closing arguments. My favorite part of the trials. Thank you, XCDA. Odin's Martyr. I took it as Rentschler read no x-rays in Welcher report. Says I got x-rays from FBI. I don't know. Barb Chitterly, were the x-rays in the same random folder that the other pics and video were that Proctor misplaced? I don't know. Again, news. I don't like when judges jump in without objections. It shows bias. Sometimes they have to. Very rarely, though. Icosaplex. If on jury, I still wonder how big of a cover-up to think wanted defense to commit, how it might only take few in the know, tribal loyalty, willful negligence, doing the rest. If on the jury, I'd still wonder how big of a cover-up to think. Yeah, you'd be kind of exploring that avenue of, if this is a cover-up, how they do it. How far does it go? The real Chloe Shoutout to Karen's defense team for seeing justice and doing something about it. Okay, now that we've done all of that, this is going to get complicated because I have to go through Hank Brennan's closing argument, which I have to have good notes on because he has some good points.
Mostly the one on the top of his head.
Is there a point on the top of his head? Is there a point on the top of his head? What? Where's the point? Top of his head.
You've never heard that before?
He looks like alfalfa. I just saw it from, no, he looks like alfalfa. Like if there was a cowlick back here with the way the hair is, if there was a cowlick back there, tell me he's not alfalfa. From Little Rascals.
No, we like alfalfa.
But tell me he doesn't look like alfalfa. When you square on, just tell me he doesn't. What was with the look?
John O'Keefe was 46 years old.
And this is where I pause. You just got called a liar. Like a liar. And you start with John O'Keefe with 46 years old.
Oh, I don't think he changed his plans at all.
"46 years old. He spent his life helping people. He's described as a good man, kind, generous, thoughtful. He was a Boston police officer. He worked to help the community. Everything you've heard about this man, he was a good man. He helped people. When his niece and nephew had nobody, he took them in. He took them in.
Do I have him sped up? No, he's on normal speed. Why does it seem awkward?
John O'Keefe seemed to be the type of person who would help anybody at any time. And on January 29th, 2022, John O'Keefe needed some help. He needed help from somebody else. You see, John O'Keefe had just been hit by Karen Reed in front of 34 Fairview Road, and he lay on the ground dying. And he needed help. Someone to reach out a hand, someone to knock on a door, someone to make a phone call to 911, even anonymously. Not take responsibility, just to help. And there was only one person in this entire planet who could help him that morning, to give him a chance.
Really? Really?
See, I've got a theory on this.
Only one person in the whole planet, who could have made that phone call. Just one. Only one. How many people were at the house at 12:30 in the morning?
So the thing is that I don't think that he's talking to you or me here. I don't think he's playing to win on this close. I think what he's doing is he's playing for a draw.
I know. He's going for his jurors.
Yes, and he's basically saying, I need you to be super, super, super emotional about this so that you don't listen to anybody who might, try to convince you out of this. You need to be like, that's what he's doing here.
Wait, he does a good job at it. And you and I have the same.
I said that in my stream. I was like, once you understand what it is he's doing, he does a very good job of it. But you're gonna hate it because you're not who he's talking to.
Yeah, you're not going to agree with it. And I think I messaged this to you. You and I actually probably simultaneously messaged this to each other, because I messaged something and you messaged it like right back, like about how he was speaking to the jurors that were gonna dig their heels in for him.
Maybe it was a 33% chance if he met the Isaac Wolf of the world. but to give him a chance. And that one person who could help him that morning was this defendant.
I also really, really hate fake emotion. I really hate fake emotion. And it is not hard.
He's got no other kind.
It's not hard to see fake emotion. Hank Brennan cannot emote properly here. This is the most uncomfortable attempt at sympathy emotion that I've ever seen. This is really uncomfortable. It's awkward. The tone, inflection, all of it's wrong. I made a joke about Alan Jackson when Alan Jackson was giving his closing argument. I was like, and that night he walked into a basement that was dark. The darkness of the sky paled in comparison. Alan Jackson got a little histrionic there, and I was teasing him for it. This is bullshit. This is not real emotion. This is not real.
Right here, Karen Reed. And she made a decision. In her Lexus with the shattered taillight, debris field all over the front yard, and John O'Keefe lying helpless like a child on the front yard. She made a choice.
Like a child.
She didn't call 911. She didn't run to his aid. She didn't knock on a door. She made a decision about herself. In her Lexus, she drove away. She was drunk. She hit him, and she left him to die. She was drunk. She hit him, and she left him to die.
Could have gone the third time. Honestly, those points, not bad. The bullshit at the beginning, not good. Those 3 points and then re-emphasizing them, better.
Before I go through and detail the evidence, let's talk a little bit about the evidence as a whole. She was drunk. She was drinking that night. She was drinking McCarthy's with John. She was drinking at the waterfall. Her blood was taken with samples of the retrograde analysis, almost 2 to 3 times the legal limit. She was drunk. She hit him. The timeline in this case is beyond dispute. You can accuse, assault, characterize, malign, twist. The timeline doesn't change. It is data. Data is data. The black box, the forensics from the SD card, we know exactly.
The timeline. Why did you have to focus on the timeline? Jackass. I'm sorry. I'm not sorry. 12/31, 12/36, 12/31, 12/36, 12/31, 12/36. How does that timeline work? Or under your theory, 12/32, 12/36, 12/32, 12/36. How does that timeline work? When you say the timeline is beyond dispute, this is why I think prosecution needs to go first, defense needs to bring up second. This is gaslighting.
Exactly step by step where they were. We know in that window, she hits him because he never moves again. His healthcare data, the temperature on the battery of the cell phone, the physical evidence, the debris field, the DNA, the hair. And then she left him to die. He had a basal skull fracture, counter coup. You heard all about it when the back of your head hits the ground and the brain comes forward.
Get it right, Hank. Coup, counter coup. Coup, counter coup.
Dr. Wolf told us the reason why they have level 1 trauma centers around the country is because people can survive this injury if they get help. That's why they have this care. That's why they have these hospitals. But you got to get help. You got to get help. And if you don't, you develop symptoms, ecchymosis, raccoon eyes, your brain swells, and you die.
How the fuck does he sell this? How do you sell this? Like the victim on the lawn that needs help. Even Dr. Wolf testified that this would have been immediately incapacitating. Scorty Bello said the person he'd be you don't call it dead on impact, but essentially it's dead on impact.
Yeah, it's if somehow like this happened to you in a hospital, you know, with the you're probably not getting saved.
So why is this his pitch? I've been trying to figure this part out. Why is he trying to pitch this? Is he trying to change the action? Is he trying to say that Karen didn't mean it?
He's basically trying to make it sound like she's, you know, cruel and whatever else. And I'm like, yeah.
I don't understand this part.
She was drunk. And that night was a recipe for this.
He's good. He keeps saying that she was drunk. He keeps on saying that she was drunk. That's good. He's good. That's smart.
Disaster. But before we get to the drinking, in some ways, the fate of this night was sealed well before that night because John O'Keefe and Karen Reed were in a toxic relationship. This relationship was crumbling. We hear lovey-dovey, and it was crumbling, and we know it. And we know it because a month before, his niece Kaylee talks about when they went to Aruba. It should have been a wonderful event. It was discord. It was fighting. It was aggravation. And when they got back, the discontent was palpable. Miss Reed reaches out to Brian Higgins, text messaging. John O'Keefe, the relationship is crumbling. And you heard a little bit about what that relationship was like. Kaylee, his niece, told you when there was an argument, John would do what John does. He would walk away. She described to you one time to get away from the scene, he walked into his bedroom, but the defendant wouldn't let it go, pounding on his door, having to get the last word, never letting go of the fight. Kind of mirrors what happens on January 29, 2022. And maybe outward appearance, they got along. Maybe sometimes quietly they got along. But behind closed doors, relationships have up and downs. We have a bird's eye view into the relationship on January 28, 2022, because we have the text messages, not so lovey-dovey. The relationship is almost over. The tensions are simmering beneath the surface.
Simmering?
They are not getting along.
Yeah.
She believes Mr. Keefe is already halfway out of the relationship and he's not into it anymore. You will read them, you saw them. This relationship was unstable and at its end. And so fast forward that night. That night, after this discord, after the arguing, they go out and what do? They drink. And they drink a lot.
She was drunk. This is his argument. His argument is drunk, car, present, no other explanation. That's what his argument is. But I will say he is far more effective at telling a story than Adam Lally was. Way more effective.
But so Zora.
No.
Yes. I mean, earlier today, I was eating a chunk of steak, and Zora was quite effective at telling me the story of how she wants a piece of the steak. Lally, on the other hand, would have meandered for ages.
No, Lolly would have asked, "Was the steak outside in the snow?"
And was there a high top?
Probably.
And then he would have told us the entire genealogy of every single person who's ever even thought of Canton.
You gotta admit, the dude, Brennan's courtroom presence is like 5 miles ahead of Adam Lally. Like he's pacing in front of the jury box. He's reciting and narrating and orating, and he's doing a good job. Now he's missing a lot of facts, and he's giving a lot of vague recitation. But let me tell you this: to some jurors, that plays.
I mean, yes, he's better than Lally, but this is such faint praise.
I understand that. I understand it.
So he drinks a lot, and Karen Reed drinks a lot. You've seen the McCarthy videos. You can call it 6, 7, 8, whatever you want to call it. You can see.
Is Hank drunk? Is Hank drunk? Is he drunk? I'm
I don't
tired of
think
the
so.
mispronunciations of everything.
I think he does it on purpose. Honestly.
Macaque videos. It's we all know. We know what these things are. We can you pronounce them properly for one time in your fucking life?
I mean, it might be some sort of speech defect, but I did read, somebody sent me a, something talking about him and basically noting that, like, they claim that part of his career success is that he drives people super nuts. And I'm just like, I could totally see that, in that I could see him doing this on purpose to drive people nuts around him so that they make mistakes. That said, wrong time. But I mean, I don't know. And I worry that I'd be dunking on him for like some sort of speech defect or, like whatever else. Or I mean, it is I don't think he's drunk, because if he's drunk, he's doing way better than expected. And I also don't want to say that he's drunk, because if he gets a conviction on something and he was drunk doing it, then that just feels like I'm dunking on the other side.
Yeah.
See the shots into the next drinks, more shots into mixed drinks. Count them yourself. Over a half dozen mixed
That
drinks
actually sounds like a
in
good
just
idea.
a few hours. Sober. And then at the waterfall, a shot, a mixed drink. Now, it was brought up the waterfall that there was some type of discord between Brian Higgins and John O'Keefe. They knew each other. They were friends. Brian Higgins' conduct of speaking to Karen Reed is not honorable. It's not. But they were friendly. There was no adversarial relationship. There was no anger between them. What we heard is they barely greeted each other. Could we have slide 1, please? At the waterfall bar, when you see John O'Keefe come in.
Somebody in the chat's
there's him
mad.
barely greeting. That's him.
Why? What did I do? I didn't mean to do
Barely
it.
greeting each other.
They didn't actually specify, so I assume
Reality
that they're probably just
sometimes
one of
is
the
different than argument.
other male
This is a
DNA sources
celebratory
that's
mood.
on the.
Celebratory mood. A bunch of friends.
Oh, distributed
They're
load.
playing around. They're hugging. They're grappling. This is a fighting technique for a murder 2 hours later. Is that the story? They're practicing.
Good argument, Hank. Good argument. I like that you focused on that. Very good. Now, if you
I don't know.
recite-
The problem is he's very blatantly misrepresenting the
That's-
argument.
if he could cite the facts properly, I'd be more appreciative of the argument, because the argument could be made if he cited it properly. If you play the facts as they are and you make the argument, I agree with it more.
I mean, this isn't the argument that that Jackson was making, and so it just ends up coming off like he can't address it, like he's. Yeah, I'm just like, no.
Saying their moves to murder John O'Keefe. In the celebratory mood, you don't see any aggravation or animus between Brian Higgins and John O'Keefe. Inevitably, the next morning, Karen Reed is brought to the hospital and they take her blood. Now, the government doesn't have to prove that she was drunk. It is either that she's over the legal limit, 0.08, or she had enough alcohol to affect her ability to operate a motor vehicle safely, but you will know that she was far beyond the legal limit. After the retrograde analysis, almost 2 to 3 times the legal limit. Almost 2 to 3 times the legal limit. Now, it's been intimated, not come out and said, that maybe she went home and started drinking after she got home. No evidence, mind you, no evidence. And that somehow that is why she had a high blood alcohol level.
That argument wasn't made, not in closing. It was made in the first trial. I don't think it was made here. But
It was
not in the closing argument.
not in the
Wasn't
closing, but it was pushed in questions.
Okay.
I don't have a problem with him addressing that. I just the issue is that he's got on this is that
He burden shifts.
yes.
And it's here. He burden shifts. Inappropriate.
It's not appropriate for me to comment on the credibility of another attorney's argument, so I won't.
Oh. Another thing about Hank Brennan. It would be inappropriate for me to comment on something. I wouldn't ever do something.
Then just don't do it.
Then 2 seconds later proceeds to do that thing.
Yeah.
That part.
Do that.
I hate it.
But Karen Reed will do that for her. So if we listen to slide 2, she'll tell you exactly what she thinks about that claim.
God, this is Karen Reed. I don't like you for this.
Oh, I don't like that she gave these statements.
Takes probably about 5 or 6 or 4. The drinks that they were pouring me at McCarthy's, which is where I consumed most of the alcohol, was the weakest at the time. It tasted just like old soda water with lime.
Okay. I hate everything about that clip. I hate everything about the clip. I hate the smile. I hate the smirk. I hate the downplaying. I hate the drinks. I hate the alcohol. I hate the driving. I hate everything about that clip. Nothing about that clip is good. And it just became prosecution ammunition.
Yep, 100%.
Everyone can say what they want to say. It's whatever. If I am this is where I got it became very, very clear to me that Hank is not talking to the whole jury. Hank's talking to 1 or 2 or 3. Because it became very, very, very clear from the very beginning. This was about character assassination. This was about finding people that are going to focus on alcohol, drinking, driving, operating, and that was what this is. He's looking for his holdouts.
Yep. And he's just telling them, hold the line.
Yeah.
Slide 3, please.
I wouldn't have gotten on the expressway. I wouldn't have gotten on the expressway at 12:15 on January 29th. I mean, it was quiet. The roads were very quiet. You can see on the videos. And I was going, when I've had a few drinks and I drive, I always drive extra slow. So I know my alerts aren't as sharp as they should be. But I shouldn't be driving.
Thank you. Do you think she drank when she got home?
Hank Brennan didn't have to make the argument. I mean, that's the problem. That's the problem. And if people can't realize that as to why those clips are a problem, y'all don't get to rationalize that away. You don't. Those clips are not good. They're not good. If I am, let me tell you, if I am defense counsel and I learn those clips and I see those come over in discovery, I am throwing my laptop against a wall and calling my client and screaming at them for the next 3 hours straight. And I am not the only attorney that would do that.
I mean, I could just say the number of files where I've had to deal with bad facts from my client is all of them.
It's not just the best evidence they have. It is the only thing.
Yeah, I mean, this
the-
is their entire case right now.
It's the anchor point. This is the anchor point that Hank Brennan keeps going back to. I talk about anchors of some lawyers anchor to a podium, some lawyers anchor to a theme, some lawyers anchor to things. This is Hank's anchor point, the clips.
When they leave the waterfall bar at 12:12, you see a video, you have it in evidence, there's a still photo of John O'Keefe holding a glass. Not from the Albert's home. He didn't sneak into the house in the cupboards and grab a glass. From the waterfall, you see him with a glass, and in it is a straw. Take a look at that picture. And now from 12:12 on, we virtually have a historian in the data that tells us exactly where he went, exactly step by step where he went. And how do we have that? Well, we know the defendant's car had like a black box, and Judd Welcher, Dr. Judd Welcher, took the data from the black box and downloaded it so you can see the movements and the triggering events. And then Shannon Burgess, well, you don't like what he says, don't attack the data, attack the man. He can be mocked for his LinkedIn profile or his unupdated CV. But what he did is he found a key critical piece of this case that did not exist before. He found it recently. And it was that SD card, the SD card that everybody missed, including the defense expert. Everybody missed it. So as much as you want to make fun of him, Shannon Welcher found the key so that we could have the time and date.
Did you catch that?
Yep.
Shannon Welcher found the key, the time, and the date. Shannon Welcher. You didn't.
It was
just,
hidden behind his degree.
It was Shannon Burgess and Judd Welcher just became one person, which was the argument the defense was trying to make the whole time. so Hank Brennan just goes, Shannon Welcher.
I missed the Shannon Welcher.
Did you miss that? Do I do replay it? I do replay it.
No, I mean, I hear what you're saying.
The SD card that everybody missed, including the defense expert. Everybody missed it. So as much as you want to make fun of him, Shannon Welcher found the key.
Did you hear it that time?
Mm-hmm.
We are one expert. We are one expert. Which was what the defense was trying to do the whole time, was to basically say, you can't take one without the other. And Hank Brennan comes back in and is like, Shannon Welcher. You mean Judd Welcher and Shannon Burgess? That was cool. One of them has a degree. The other one's still pursuing it. No shade, but still pursuing it. Oh, and I started a comment that it's no shade, movie trailer guy. Rob, I love you, bro, but you pause so much for commentary. Sorry. It's a commentary channel. I have to. Just let us hear it. There's the raw footage. I'm watching this the third time through. I get it. It's not for everybody. It's no criticism at all. It's just, it kind of is what it is. I'm going to pause when I can and talk about when I can. And aren't you glad I did? Because I caught the Shannon Welcher comment.
Mm-hmm.
Because Shannon Welcher.
So that we could have the time and date and location coordinated for an impenetrable timeline that can't be broken. That's what Shannon Burgess did. And so we know on the way from the waterfall to 34 Fairview, Ms. Reed is driving drunk.
Yes, knew it.
Mr. O'Keefe is in the passenger side of the car, and they're heading their way to 34 Fairview, and they get lost. And now we have more data because John O'Keefe has a cell phone. And I said it in the beginning, it is a historian. It doesn't suffer from bias, it doesn't suffer from prejudice, it doesn't suffer from memory loss. It
Well,
has
everything
data
else in your
on
case
it,
does.
and he puts on ways.
Go on. Go off, King. I want to hear you. Give me the rant because I want to do it too.
He's like, it doesn't suffer from bias. And then he's got like a list of biased witnesses. It doesn't suffer from prejudice. And he's got a list of prejudiced witnesses. And it doesn't suffer from memory loss. And like literally, Dever, his whole argument is that, you know, she has this false memory. And I'm like, my dude, come on, right? Like,
the data on the phone doesn't suffer from bias or memory loss. No, just the person who's pulling the data, just the person who's pulling the data and interpreting the data as to when they graduated college. Like it's
massive conjecture, confession through projection.
He's not going for us. He's going for one or two. The thing is, his science and data are the epitome of gaslighting. I've never seen someone refer to science and data as being non-scientific or data driven, but instead focusing on how my witness interprets the science and data, because those are two very different things. Very different.
High location data, as Ian Whiff would say, and it tells you second by second the speed, the location, the movement. That's what it does. And he has healthcare data on that phone. The healthcare data separately shows his movement, and that is critical. It is critical because it not only shows his movement, it shows when he does not move. That healthcare data is critical. And it's not subject to bias. It's not in dispute. There's no other contrary evidence. It is data. On the way to 34 Fairview, alcohol fuels tension. We know that. And we know from those text messages the tension in that relationship. And then there's a trigger. There is a trigger on the way because they're lost. And when John O'Keefe calls Jen McCabe for directions, Jen McCabe says something that triggers what's going to happen next. Could I have slide 4, please?
Very close to the Alberts. In fact, when Jen was navigating John to the Alberts when I was driving, she said it's near Ashley's house. Ashley and John had hooked up prior to John and I dating.
And so as they travel to 34 Fairview, under the duress of this crumbling relationship, fueled by intoxication, we have triggers. Now, we know on their way there, we know from the data, where they went, how they moved. If we look at slide 5, Ian Whiffen showed you a guide. You could enlarge that just a little, please. And it shows you with the healthcare data, it registers as flights climb, but it doesn't mean someone's climbing upstairs. What it means is there's an elevation, and he breaks down the data, the red, the green, if you can move down to this film.
Hey, Red Green is a great show.
Bottom left, that's 34 Fairview. You can see second by second the circles of their route, even the 3-point turn on Cedar Crest. That's what.
Best part of his case. It's the best part of his case right here. And it's a good part of his case. It is, you have to admit, it is the best part of his case. The cell phone. You have to discredit Ian Whiffen, don't you?
I don't have to admit anything.
You have to admit nothing. Right. This is my point. Here's the problem. This is conflating the burden.
I don't have to answer questions.
But this is conflating the burden of proof. And this is also why I'm kind of digging in on this. Hank is going for his holdouts, because doesn't this feel like poking holes? Like it feels like it's establishing alternative theories. This isn't laying a foundation. This isn't proving this happens. This is establishing alternative theories.
He comes up with new theories of the case in his clothes. It's actually ridiculous. I've never seen that happen before.
Neither have I, which is one of the funny things that I keep laughing at. Not laughing in a sad fashion of laughing, where you're looking at this and you're going, you do realize you are the prosecution, not the defense, correct?
I mean, somebody's going to let him know at some point.
At some point. But here's the problem. He's running his case like a defense lawyer, and based on just how the system works and how people are perceived walking into that courtroom and how the courtroom works, that can work. Hank Brennan is delivering the type of closing argument that has enough holes, gaps, and with the right amount of misunderstanding of what burdens are, easy enough to reach a guilty verdict. You can see it. Don't give me that passive look. You know you can see it happen. Bad person in bad chair. Why not, if not bad, why in bad person chair?
I mean, he's making bad arguments for a conviction, but they're potentially persuasive.
Yes.
I mean, he's arguing he's arguing all sorts of impermissible inferences.
Yep.
And he's doing it on purpose.
But that's the thing. Give the analysis properly. The analysis properly is, yeah, he's doing all these things. They're effective. It's bad. It shouldn't happen. This isn't how it's supposed to be. But he's doing it. Ain't right. I don't like it. But I'm not the one who calls balls and strikes in this courtroom.
You see, at that point, they've left the bar. Remember, the battery temperature was 82 degrees. They're now in a car. It's now 77 degrees. Think about how accurate the battery temperature is, that it reflects the difference between being in a bar and being in a car. They take a 3-point turn at Cedar Crest.
I mean, that's not super.
And because of Judd Welcher, we have the data.
I'm just
and
like,
it's a triggering
okay.
event. Remember, if there's an acceleration past 30%, it registers data on the car, and that's exactly what happens. Is a 3-point turn, and it all lines up with the cell.
God, I hope there are smart people on this jury. There's an acceleration past 30%. It registers. I go back to my original theory. Hank Brennan doesn't understand the science and therefore cannot articulate the science. So he goes with an overly dumbed down version of the science that actually ends up being wrong in several respects. The man has done more insult to math and science in this trial than the aggregate of all trials I have seen to date. And that includes the Gwyneth Paltrow reconstructionist who did the sliding down the ski hill and magically ended up between skis. He does not understand math, science, physics, or engineering. He does not. I am confident in that. And I would be very, very happy to have a discussion with him to prove that point. Very frustrating. Very frustrating. But he understands human emotion very well. And he plays on it quite a lot.
After you synchronize the times, it's that simple. It's nothing complicated. There's nothing tricky. There's nothing devious about it. It's data. They do the 3-point turn, and you can match the cell phone clock with the Lexus clock. And when you do, you can reconcile the difference. There's been a lot of talk, a lot of argument, a lot of fights. Shannon Burgess says 21 to 29 seconds. Mr. DeSorga comes in. Unfortunately, he wasn't able to actually do anything. He wasn't given the invitation to test the data. He just looked at the report and made criticisms like a Monday morning quarterback. But even he, looking at the data, says, well, it's 3 seconds off or 2 seconds. Same window, same time. We can have all the arguments we want. They're there. They're together.
Imagine the level of gaslighting. Just, I don't have to ask you to imagine the level of gaslighting. Just, my expert says 21 to 29 seconds. Their expert admits it's like between 3 and 5. It is what it is. We're kind of in the ballpark. We're kind of close. It's a murder trial. We all know that she hit him, right? Just, we're good. Okay. This is the same lawyer who stood up in opening statements and said, listen to the science and the data. How many times did he say science and data in the opening statement? Like, I'd do a bit over 100. I am aggrieved. I am insulted. I am gaslit. I am furious. Hank Brennan has destroyed the inner engineer child that I was once.
Together, the data matches up
Yes,
perfectly.
facts, science, and data.
Perfectly.
Facts, science, and data.
And so they make their way down.
And he thinks that, wait, hang on. He thinks this helps him right here.
It's off for 2 seconds. Same window, same time. We can have all the arguments we want. They're there. They're together. The data matches up perfectly. Perfectly. And so they make their way.
He just said 21 to 29 seconds is the same as 3 to 5 seconds. We all agree that this range of ambiguity is also acceptable, but they're there and the data matches up perfectly. Perfectly. He reemphasizes the perfectly. Are you out of your motherfucking mind? You just used those words in the same sentence. They are not the same. They are, in fact, different words.
Are you sure?
And concepts.
Because I'm pretty sure Brennan can hire an expert for $500,000 who will say that they are the same.
He might. I don't know. This morning you used the word perfect, and it was in fact 1.5 sentences away from the word ambiguous. Oh my gosh.
And look at this guy's painted arm.
Down to 34 Fairview Road.
This dude is covered with finger paint, therefore you must
They don't
convict.
stop. And John O'Keefe gets out of the car. They go to the flagpole, and we know for 2 reasons. One, the data. And secondly, Mr. Nagel and Ms. Mason at Cedar Crest, at that intersection before it goes down to the right, they meet. They let Karen Reed go first. They follow behind in the truck. Now, at this point, Mr. O'Keefe has about 8 more minutes before the beginning of the end of his life. And he's in that car.
How does that math work? 8 more minutes before the beginning of the end of his life, when you were just talking about how someone can reach out and save him. You little shit. You little. I really don't like this man right now. I really don't like him. I don't like him. I promised I was going to try and be neutral. And I've called out certain points that he made that were good. But this is horrible. This is 100%. Remember how the judge was like, hey, you might have seen photos that might have been disturbing. You cannot base your judgment on how those photos made you feel. This is how I feel with arguments like this. Like, you might hear things that are upsetting from the lawyers that are annoying, but you cannot base your decision. Now, Jackson does it too. It's just Jackson does it in a less condescending, whiny, woe is me phrase. Jackson says it with his whole chest. This is annoying.
He's in that car for most of it because Miss Mason and Mr. Nagel don't see anybody get out of the truck. Nobody crosses the lawn. Nobody goes to a garage. Not just because they didn't see it. And they didn't. Not because they didn't see it. Because the healthcare data on the phone shows that John O'Keefe is not moving. The car is stopped at the flagpole. The healthcare data stops. The battery stays at 77 degrees. The data is the data. You can't change it as much as you want to. It's data. And they sit at that flagpole.
You can't change it, but they changed it midway through.
Terry, data doesn't lie. And you will see
the data doesn't lie. The data doesn't
acceleration, 75%. You will see speed, 24 miles per hour backwards. You will see distance, over 80 feet. That's what you're going to see in this data on that night. Anger, although not necessary.
Is it an opening statement? Is this an opening statement? Because he kept on saying, you will see, you will see, you will see, you will see, you're going to see. No, sir, you should have proven, and you should be specific in what you have proven. This is my problem. You have not proven shit. And you have not argued that you've proven shit. You haven't done anything, Hank. You haven't done anything. You're a good storyteller.
I mean, he has proven shit. Exactly shit.
Yeah, that's fair. That's a fair assessment. And yeah, you know what, Kate R., my brain was in the same place. That's why I was actually going for the pause button. Trying to resist making jokes about an android. Yes, my brain went to Star Trek 2. I was thinking about Data. Like Data the android. I was thinking about Data. Like the data. Data said this. Data said this. Data said that. Data doesn't talk that much. Data talks when you ask Data a question. Like this was
in any of these charges, anger can be inferred for somebody to come back that hard, that fast, that reckless, that obvious, likely to create a plain and strong likelihood of death. That data tells a story that can't be changed, can't be attacked.
Really?
They did some crash tests on me. You know what else they do? Text stream data. There's nothing about that data that is uncertain. Nothing.
Oh, it's burden shifting, you fucker.
Take that down, please. When Miss Reed hits John O'Keefe, collides with John O'Keefe. We don't know if he went in the air a foot. We don't know if it was how much of a clip it was. We don't know if he stumbled back, but we know there's a collision. There's no doubt there's a collision because her taillight's all over the yard.
This is his best argument. And he does it in a fashion that is very effective. Very effective. Listen to how he phrases this, because there's a lot of people that will 1000% buy into this. 100%. Ready? No, I'm not skipping this part. This is good. If we're analyzing closing statements and closing arguments, and we're analyzing this objectively, right? We're doing this objectively analyzing this. And your goal is to persuade the jury, or at least the members of the jury who you think are going to go to the mat for your position. How do you do it if you're Hank Brennan? How?
Badly.
But But don't tell me this didn't put people firmly in one camp. Like if they were siding in that direction, they're there now. They're not moving. This is good, Ian. Come on. You know it's good. You don't like it. I don't like it. I think it's gaslighting. I think it's bullshit. I think it's not fair.
I don't think it's going to persuade anybody who isn't already on his side.
That's what I
the
mean.
thing.
But that's what we started with. We started our premise with this. We started our premise with the understanding that there were people that were embedded in one
and
camp
I've said
or the
it's
other.
a highly effective way of, of locking or trying to lock down to get a hung jury.
Yeah,
and that's fair.
Ms. Reed hits John O'Keefe, collides with John O'Keefe. We don't know if he went in the air a foot. We don't know if it was how much of a clip it was. We don't know if he stumbled back, but we know there's a collision. There's no doubt there's a collision because her taillight's all over the yard. It's all over the yard. And when he falls back and he hits the back.
Never mind any other explanation. Never mind any other explanation whatsoever. Don't disregard everything else you just heard. But drunk, taillight, yard, body. That's it. That gives us enough. The funny thing is there's a lot of jurors who will hear all of that and say, got it. Please explain why this is a good argument. Why is this a good argument? Because of what I just tried to explain. There are jurors who will have the impression and the feeling, the gut feeling they have embedded in them based on a view of everything, based on Kara Reed's statements, her demeanor, her actions during the trial, based on all of the above. And they will say that what the defense has provided as far as technical evidence is just to explain around a certainty that we all know exists because the person is bad. This is a bias that people have. It's an understanding that people have. If in bad person chair, why not bad? Because they are the accused, they are already behind the 8 ball. Not only that, but there are certain people who mistake beyond a reasonable doubt for, I mean, I guess it happened because there's no other explanation that I can think of, without really understanding what that is. It's not just that you can think of the explanation that's alternative. It's any reasonable alternative to every single element that has to be proven. Every single element. You have to prove to you how everything happened, what happened. Certain circumstances, you don't have to go that far, but in something like this, where there's a reasonable alternative, like it could have happened elsewhere or under different circumstances, you have to prove it. But some people don't understand that part. And when you have the attorney that's arguing it, conflating a lot of the burdens, it becomes more complicated. It's effective. It is effective because it ingrains in people. Someone was driving. They were driving drunk. The vehicle was there. The taillight was smashed. The body ended up on the lawn on or about or near where the vehicle might have been. And there's certain data points that are somewhat close, but within an error of margin. I don't need to care about the error of margin because I have the underlying facts. And oh, by the way, I have statements by the defendant, which do whatever rationalization you want, but I have statements by the defendant that says, I hit him, I hit him, I hit him. People have been convicted for far less and with far less evidence.
I mean, people have been convicted on the basis of one juror says he wouldn't look at the jury. The other juries or another juror says looks at us too much.
Yeah.
So like you can get convicted on anything.
It's a game of inches, folks.
Not that game of inches, a different game of inches.
Different, a less fun.
It was head, his basal fracture. He's then lying there helpless. When Miss Reed leaves, she leaves behind tons of her taillight. All over.
You know what's funny? I'm going to take this one up. Well, then maybe Higgins should hit him with a snowplow. Everyone there was drunk and driving. You know what's funny? If Higgins was in the bad person chair, I think he'd have the same possibility of conviction.
Yeah. Look at all the texts he sent.
Yeah. If Higgins was in the bad person chair with the lawyers next to him and putting on experts and testimony and all the above, I think he'd have the same outcome. I think you would. I really do. I don't disagree. Huh. The difference is the system.
Oh, yeah. Oh, yeah, it's called the debris field. And you've seen videos. You can't replicate the exact contact. You can't, because you need where the person was hit, how fast the person was going, but you know what happened, because when you look at the debris field, when a light is broken, it's no different than what was on the front yard. It's no different. She leaves him behind. She leaves her taillight behind. She goes home. And on her way home, you know she's still angry. You know she's still angry because she starts leaving him voicemails. Slide 7, please.
God, this is effective. It's effective.
Healthcare starts at 12/31/56. 12/32/04 to 12/32/12 is the data, which is adjusted.
He hasn't said shit about the injuries. Nothing about the injuries.
Oh, he
nothing
said a lot of
about
shit.
the lacerations. He has, but he hasn't said, he has not identified any of the problems. No injury, no nothing. It is.
Oh, I mean,
pure
he's going to steer
emotional
well clear
argument.
of addressing any of the weaknesses in his case.
I know this is pure emotional argument. At least Jackson came out and attacked some of the weaknesses of his case. He minimized them, but he didn't just ignore them. Jackson minimized the voicemails, right? He played them down. This is just plain and simple. I am going to ignore everything bad and focus on only these things, and I'm going to gaslight the hell out of you. This is horrible. But fuck, I would be stupid if I didn't say it's effective to people that listen to it. Some people have just shut him out. They're not going to listen to him at all. But there's one or two. It's not bad.
Adjusted when you reconcile the thoughts of Alexis. 12/32/09 is when Keith closes his phone after looking at Jen McCabe's text. 12/32/16 is his last steps. Mr. Disorder says that red range should move a little bit, 2 or 3 seconds. They can move it 4 seconds, 5 seconds. It doesn't matter. It's all in the same window. It doesn't change. We could have slide 10, please. Can you play that, please?
Is this John, I fucking hate you? Yeah. Oh no, this is the video.
Thank you. Each one of those pegs represents 10 feet. You can't place that car where it was in front of Fairview. You just can't. The data doesn't tell you that, but that tells you the movements of that car.
Yeah, because
Now,
the notion
John
that
Keith-
while drunk, she supposedly accelerated at 24 miles per hour backwards along a curve.
It's worse. You missed it. It's worse because in the argument that he brought out, she was still accelerating, right? It wasn't 24 miles an hour, and their theory is now that collision might have occurred after the TechStream data event registered. They needed that for the cell phone. So Hank Brennan was like, "It's still going up, isn't it?" So in theory, she went even higher than 24 miles an hour in reverse, beyond 87 feet. Well, at that point in time, you're colliding with a house.
Yep.
Square that circle. But this isn't about the science and the facts and the data. This is about emotion. If I have never been more gaslit Hank Brennan is the gaslighter in chief. The gaslighter in chief. The facts, the science, the data. The facts, the science, the data. You haven't given me shit. You've given me emotion with a desire to make certain things fit that emotional reaction. That's what you've given me. It's really annoying.
Sadly lays on the ground, abandoned. You're going to have to ask yourself a question for charge number 3, leaving scene knowing somebody was injured and then died. You're going to have to ask yourself, is there evidence that Miss Reed knew?
Is that it? Is he swinging for the lower? Is he going for the lesser included? Is that what the abandonment was and the person was going to live? Is he hoping for the compromise? Interesting.
That she had hit him. Don't need to prove it for murder 2. Don't need to prove it for OUI manslaughter. But for the 3rd charge, Commonwealth has to prove beyond reasonable doubt she knew she hit him. We weren't there, but there was an eyewitness. There was a guide. And that eyewitness tells us that she knew. And that eyewitness is Karen Reed herself. She tells you that she knew. We have slide 8, please.
Could I have hit him? Did I hit him?
How could that have been?
I don't know what that could have been. It was howling wind. I had YouTube acting on the stereo. And I thought, did he somehow try to flag me down, which was the reaction I was hoping to garner as I slowly pulled away from the house. Did he come up and maybe trip or bend over to pick up his cell phone and I ran over his foot and then he passed out drunk? I mean, I didn't think I hit him, but could I have clipped him?
This is all like suppositions and possibilities. So.
It was. It was. But that was one of the only clips. It wasn't like the 5-second one. That one was more like her postulating and her wondering of what she did or what she could have done or all the above. And is it burden shifting? It absolutely is. Is it effective? Oh yeah. Oh yeah. Hank Brennan hasn't done anything to this trial that's been magical or special. I don't know. If this comes back as a guilty verdict, I'm going to say the only person responsible is the interviewee. It's a righteous case as a defense counsel. It's a righteous case for a defense counsel to argue. The statements hurt more than anything in the world. More than anything. People are going to hate that. I love it. You're going to hate it. You can hate it all you want. Hate it all you want. Why didn't the defense object? Why didn't the defense object? They're her words. They can always be used against her, whether they're sworn or not.
Yep.
Always. Every single time. Whether
Big
taken out of
exception.
context or not. Every single time.
When she left Fairview and left John behind, she didn't think he was mortally wounded. But she knew she hit him. She knew she'd hit him. And so when she made her way back home, not only did she leave debris field all over the front lawn, but she took evidence with her too. Hair, DNA on the taillight, and she drove back to John's house. And she started calling on the way back, 12:33, just a minute and a half later. And then her messages show her anger. You see, this was John's fault. This was John's fault. And her phone calls tell you about the tone and the destruction of that relationship. 53 phone calls that night. 53 phone calls. Not one to 911. Not one to Jen McCabe. Please go outside.
Yeah,
and
you know
try to
what?
help.
If I think I've killed
Not one-
somebody by hitting them with a
Not-
car, I phone the fuck out of them. You know what? I got my phone right here. I'm gonna
No.
phone some dead people. You want to
I
talk
know.
to George Washington? I'm just gonna give him a ring
Don't-
right now.
You're not talking to me, buddy. That's the
How
thing.
about
You're not
Elvis?
talking to
Let's
me.
get Elvis on the line.
You're not
Like-
talking to me. You're not trying to convince me. I say this to opposing counsel all the time. You ain't trying to convince me. You're trying to convince a judge, or you're trying to convince a jury.
So
I'm not going to buy your bullshit. I'm not going to buy the bullshit. But is a judge? Is a jury? I don't know. I don't know. And this is an effective use of Karen Reed's own words. It's an effective use of her words. My God. He piggybacks a clip of her questioning. Yes, it's out of context. By the way, every bit of evidence that gets introduced or argued in closing argument is always out of context. No lawyer in closing argument is going to present the evidence most favorable to them in context that might disfavor that evidence. That's not how that works. When I watch these closing arguments, I'm sitting here watching Alan Jackson. I'm like, Alan Jackson like gave me a 8.8 unweighted, go to a 9.2 weighted, and then like a 9.5. You round up to 9.5. With Hank Brennan started at like I want to say like a 7.2. And then the more that I saw his tactic and strategy, I was like, all right, bro, you're at 7.8. And then the more he kept on leaning into the quotes, the text messages, or the phone calls, the repeated quotes and the audio clips, I'm going like, you're like an 8.4 on presentation and narrative. And he kept on going. And I'm going, you're going for the hung jury. And a hung jury for you is a win because you know that they're going to try this case a third time.
100% they will.
Felt gross, right? Felt really nasty to feel that he was shifting and he was going for the hung jury. I didn't like feeling that, but I immediately felt a shift. I was going, bro, you're going to hang the jury. You are trying for the 1 or 2. You're not going for the proving it to the middle. You're not going to try and persuade people who are on the fence about the data. You're going for the emotional holdouts. Wow. Okay. That's what we're doing. We're going for the emotional holdouts. All right. And then once I realized that was his tactic, I then reanalyzed his cross based on what the tactic was. Now he's at like an 8.8 for me. Because if you're trying to get 2 or 3 people on the jury that you think are emotional holdouts and you're trying to get them to stick their heels in the ground and hang a jury, this is what you do. This is what defense counsel does, by the way. This is what defense counsel does. This is really good defense work. No, this is good defense work.
Yes, you're right.
This is hanging a jury. This is damn good defense work. He's completely conflating the burdens. He's not trying to prove his case. He's trying to find a holdout. And holy shit, it's frustrating. We're just gonna have to see what happens. That's why I said the cross. I said people are gonna be mad at me. I said people are gonna be really, really mad at me. But the 8.8 is the 8.8. I give that grade because of how effective it would be to a holdout on that jury. I have tried to take my biases out of this and view this as, hypothetically, if there's someone on the jury that's really viewing this case at all towards in the camp of Karen Reed is guilty, how effective would this closing argument be to that person, to that one person? how much would that cause that one person, 2 people, 3 people to dig their heels in? And I said it's an 8.8 because holy shit, the points that he hits, the pressure points he hits, the positives he hits, it's not the facts, it's not the science, it's not the data, it is the emotional holdout points. They are the pieces of this that are intended to make the person dig their heels in.
That's exactly what he's doing. He's targeting those issues to get people who are already on board to really ratchet down. Also, I just shared on back end.
Is that baby moose or big moose?
That is not a moose, but it does show the outhouse.
Hang on.
It wouldn't let me share it here, so
Give me a second. Pull this down.
Why would they try a third time? Because they have unlimited money and
oh dear. Hey dear. It's not small in the outhouse. It's a healthy looking deer.
That's a healthy looking deer, and it's I'm actually okay with the idea that it's going to get used to the outhouse being there. Because there's an entire possibility that I might be able to
don't. I know where you're going with this. You know where you're going with this. The chat might not know where you're going with this. You may now finish the thought because I don't want to leave them in suspense.
There's entirely a possibility that I could hunt a deer by sitting on the outhouse.
Ian is contemplating taking a shit and shooting a deer.
Probably not actually taking a, but just
my thought process was walking out of the shitter and shooting the deer. But I also contemplated just swinging the door open and taking the shot from there. Which honestly, was kind of my thought. Honestly, feels kind of like this, like Hank Brennan, like just taking a shit and then like swinging the door open and taking the shot.
I mean, you're not wrong.
You know, we had a bear in my neck of the woods this week, like down the street from my office.
Did I tell you that I saw a bear?
You did, and you both almost took a shit in the woods. Yes, I loved it. It was one of my favorites. But I actually had to tell clients to like keep their eye out because there was a bear reported, and I had several clients going, "Wait, what?" And I was like, "No, yeah. When you leave the parking lot to come to our office, there's a bear that's been reported in the neighborhood." And they named the bear after one of the streets in Herndon. It was kind of cool. It was a big black bear too. It wasn't small. Like they took a picture of this thing. Let me see if I can find it. Brief distraction, folks. Sorry about that. Herndon black bear, because it was not small. Not small. Let's see, WTOP. Where are you, buddy? They named him Eldon, which I thought was cute. That's a small photo. I don't want a small photo. I want the big photo. Give me the big photo. Can I have the big photo, please? Yeah, give me the big photo. That's decent.
I just shared another one.
I'll pull that one up a second. Stop that screen. Present the screen. Share the screen. That's the mailbox. That's a mailbox. That's
a good size bear.
Who have seen black bears. Black bears are not generally like large, like big. That's a good sized bear. Like when someone said there's a bear in Herndon, like down the street from my office, I was like, it's funny. It's probably one of those scraggly little things. And then this photo popped up and I was like, that's actually a decent sized bear. It's like, that's pretty big. That's a mailbox. And this is a very residential area. So it's like, cool. It was big enough that Herndon Town Police was like, no, we're gonna call in Virginia Wildlife. They were like, we don't have the resources to trank this bear. which was the good call. It was the right move. Let's see. Then you got this one. Video file.
I'm just sending you stuff that's better than Brennan.
Oh, this is the mama moose and the baby moose.
Yep.
Is a baby moose. Mama moose is young mama. That's a cute moose. Well, it's better than Brennan. I will give it that. It's better than Brennan. I feel less gaslit by the moose and the bear. At least they like I felt like the size that they advertised was appropriate to what they delivered. I realized the intimation of what I said after I said it, and I take it back.
Yeah, and there's a couple of bears in that area, but the mama moose with the baby moose is what scares the crap out of me. Because
where's the data moose?
Oh, you don't need data moose. Mama moose could
Mama moose be just fine?
absolutely. Also, I'm pretty sure data moose. So data moose, I think, died.
Well, I mean, the big question is, Scaramouche, did you do the fandango?
Nice. The
kind of
what do you call it? I found the body of what I think is data moose, and I had to get a permit to keep it.
Oh my!
So
okay, let's get gaslit some more.
One to a hospital. Not one to anybody but him. 53 calls. Slide 12, please. You play voicemail one.
Mariko, natural causes.
The calls keep coming.
Yeah, that's the kind of message you leave for a dead person.
2 degrees. He's been outside now, not moving, on that cold, hard ground with his cell phone under him. The warmth of his body, the cold ground, 72 degrees. It tells you the story. As this temperature plummets and that cell phone battery is compromised, so is John O'Keefe. And him and his cell phone alone on that yard. 66 degrees at 12:45. It is plummeting. Ian Whiffen's taking a phone and putting it in a freezer, not a same analogy. The idea that means that John O'Keefe went in the house, absurd. 66 turns to 61, it's 12:53. 48 unanswered calls from the defendant. He's not in at a party. He's not wrestling with Brian Higgins. He's not in a fight. If he's in a fight, his cell phone would be moving. There'd be healthcare data. There'd be steps. If he got into the house in 20 seconds and his cell phone is found under his body the next day, and how would he get back outside? There would be more steps because his phone is working. The data is the data. There's nothing wrong with it. It's registering everything. The temperature, the movement. He doesn't go in any house. He can't go in any house.
Best argument.
His phone never moves again.
Best argument.
Voicemail number 3, please.
Lolly did it better though.
John, I'm dealing with a fucking kid. Nobody knows what the fuck you are, you fucking pervert.
Did you hear that? Nobody knows where you are. It is 12:59. John O'Keefe has been on that lawn for about 27 minutes. She hasn't called anybody else, hasn't spoken, has no information. Nobody's called her. You'll see her phone records. And she
doesn't help your case, Hank.
Says nobody knows where you are. She knows. She knows. Nobody does know where he is. Except her. Except her. Why is she asking nobody knows who you are? She is starting to get panicked. because she knows she hit him. Not suggesting she meant to kill him or for him to die, but she knows she hit him, and now he's not responding, and she's getting nervous, and she's getting anxious, and she's leaving call after call after call. He's not answering. He's not calling back. He's not even picking up the phone. And we know what's happening at this point. Panic, drunken denial, it's setting in. And so then we see the healthcare data from Miss Reed's phone. She doesn't move after a little after 1 o'clock. She could be sitting, she could have fallen asleep, but she doesn't move for a while. But she wakes up. She wakes up early the next morning. Take that down, please. And when she wakes up, she doesn't call Jen McCabe and say, "Where's John?" She doesn't call Brian Higgins, has his number, has been texting with him. "Hey, was John at a party with you? Did you see John tonight?" She knows exactly where she is, and she's frantic. So she wakes up Kaylee, that young girl at the time, and she says, she's panicked, she can't understand what she's saying. "Call Jen McCabe, call Jen McCabe." Why is she calling Jen McCabe? She calls Jen McCabe. You know what she doesn't say when she calls Jen McCabe? "When did he leave the house? What happened last night?" No. She calls and says, "I left him at the waterfall. I left him at the waterfall." See, now it's gone from panic to self-preservation. "I left him at the waterfall." And Jen says, "Left him at the waterfall? We saw you in front of the house."
This is effective. Hank is now hitting his, this is where he's hitting his rhythm. He's feeling comfortable. He's summarizing, but not really. He's arguing. He's using the best bits of the evidence out of context and arguing it the best way he can. This is closing argument.
Click. Hangs up. So then she calls someone that she doesn't know very well. She calls Carrie Roberts. But now she has to pivot because someone has seen her in the exact spot that John will be found soon. Whether she's the first one there or somebody else, John will be found.
He lost
lucky
here.
Missed him. It's a snowstorm. You can't see, but someone's going to find him at some point. So she calls Carrie Roberts. It's no longer she left him at the waterfall. She pivots. And she calls, "Carrie. John's dead. I think he got hit by a plow." Why do you think she chose those words? Why did she choose those words? Because she knew that there was a collision with a large motor vehicle, and she had to substitute her 6,000-pound Lexus for another big vehicle. "I think he got hit by a plow." And so now we have the introduction of Jen McCabe and Carrie Roberts. Phone calls that they probably never, ever wanted. A worse nightmare to get a call like that for what's going to happen, what they're going to see, what they'll never be able to forget. But because the defendant is John O'Keefe's girlfriend, they wake up in the middle of the night in a blizzard out of their kindness, their loyalty, their devotion to John O'Keefe. And when she calls them and tells them that she wants them to come out, this soccer mom with a perfectly normal life
Soccer mom, the normal
gets drawn into this whole farce, and she answers that call. She gets out of bed. The spirit and kindness she displays to put herself in that position because someone asked for help, because that's what good people do. Carrie Roberts didn't know Jen McCabe. They both knew John. They met each other once years before. Carrie Roberts, separately at that time, answers the call, gets out of bed, drives to go help because they have a common denominator, a common bond, John O'Keefe. And so you hear and see at 5:07, the defendant leaves Meadows. She leaves. And Kaylee is behind waiting. And you see her back up, and Judd Welch just showed you all of those demonstrations where you could see the unsettled snow in the back, and after the bump, you can see the pieces missing, no taillight. There's no taillight on the ground, all the white snow. There's no crack, there's no break. It's a nudge. It's a nudge. But the tail light has already been broken because when you look at the video, not one little piece, it's still framed, little angle with the light, the brakes are, you take a look, you'll be able to slow it down. You'll see the exact same piece is missing because it's back at Fairview. That's why it's missing. It's not there, it's back at Fairview. And then she leaves at 5:07. She gets to Jen McCabe's about, 5:35. 28 minutes. It's about a 10-minute ride. Where does she go in 28 minutes? Where does she go? We don't know. We don't have data for that. But we know when she gets to Jen McCabe's house, she is panicked, frantic, out of her mind, screaming, waking everybody up. Jen McCabe comes down, can't understand her, going out to the car to try to console her. Why is she so frantic? Why can't she speak? Why can't she say a word? Because John went out and had a drink and fell asleep on a couch? Because John would maybe be cheating on her? What is causing this extraordinary duress? Did she stop somewhere on the way by? Did she just see death?
She just
Kerry Roberts comes, take charge kind of person. She pulls him behind. She sees the broken taillight in Jen McCabe's driveway, and she decides she's going to commandeer this. We're going to the back to Meadows. You're going to follow me, leave the car, I'll drive. At this point, Jen and Kerry don't know each other. They've only met once. And they go back to Meadows. They obviously don't find John because he's back at 34 Fairview. And then they start their way towards 34 Fairview. They start driving towards 34 Fairview, and they're looking. And you heard from Kerry Roberts, Jen McCabe, they're looking out the window. They can't see a thing. The snow, the blizzard, the weather, the darkness, they can't see anything. And they're driving, and they decide they're going back to 34 Fairview. And this is remarkable. This is remarkable. When they start their way past towards 34 Fairview, they get close. And when they get close,
they're spotting him.
they can see nothing. But the defendant screams, "Stop, let me out." And they look around and they say, "What? Let me out, let me out." She does not see John O'Keefe. She knows where he is. She knows exactly where he is. She knows where to find him. She knows where to expect to find them because she knows where she left him. She tells us. Slide 13, please.
She tells us more.
Driving Jen's in the passenger seat. And
Side note, every clip that is like the 3 images in one, that is from the cutting room floor, right? Like that's the 3 clips of the same shot from 3 different cameras.
Makes sense.
I've described this to everyone, so you probably know this before, but John looked like a buffalo on the prairie. It was just a lawn and a heat that it wasn't a bush or a hydrant or a dog. It was a weird shaped lump at that time in those elements. And I was looking to find him on the side of the road.
Some people are going to hear that and call bullshit. Like some people are going to hear that and be like, this is the way she phrased it, the way she did it. And it's not like it's like in the immediate moment of trauma explaining something. This is several months later.
Well,
I hate these interviews. I hate
the argument they've got is that she clearly must have killed him because she describes him as like a buffalo on the
buffalo.
And I'm like, what?
The argument they're making is that she didn't have to look and recognize. She knew he was there. That's the argument they're making. And the thing is, they wouldn't be able to make that argument. Here's the thing. They can't make that argument if she doesn't give this statement. If she doesn't say this out loud, that argument is gone. I will very much I understand that you have to fund your defense. I get it 100%. I really, really, really do. I very much do. Oh baby, this would have been. I would have not been okay with. I would have fired my client. I would have fired my client.
I wouldn't. I do criminal defense.
That's
My
different.
clients talk all the time.
That's the difference. I don't handle this much. I get clients that say a lot of stupid shit. Usually people argue with their wife or with their husband. They're saying some really stupid stuff in not a very nice way. Maybe I wouldn't have fired my client, but I would have sat him down. It would have been a stab you in the leg with a fork conversation. It would have been. If you do another interview, I will stab you in the leg with a fork. Yeah. That's
Do you
what I
have
would
like a work fork?
I need one. I'm gonna find one.
Maybe I'll pick out a fork and make like a nice leather holder for it.
Keep it on my. I can keep it on my trial suit, my belt on my trial suit.
Yeah, you could just whip it out and be like, "Mate, wrong words."
Do you want it? Do you want the fork? 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 Stop talking. Do you want the fork? No. Okay.
It probably needs to be a wooden fork because that way it can go through the metal detectors.
Same. We're on the same page. Got it. Wooden fork.
I find him.
Thank you. A weird shaped lump in a blizzard, and you equate that to John O'Keefe. A weird shaped lump, not like a bush, and that is John O'Keefe. She tells us she knows where she left John O'Keefe. And so they go over to Mr. O'Keefe, Kerry, and Karen. And she's upset, there's no doubt. I am not for a second trying to deprive her of the unrest and the trauma that is happening at this scene. Doesn't change what happened before, but I appreciate the trauma. And they're trying to help him. And guess what happens when they first move him around 603, 604? Ian Whiffen, data. The cell phone battery gets the cool air, presses on the battery, the cell phone battery drops. Healthcare data, he has not moved since that 22nd, hasn't moved. They start shaking him. You're going to see when you look at the records that healthcare data starts to move. He's been there all night. Nobody else. Her. And so when they try to help him, she says something that is remarkable. She says, there's a piece of glass stuck in his nose. And she plucks it out. And she says when she plucks it out, blood spurts out.
Right.
We'll talk about that in a couple minutes. Remember that. Piece of glass, pulls it out, blood spurts out. That's what she says. As they try to help John, Jen is calling 911. They would like you to believe there's a conspiracy. That the glass that's found in Mr. O'Keefe's body is somehow from inside the Albert House.
All right, I'm going to fast forward to his ending remarks. I don't, it's not disparaging. I just need to get through this before I pass out. I've been streaming for 6 hours.
Full body injuries. Could I have slide 19, please? You bet they can.
Told you. At the very beginning of the stream, I told you folks at the beginning of the stream that the prosecution, there were people that saw this clip, and irrespective of everything else that this clip was intended to prove, irrespective of all of the above, everything else, people saw this that were Karen Reed is guilty, and people were like, totally confirms my suspicions. So the fact that Hank Brennan played this in the last few minutes of his closing argument goes to suggest that he's looking for those holdouts. Because if you saw this clip, for what it was, I don't know. Without the added context, which is how Hank Brennan argues his case without added context, then maybe you could see it that way. But how he takes his case to the close.
We don't know if this is the body position. We don't know if this is the exact speed, but what it tells us, this is viable. Look at the debris field. Look at his turn. Remember his.
Bro, if you are the prosecution and you are saying this is viable, Ian, have you ever been in a case where the prosecutor goes to the jury and says, you know what, jury? This is viable. Please convict this bad guy.
Viable is like so the wrong word.
Sneaker on that curb that got lodged against the sneaker.
But this is why I also go with the point of he's not trying to convince the whole jury. He's looking for holdouts.
Mr. O'Keefe then falls back, hits his head, counter coup, left to die. Thank you. Ladies and gentlemen, there is no doubt what happened that night. There is no doubt who did it. You have a very difficult task ahead of you when you consider the evidence and you consider the law. Very difficult. There are 3 charges. There is second-degree murder. Ms. Reed, when she chose to drive back at Mr. O'Keefe in that night with a 6,000-pound Lexus, in that anger, 75%, whether she meant to hit him or not, didn't mean to kill him, she hit him. Straight, it is a plain and strong likelihood of death. You would never get back down your driveway if your kids were at the end of the driveway. You would say, well, you're going to kill somebody? You would never do it because you would expect, if you drove at them at that speed, that someone would die. That's second-degree murder. OUI manslaughter, she's drunk, she was reckless.
What a shitty explanation of the law. Were you just tired? I imagine he was just tired.
She doesn't have to know she hit him. She doesn't even have to know she hit him. But she did. She did. And she left the man.
I'm sorry, Justice Jane. What? What? He Brennan thinks on his feet? No. Where? The last time Hank Brennan thought on his feet, he presented the backside of a sweatshirt that had holes in it that were cut by the criminologist. That was him thinking on his feet. Hank Brennan thinking on his feet is intentionally misleading the jury. I don't want him thinking on his feet. I'd like him to prepare his arguments appropriately. It's not how that works. Hank Brennan gave an 8.8 to the people that were like ingrained in his camp. But to everyone else that watched the full trial, that was a 2. Maybe. He didn't address any of the evidence. None. None. He gave broad 34,000 foot up in the air glancing views at the testimony. No recitations, no quotations, no remarks, none of it. It was a joke of a close. I gave him the 8.8 because I understood the legal strategy and how he delivered it. It was to persuade the 2 or 3 people that were in his camp. But from any objective observer who had watched this trial, this closing was dog shit. It was horrible. It was an inaccurate recitation of facts, if you can call anything that he recited as fact, but instead, rather than summation. Inaccurate summation at best. Impermissible argument. And his closing statement was, it shows that it's viable. No.
Viable is such a bizarre thing to be arguing here.
Viable. Within the last 2 minutes of his closing argument, he says the word viable. As in feasible. As in presuming that there are other methods of doing it because feasible suggests that it is
He's
less
like,
than likely.
What he's arguing is it's possible that she could have done this. And I'm like, You need to be arguing proof beyond a reasonable doubt, not possible.
Oh no, just Jay. I don't want to confuse you guys. I am praising the strategy. I think the strategy from a litigation standpoint, while I disagree with it, is remarkably effective and smart. It is smart, strategically thinking, given everything that we have seen in the case in chief by the prosecution and the defense, to, from Hank Brennan's standpoint and the prosecution's standpoint, find your holdouts and grab them. And I think this closing argument was remarkably effective to that end. Very effective to that end. Like I said, 8.8 on trying to keep your holdouts convinced. Did a great job. But if I'm grading the closing argument as a summation of the trial and how I would view it from the outside perspective looking in, 2.2. Horrible close. Horrible. Just the worst. Let's get to those last few seconds here.
Who was kind and generous and thoughtful. She left him alone. She left him alone to die. Could I have slide 22, please? He is not an it. John O'Keefe is not a body.
Is he not the guy, as he was referred to in the chat with Jen McCabe, purportedly one of his best friends? It's not the guy.
John O'Keefe is not a buffalo on a prairie. John O'Keefe was a person.
I'm just like, this is what he...
By Karen Reed.
Take it. Thank you. All right, jurors.
All right, jurors.
This is what he decides to end on as his big finish, is he's not a buffalo on a prairie. And I'm like, of all the quotes to go back to.
And with the feigned emotion too. I don't like when lawyers use the feigned emotion. Just present it normally. Hank Brennan, I made a comment a while back when he was presenting an argument, and when I believe he intentionally misrepresented something to the court, got caught in it, and then misrepresented it again. And I said, in that stream, I said, Hank, you're dead to me. I have had difficulties listening to Hank Brennan ever since then, but I have tried my analysis to be neutral in my interpretation of what he offers, what he argues, what he presents. And I did that today. And I stand by my analysis of, if he's going for holdouts, he did a good job. In toto, if I'm reviewing the argument as being an accurate recitation of the facts before the court and the facts in evidence, drawing all reasonable inferences therefrom, like I said, it's a 2. There wasn't anything specific. Nothing. It was garbage. But garbage in, garbage out, just like everything else. So I've got to swoop and go through super chats. I've been streaming for 6 hours. I've got 23 of these to read. Ian, you're free to stay. You're free to jump. Whatever you want to do. It's been a long day.
I'm looking at the your mods. I think will want you wrap up sooner rather than later. So maybe I'll jump, because otherwise I am not good at.
We get sidetracked. We get very sidetracked.
Sandy, you're welcome, and I will. I will see you guys soon. Good night.
Night, buddy. Thank you guys for being here. Just a few more minutes and we'll wrap up, get these super chats done, and then we'll be out of here. Thank you for sticking around. Thank you for showing so much grace to Ian, who has done great coverage and recaps. Please check out his channel, Runkle Bailey. Please go like all the streams, especially the recaps he has done. While you're doing that, before you jump over there, look at the bottom of the screen below you, hit the little like button, please, and hit subscribe if you wouldn't mind. There's 4,000 of you watching. Please do that. It would be great. Wonderful. It would mean a whole lot to me to do that. Please also engage in the comment section. Give me your impression for those of you on replay crew. What do you think of the closing arguments? Who do you think had the better argument? I want to know. Again, news. So Rob admits he is wood daddy, just denies it is wood stacks. Comment. Shay B, the invisible dunce cap has Rob stumped. You mean on Lolly? I saw the dunce cap. Josh H, honestly, I think the defense got the x-rays from ARCA. Dr. L said she got them weeks ago. ARCA's report was 7 weeks ago. Commonwealth hid them. How's not a Brady issue? We don't know enough facts behind that. We're speculating at this point. Ashley English video in your IG and X. I found it. Thank you. I got that. I saw that note come up and I pulled it and saved it. Again, news. He is giving proof of life. He's a good man. Is that allowed in closing? Yes, it is. You're allowed to argue the evidence and any reasonable inferences therefrom. Again, news. Was he drunk? Did they ever produce his BAC level? Not relevant for purposes of this crime. That's why they couldn't get into it. The squid. One, calling Apple Health data as health care is annoying. I agree. My phone can't diagnose a heart attack or broken bones. I also agree. Hank admits in his closing they didn't know how the accident happened, means he didn't prove his case. That's my impression too. Brianna Ruffino just got out of seeing the musical Parade. True story about the case of Leo Frank, basically Karen Reed of the 1910s in Georgia. Stabbing, LOL. Justice matters. Justice does matter. Bookish. Men kill women because they're humiliated by them. Is it unreasonable to think Higgins got into it with John for that reason and it got out of hand? I don't know. JB, yep, he is a huge fuck up, but he found stuff we liked and it helps our case. Lots of stuff. Lots of stuff. Odin's martyr. Should the defense have gotten into the key cycles? I think that would have been confusing. I think I liked where they did. They kept it short. They kept it concise. They focused on reasonable doubt and the impact. I thought that was the far better message. Give the jury one thing to hang their hats on. I liked it. Again, news. Healthcare data from watches and phones is inaccurate. I agree 100%. My watch and my wife's watch gave different distances for a walk we took together. That's interesting. Very good comparator. I also had the same issue with the phone data in the Murdoch case. I did too. The Murdoch case, the phone data bothered me a lot. Bubbles, Rob, what do you think of HB's demeanor with the Welcher on cross? All the objections. Rentschler on cross. Delivery. I didn't like the delivery. And towards the end of it, he started making the defense point rather than his own. Excuse me, we've been going for 6 hours. 6 hours and 8 minutes. AG, tell us the story of Brennan you've faced off against, i.e. a lawyer who wins primarily by pissing his opponent all the way off. I'll tell you what, my now partner, my now controlling boss, he and I had it out in court several times. He was very aggressive, and I don't play aggressive. And it threw him that I wouldn't play aggressive. I don't know. I liked that match. That matchup was one of my favorites. I'm glad I don't have to face him across the aisle anymore. But I liked that match. I thought that played well. And I have since developed and changed my strategy a bit with lawyers like that. And found a way to piss him off even more. I don't know if that's a very good story, but I'll try to think of one for next time. The squid. Hank believes in his experts' science and data so much he abandoned his rebuttal after his case got fisted harder. Oh my God. Well, Hank abandoned it so fast after his rebuttal case got a lot of inappropriate things done to it by people who are very capable of delivering those inappropriate things to people who are very capable of receiving those inappropriate things. I don't know if I want to PG that much too down. People can see it on the screen. The disgruntled moderate, rumors are the Alberts and McCabe's are swingers. Oh my, I didn't know that. If KR and John O'Keefe knew, could John O'Keefe get in to kind of give a credence to the pervert comments and voicemails? I don't know. We didn't get that in evidence, though. Is that an avenue that would be out of bounds character evidence? I don't know. From an evidentiary perspective, you could get into it, I guess, if you're trying to go for the motive. Katie Hewling, we had a book on outhouses as our bathroom book growing up. My favorite story was where the mom poured bacon grease down the hole and the daughter ended up peeing on a grizzly. Oh my. Okay. Alex Martin, at times, Brennan reminded me of Elaine's closing. All over the place, vague, ambiguous, not really reciting anything that was in evidence. Yeah. Kristen M96, I feel like there's gaslighting Paul Revere in Massachusetts joke somewhere in my head, but it's 3 a.m. Same. Honk Banana Note, reminder, Dumple of the Bailey. Will not forget that. Lola, the good dog, thank you both for all the late nights covering this trial. We heart you all guys and your pups. Woof. Chihuahua Trail Watcher. Chihuahua Trail Watcher. Got it. Thank you, Lola, for watching the trails. Odin's Martin, you missed Hank's Alan Jackson tribute from the trial one. I'm going to have to go back and watch it again. Tammy Lynn, I feel for the children involved in the case. My word, I apologize for that. The yawns are coming on because it's late. Tammy Lynn, I feel for the children involved in the case. They do not deserve any of it or to be the focus of the closings. I agree. Joshua, thanks again for the great FNF. Thank you very much, Joshua. Wonderful mods, all the mod squad, and have a wonderful weekend, everyone. That is going to wrap us up. Hey guys, thank the mods. Very much appreciate all of you guys being here. Extra hours, 6 hours and 11 minutes. Thank you for being here. Very much appreciated. Please, guys, go look at Ian, look at the channel, look at the videos, the live streams, all the above. I'm almost incoherent. It is 3:19 a.m. I am incoherent. Please go watch Ian's live streams, the recaps, all of the above. Please like the streams when you're there. Subscribe to the channel when you're there. My understanding is beginning on this live stream, he was at 295,000 subscribers. Please try to get him to 300. I would love to see that benchmark met. I'm at 201 or something like that. Give a subscribe. It'd be awesome. I would love to see that happen. To everyone else, have a lovely evening. Have a lovely weekend. Get out there. Go make something. You'll feel better. I really appreciate you guys being here. Thanks for the recap. We are going to be on jury watch. I'm sure we'll see something over the coming days, and we'll be here to talk about it. So cheers to all of you. Thank you. Good evening. Have a wonderful weekend, and I'll talk to you next time. Bye, guys.